person at page 54, item number 88, my lord. The matter was appearing as specially fixed, but now it has come urgent motion. My lord, there is urgency. I remember, your lordship, kindly remember that at least once or twice I mentioned that my client comes from Nagpur and he is staying here for the last 2 months. Before vacation, the matter was appearing. It has now come under urgent motion. I have given notice to the other side that I shall be mentioning before lordship for upgradation. And subject to lordship's convenience, any date in December, provided
number?
only on 6th, I have some problem.
Item number
Item number, my lord, 88.
of the commercial?
No, non-commercial, my lord.
Non-commercial.
No, my lord.
Who is for the other side?
My lord, Mr. Trivedi is appearing. Lordship will kindly remember. On the ground of Mr. Trivedi, my lord, matter was urgent from time to time, and I have always accommodated him. Any date, my lord, 7 except 6.
What is the GA2?
My lord, the GA2 is, my lord, the application for extension of time to file the written statement. They could not file the written statement. Master Sons was there. That was refused. So thereafter, they came before lordship.
So what is
It
the
will take
GA2
hardly
now?
5 minutes. GA, I do not know what GA they have filed.
So why you wanted to mention?
Mention for the reason that my suit is being still, I am not in a position to proceed with the suit. That is the problem. Unless
That's why I'm asking, what is the stage of the suit, sir?
stage of the suit, only filing and witness was examined once. In the meantime, he jumped in the fray and says that yes, we have filed an application for extension of the time to file the written statement. So lordship asked my witness to you come down, matter will be heard. My lord, it is matter of hardly 5 minutes. Either your lordship will accept or reject the written statement or put some cost upon them.
Who is for the other side?
Mr. Trivedi is repairing. I have given notice. I have given notice, my lord, and I have just now spoken to the learned advocate on record. Also, he says that he is on the way. He's come. He is on the way.
काम करो. Wednesday to be mentioned.
No notice.
My lord, may I be permitted to mention item number 93 of your lordship's non-commercial list?
Senior.
Please, your lordship, my lord, may I have your lordship's leave to mention item 119 of the non-commercial list.
119,
my lord, the first new chamber application.
Yes.
My lord, I was praying that if the matter can be taken up on Thursday, there is some personal difficulty next week, my lord. May it retain its position and may it come on Thursday.
What is the GA3?
Yes, my lord.
What is GA3?
My lord, GA3 is the amendment application.
So it will come on Wednesday.
My lord, I was having some personal difficulty from Monday to Wednesday. So I was praying if it can come on Thursday, my lord. Or any day suitable.
Okay, you do one thing. And if juniors are there?
Yes, my lord.
Let me mention when if the matter
as your lordship. As your lordship, please. I'm deeply obliged.
Lord, may I have Lord's kindly to mention the matter, my lord. Lord, your lordship will be pleased to pass an ex parte decree. My lord, we've taken out an application for recalling of the ex parte decree. Lordship was pleased to pass directions for affidavits. Thereafter, the matters not appeared. I'm mentioning upon notice, my lord.
Who is for the other side?
My lord, Sandersons and Morgans were appearing, my lord. We have put them on notice.
You filed an application recalling of the decree?
Yes, my lord.
Order 9, Rule 13.
Order 9, Rule 13. Initially, we had gone before the appellate court. The appellate court granted us liberty to come back and apply for your lordships. There are two applications. One is a Section 5 for continuation of delay, and the other one is under Order 9, Rule 13.
Pleadings completed.
My lord, by affidavits, there were directions they have not filed. They have, as in the affidavit in opposition has come in. Affidavit in reply, I couldn't file because, my lord, of the visa conditions at Bangladesh.
Tuesday to be mentioned. Inform the other side.
I will, my lord. Grateful.
Yes, next.
My lord, may I have your lordship's kind leave, my lord? This is a matter, my lord, Birla building, my lord, in respect of lease, my lord. Where lordship had refused the ad interim order. We went up in appeal, my lord. We did not succeed, my lord. Observed by my lord and also by the division bench that it should go before the testamentary court, my lord. We have instructions to withdraw, my lord. I have already filed before the testamentary court. I have already filed before the testamentary court. It is returnable, my lord, on Tuesday, I'm told. If, my lord, I know, my lord, this is non-commercial. If it can appear on Monday as to be mentioned for my withdrawal, my lord, I shall be grateful, my lord.
Which matter?
My lord, this is, my lord, the Birla building between
lease, my lord.
lease execution of lease, my lord. Initially vacation bench, my lord, passed an order. My lord's order has been affirmed.
So what do you want to withdraw the
I want to withdraw, my lord, the suit because I've already filed before the testamentary court.
Second bite to the cherry.
That, my lord, because your lordship observed and also division bench observed that it should go before the testamentary court.
Wednesday to be mentioned in Wednesday to be mentioned.
To be on Monday. I know, my lord, it's non-commercial.
Non-commercial.
Because we were hoping to move on Tuesday before the testamentary court, my lord. But we have filed already. We'll be serving my lord friend very soon.
Well, I'll pay for an opposition.
Come on Wednesday. Come on.
Very well, my lord. Grateful, my lord.
Yes.
May I please to mention item number 82 of the non-commercial list. This
Ah.
is the matter which was heard by your lordship. There was directions to file written notes. Our written notes are ready. Your lordship recall this is the dry fruits matter, but the respondent in the meantime has sought to file reply and then written notes will be filed.
Ah.
If your lordship takes it up on Wednesday because our written notes are ready, we are not filing because they are supposed to give a reply. This is that Sindaram Savarmal dry fruits matter where the Supreme Court
dry fruit.
directed that it should be heard out. I'm only bringing some indulgence on Wednesday if it can be taken up.
Yes, it will come on Wednesday.
It-
Adjourn motion will come.
it's actually a specially fixed, but
Correct. Now in the PLA it is 82. Wednesday adjourn motion will come first.
great.
My lord, may I be permitted to mention item number 93 of your lordship's non-commercial list?
92.
93, my lord.
93.
GA6 is appearing, lordship. It is my application praying for extension of time to file my written statement.
93.
93, lordship.
You for the dependent.
I'm for the defendant,
GA3.
lordship. GA3. I'd mentioned earlier GA6, lordship. Lordship had mentioned it earlier. Lordship directed to take out an application. I've taken out an application.
What is the delay? How many delay?
Lordship had initially extended the time till 1 week after vacation, lordship. However, the advocate on record.
3rd of October, your lordship had directed them to file the written statement within.
Okay, in the Wednesday, the matter will come up because the PLA will go down.
Lordship,
You
if it
see
may
on
be
that
taken
day.
up under to be mentioned, only my application, lordship, may be
Correct,
taken up.
correct. You see on Wednesday, the matter will come up. If it is not, then you mention and we'll see to
I
it.
shall mention at rising,
If it is
lordship.
not.
If it is not taken up. Deeply obliged, my lord.
May I have lordship related to mention a matter for inclusion in the list, my lord. This is a PLA matter, my lord. Initially, this is application was filed for probate, my lord, which has subsequently been converted into a letters of administration, my lord. For that purpose, it needs to be reaffirmed, my lord. But the petitioner is, my lord, hospitalized and is hospitalized in Mumbai, my lord. So I'm praying for a leave, my lord, so that the
By which order you have been granted reaffirmation, re-verification?
that
When?
order has been passed by the coordinate bench in the month of September, my lord.
Then
Thereafter, from that period only, he was hospitalized. He's suffering from
it is not
cancer.
listed.
No, my lord. So I'm praying for inclusion in the list, my lord.
Thursday to be made.
May I have my lordship's kind leave to mention two PLA matters for the purpose of inclusion in the list, my lordship.
Give. Testament.
May I have a lordship list to mention on PLA matter, my lord, inclusion in the list, my lord,
What is the stage?
for passing order for issuing citation. My one of the beneficiaries is
Testament.
living in.
Yes.
Lordship, may I be permitted to mention two designs appeal of 2017, your lordship, for inclusion in the list.
Design appeal.
Yes, sir.
2017. What is the stage? Hearing.
No, your lordship, the designs against which appeal have been preferred, it's expired. Your lordship, we want to get it dismissed on.
Huh?
We want to get it dismissed because the designs against which appeal has been preferred is had expired.
Okay.
So appeal has become infructuous.
So you want to withdraw?
Yes, your lordship.
Monday. Within make a withdraw. IP,
May I have your lordship's
IP number is given. Yes. Yes.
May I have your lordship's kind leave to mention item number 25 of your lordship's commercial division.
35.
25, lordship.
Ah.
I'm enjoying an interim order,
Ah.
which is to expire today.
Ah.
Lordship, this matter was mentioned and it is appearing at my behest, but it is appearing under the heading motion.
Ah.
But I had prayed for extension of interim.
Correct. Wait, it will be taken up. If it not taken up, 415 you mention before rising. I will see to that.
May it please, lordship. May I mention another matter? My lord, this is a PLA matter, my lord. I was only praying that may the matter appear as to be mentioned on Thursday. My lord, the copy of the will has been annexed to the petition. We were only praying for leave, my lord, so that the original, now we have got the original. On Thursday to be mentioned, deeply obliged.
For inclusion of the matter in the
Testamentary.
matter.
Testamentary.
Testamentary.
Sir.
Commercial list for item number 1.
GA1, the interim order is confirmed. Vacating application dismissed. Review allowed. The plaint is returned to the plaintiff with the direction to approve before the appropriate court in accordance with law.
Grateful, madam.
So this is appearing at my instance. Sorry. Yes, my lord. My lord, your lordship had directed the plaintiffs to serve a copy of the plaint. We have written to them on several occasions. They have not served. Lordship, kindly see the order of 18 November 24.
Your lordship,
Lordship, the last paragraph. It is only I do not understand this practice.
Yes,
your lordship, I'm praying for a short passover, but we've already served them a
that's
copy of the plaint
correct. But once
as per
they
the order of your lordship. My
When?
lord. We've served it on 27th November. I haven't been able to
27th,
November, your lordship.
Let me have a look. We have not received this. This is for certain.
where is the track report?
Your lordship, I haven't been able. I'm praying for a short passover. My senior will be right here.
Senior,
This is about a service of plaint. They could have carried it here and
bring this
shown.
up.
I have also.
And it is.
Your
Where is
lordship.
the difficulty?
Come it.
Your lordship.
That is all.
Your lordship, also, I'm praying for a short passover. We have some points to be brought before your lordship.
In this.
In this matter, your lordship.
Mentioned by the plaintiff,
Defendant, yes, my lord.
only for service of the notice. When the matter will come, you mention whatever what is the point?
Your lordship, in the they had. Your lordship, they had preferred an appeal, and in that appeal, your lordship, the division bench had been pleased to direct them to send us a copy of the financial statement so that we could have
You've done that.
we could have some proof of what their monthly withdrawal should
Okay,
be.
let them come on
However,
the
And it's returnable, my lord.
When is the date?
The
13th December. Your lordship.
13th of December.
Yeah, they come on
It's
that.
returnable. Pleadings are
Your,
complete.
your lordship, however, they have only given us a table of certified
Okay,
by their
that's
senior.
problem. No
Yes.
problem. 13th, if they have not complied with the appellate order brought to the notice of this court on 13th, the court will
We'll do
take
the needs.
Your lordship, kindly record my submissions, your lordship, in today's order. Please, your lordship.
Where is the appellate court order?
Yes, your lordship.
No, division bench order.
So suffering for the plaintiff, so suffering for the defendant. The matter is listed as to be mentioned on the prayer made by the counsel for the defendant. Counsel for the defendant submit that by an order dated 18th of November 2024, this court directed the plaintiff to serve the copy of the plaint along with the documents to the defendant within a week from date. But the plaintiff has not served the same according to the matter is mentioned. When the matter is taken up today, the counsel for the plaintiff has handed over a communication letter dated 27th of November 2024 along with the speed post receipt and submitted that in compliance of the order dated 18th November 2024, the plaintiff has sent the plaint along with the document to the defendant by speed post. Counsel for the defendant submitted they have not received the same till date. But learned counsel for the plaintiff in the open court serve the copy of the plaint along with the document to the learned counsel for the defendant and the defendant accept the same. Counsel for the defendant counsel for the plaintiff submit that by an order dated 3rd July 2024, the division bench of the appellate court had directed the defendant to furnish the annual report or accounts of the financial year 2023-2024. But the defendant has only furnished the
So,
there was a direction for furnishing statement. That has been done.
Kindly please what they have.
TC, have a look at this. Have a look at this. Come. Lordship sees the third paragraph
Yes,
on
yes,
page
I-
1.
what he has furnished.
Your lordship, they've only sent a table certified by their chartered accountant.
That is the
Only
direction.
furnished
No, it's financial
table.
statement.
No, I don't think so.
Only furnish the report issued by the chartered accountant wherein the table has been provided. Full stop. consider the submission made by the counsel for the respective parties. This court finds that the matter is already fixed on 13th of December 2024, and thus this court has not gone into the controversy raised by the plaintiff at this stage. Let the matter appear on 13th of December 2024.
Lord, your lordship has recorded that the division bench has directed filing of the annual report. Whereas, my lord, the direction is in case the annual report of the appellant has not been
Annual
prepared,
report or accounts of the financial year.
a statement certified by the director.
And directed to furnish annual report or accounts for the financial year 2023, 2024, 2024. And the statement of withdrawal tallying with the annual report. Withdrawal tallying with the annual report.
Great.
Take copy of.
Milord, we had incorporated the necessary amendments by striking out some of the prayers.
Yes.
Milord, we have deleted prayer C at page 14.
C and F.
C and the second limb of prayer F.
Yes.
I'm not praying for clause 12 leave as the defendant is within the jurisdiction of this honorable court, but I am only praying for dispensation under section 12 capital A of the Commercial Codes Act in view of my averment at paragraph 31 of the plaint, page 12.
Where is the Q? Notice dated
Yes, page 150, volume 2 of the plaint.
Page 1,
150. If Lordship sees at page 151, last paragraph after the schedule of properties that the bank has indicated, in view of the above, we request you to peacefully hand over physical possession of the above mentioned mortgage properties to bank for recovery of dues as per demand notice. Now, this demand notice is the notice dated 6th of December 2023. And my lord, in
There
this
is a 6th December
6th December notice, Lordship will find that at my lord, page 122, volume 2 of the plaint.
Sense appearing for the plaintiff. The plaintiff has filed the present suit for a decree of rupees 30 crore and further declaration and further and other decrees and other orders and allied prayers and allied prayers. Full stop. The plaintiff has prayed for leave under Section 12A of the Commercial Court Act on the ground that there is an urgency to file the instant suit without initiation of the pre-mediation process under Section 12 capital A of the Commercial Court Act. Counsel for the plaintiff submitted that initially on 6th of December 2023, the defendant bank had issued the notice to the defendant to the plaintiff for repayment of the loan in terms of the as per the terms and conditions. And now all of a sudden on 8th of October 2024, the bank has issued a notice to the defendant directing the defendant to hand over the peaceful possession of the mortgaged property to the bank for recovery of the dues as per the demand notice. Counsel for the plaintiff submit that the demand notice was issued on 6th of December 2023 on the ground that the defendant bank has declared the account of the plaintiff as NPA, and subsequently the defendant bank has also issued notice under the SURFACE Act, but the defendant bank has not initiated any proceeding under the SURFACE Act. Initiated any proceeding?
No, we have not received any notice under Section 14 as of
this. Only 13.2.
13.2 and 13.4.
Correct. Issued notice under Section 13.2 and 13.4 of the SURFACE Act, but the bank has not proceeded further under the SURFACE Act. But all of a sudden, the defendant bank has issued the notice directing the plaintiff for handing over the peaceful possession of the mortgage property. Counsel for the plaintiff submit that if a mediation process is initiated and the defendant bank will take the possession of the mortgage property, the plaintiff will suffer irreparable loss and injury, and as such the plaintiff has filed the present application praying for leave to grant praying for leave under Section 12 capital A of the Commercial Court Act. But the learned counsel for the plaintiff perused the materials on record. This court is satisfied that the plaintiff has prayed for urgent relief, and as such the plaintiff is entitled to get leave under Section 12 of the Commercial Court Act. Accordingly, leave under Section 12 of the Commercial 12 capital A of the Commercial Court. The plaintiff is admitted, subject to scrutiny by the department.
Great. But my application is affirmed. But I'll file it in the department since your lordship has granted me leave. But may I give your lordship the number and may it appear on Monday?
File it, mention, I will see.
Yes, grateful.
My lord, I am for the plaintiff petition. My lord, this is that matter, my lord, where my learned friend was to take.
I can't hear you.
My lord, this is that matter where my learned friend was to take instructions regarding the, my lord, admitted sums.
Yes.
My lord, there were acknowledgements there. My lord, my learned friend had
Yes.
submitted that payments had.
Well, so far total payment is concerned, my lord, is sum of rupees 51,000.
51,000.
Admittedly, it was paid.
Hmm.
And my lord, my clients, my lord, the instruction is that amount has not been adjusted.
Huh?
Amount has not yet been adjusted.
Ah.
My lord, my submission is twofold. First, that amount is required to be adjusted, which was paid in the year in July 2022. And my lord, secondly, the interest part. They have claimed exorbitant.
What is the total claim of the plaintiff?
My lord, their claim is 90
Where is the
lakhs.
claim? Where is the plaint?
My lord, my prayers are at page 111 of my application.
111,
my lord.
111.
25,000,
29.
25 lakhs.
Principal amount is 19 lakh 6,000.
My lord.
Yes.
Correct. And the interest is 6 lakh 92,000.
Yes.
So total 25 lakhs.
My lord.
Yes. What is your submission on
My
that?
lord, my submission is 51,000 payment was not taken into consideration.
51,000.
My lord.
Okay.
And my lord, second, they are claiming interest at the rate of 18%, which
Correct.
is exorbitant.
Correct.
Well, on the last occasion, I submitted your lordship.
So as per your submission, the 90 out of 19 lakhs, 15,000, 51,000 is to be deleted. So what will the remain?
Remain, and my lord, then my lord, in that 18 lakh something.
18 lakh.
18 lakhs 50,000.
18 lakh 15,000.
And my lord, so far the interest part is concerned, my humble submission on the last occasion I submitted. My land friend, submitted you, I leave it to your lordship. My submission is kindly make it 6%, which is
Where is our 51 lakh receipt? Where is the bank transaction?
My lord, yes, we have stated in paragraph 9.
Paragraph 9 of
my opposition.
Opposition?
Yes. My lord, page 8.
Page 8.
My lord.
Yes. Already paid 51 lakh, 8,900.
Yes, yes.
51,000.
Yes. Totaling 1 lakh 14,000. But out of that, 2 transactions, 2 amount which are paid to them, subsequently they refunded that amount. For the reasons best known to them. Only the first payment, you also say 51,896. That was accepted by them.
Yes.
Yes. My lord kindly takes page 44 of the affidavit in opposition. My lord, this sum has been, my lord, accounted for. And after taking this sum into account, a sum of rupees. My lord, page 44. This is a ledger, my lord, that they have annexed to the affidavit in opposition. Your lordship will see on 21st June 2022, my lord, a sum of rupees 51,896 has been taken into consideration. And thereafter, my lord, what is due is a sum of rupees 19 lakh 5,721. This is their document, my lord, disclosed by them.
Well, I think I have taken instruction from my client, but so far the ledger account is concerned. Well, it is true. But that amount, by mistake, that has not been.
Page 67 of this petition.
Well, they have accepted that money. They can't deny.
My lord, we have accepted. But after taking that into account, my lord, the sum due is 19 lakh. If your lordship kindly takes page 67 of my application, this is an email issued by the defendant. My lord, the payment was made on 21st June 2022. Page 67, Annexure H to my application is an email issued on 26th April 2023.
Yes.
My lord, therein they admit that as on 31st March 2023, our outstanding balance is 19 lakh 5,720. My lord, which matches with the ledger amounts mentioned in the ledger.
That's true. I do admit, my lord, there is some sort of mistake on the part of my client.
Everything is
that
mistake.
amount was not.
Then I will take the matter on merit. Then your client will be in trouble. I will take the matter. If you're not ready, I will take the matter, but be ready. Because if the matter will be taken on merit, the court will go by the record. That's why I given time to consult with your client. If your client is ready to pay, then you come with. If your client is very smart, telling that in spite of the admission in the court on affidavit, then the court will decide on merit.
The balance amount is concerned, my lord, I do admit, my lord. My client is liable to pay.
Yeah.
No dispute about that.
So,
but so far that amount is concerned.
That's why I'm telling you, I accept with regard to the 51,000. But 51,000, you are telling that the 51,000 which you are showing.
Whatever, that's true.
From in the ledger account that year 2023, you are showing the other things. In this communication, you are showing 19 lakh 5,720 is due.
My humble session, by mistake, that has been reflected, my lord, by mistake.
But in the affidavit,
my
you
lord,
I
do admit.
So what do you want? Take the matter on merit?
Well, may I submit one thing, madam? Only your lordship kindly direct my landlord to recalculate the amount after deducting the rate of interest. And my
Rate of interest, how much you are ready to give?
6%.
6%. Okay. So
Well, nowadays my savings account 4%, banking interest. I am ready to pay at the 6%. Well, calculate that amount.
My lord, as regards the interest part, my lord,
commercial matter.
commercial matter,
That's true.
and my lord, this is an
Yes.
agreed rate which is there in the invoice. My lord, I have issued a demand letter claiming interest. They have not denied.
Yes.
Well, recalculate the amount and
What recalculate? They are telling 19 lakhs. They are telling. If I want, I will. You wanted to recalculate, I will give the time. No problem.
My lord, in a similar matter, my lord, where there was a, my lord, agreed rate of interest, your lordship has granted 18%.
Correct. But
Yes.
the matter is settling between the parties, then that is different
my whole
aspect.
my whole difficulty is my client's business transaction has been totally stopped since COVID-19. Now right now, the business, there is no existence of in business. And there is no scope on the part of my client to pay the amount.
Okay,
He's
19 lakh you are ready to pay, 19 lakh 5,720. And I am awarding the interest of 12%.
Well, kindly make it 8%. Kindly make it.
Okay,
Well,
10%.
considering the financial, kindly.
Okay, 10%.
18%.
Settlement.
And when so far the total amount is concerned, my submission with your lordship, my client is here. But right now he is not in a position to pay. Your lordship, by installment, kindly direct us to pay.
Then the interest will increase.
Yes.
Installment,
Yes.
installment.
No,
I will pass an order installment. 19 lakh installment with three installment, 2 installment.
Well, kindly within a period of 1 year.
No.
That's 1 year.
Entire amount will be liquidated. Entire amount will be liquidated.
And that's 1 year. Then 20% interest.
Well, you also can't consider the present financial present financial condition of my client is totally paralyzed. Hand to mouth condition. I'm frankly submitting with your lordship. Is present in court. Hand to mouth condition. In case of your lord pass the order or attachment, all these things, he will be surrender. Nothing. No means to pay at all. Yes, virtually surrendered with your lordship.
In that case, I am giving 6 months time, 15% interest.
Very well.
10%, 1 year. 1 year. Kindly.
19 lakh 1 year.
My client not in a position to pay. Your lordship, kindly consider the predicament. Kindly. There is no business transaction, nothing of the sort. Totally closed down. And my lord, there will be kindly consider within 1 year, 10% within 1 year. I leave it.
1 year it not.
My lord.
Sorry.
My lord, I am not bargaining. I am not bargaining.
19 lakh.
My lord, kindly consider my client's
1 lakh per month.
From 2022, my lord.
My lord,
Lakh per month.
my lord, kindly consider my client's plight. My totally hand to mouth condition. Totally. Just surrendered yesterday. Kindly consider.
Yes, what? Tell me. Otherwise, if you give consent, then I have to go by the marriage.
I'm giving.
But 1 year court will not accept. 19 lakh 1 year it is not.
Or there were 10 installment. 10 installment. 10 installment.
10 installment, 6 months.
10 installment.
10 installment, 6
10 months. 10 months. 10 months. 10 months. 10 months.
15% is it?
No.
Sense appearing for the plaintiff, sense appearing for the defendant. Full stop. The plaintiff has filed the present suit, praying for decree for an amount of rupees 25 lakhs 99,704. Paying for an amount of rupees 19 lakh 06,916 being the principal amount and interest at the rate of 18% per annum till the realization of the said amount. The plaintiff has also filed an application being GA-COM 1 of 2024, praying for judgment upon admission. Full stop. Okay. Full stop. The defendant entered appearance and filed affidavit in opposition in connection with GA-COM 1 of 2020. Before taking hearing of the application, comma, the learned counsel for the defendant submit that the defendant is ready to pay the amount, but he submitted that the plaintiff has claimed the principal amount of rupees 19,05720 in 19 lakhs 19,05720.94, but 19,05,720.94. But the plaintiff has not considered the amount of rupees 51,896, which the defendant has already paid to the plaintiff, and the plaintiff has received the said amount. Counsel for the plaintiff's defendant submit that the amount is required to be deducted, and and further submit that the plaintiff has claimed the interest of rupees 18% per annum, comma, the defendant is not in a position to pay the interest part also to be reduced. Counsel for the plaintiff and the defendant have negotiated. The defendant has negotiated with the plaintiff, and now the plaintiff is ready to pay the amount, the principal amount of rupees 19,05,720.94 within 10 installment from date at the rate of 10%, at the rate of interest at the rate of 10% per annum. Full stop. The counsel for the plaintiff has accepted the proposal of the defendant. Accordingly, GA-Com 1 of 2024 is disposed of by directing the defendant to pay rupees 19,05720.94 to the plaintiff within how much one installment, how much it will come? Calculate.
Without the interest or with the interest?
Interest I will come. This one. Within 10 installment at the rate of rupees
05721
1,19,527.
572.
Yes, ma'am. For the principals.
The rate of rupees 1,90,572
90,572
rupees per installment,
90.
as well as the interest accrued therein. Full stop. At the rate of 10%. First installment shall be paid by the defendant to the plaintiff on or before, we are on 28, 29, on or before 24th of December 2024, and thereafter the defendant shall continue to pay the amount along with the interest up till December 1st, January 2nd, February 3rd, first without interest. How much September? It will complete it?
December, September, my lord.
Full stop.
10 months, September, December only.
My lord, September.
And the plaintiff defendant is directed to complete the entire payment along with the interest by 27th of September 2025.
But perhaps not that time, Lord, the court will be on vacation for puja vacation.
It is not come with.
Maybe 2 days before.
My lord, either before or after I will pay.
When puja vacation start? You have a calendar, new calendar.
My lord, in that event, either prior to closing of the court or after.
My lord, the
29.
starts from 29th. my lord, the
28.
vacation.
28 September 20 and 27 September 2025. Full stop. GA-Com 1 of 2024 along with CS so is disposed of, decree be drawn accordingly.
My lord, will kindly indicate in case of failure, my lord, or default, we shall be
made clear. It is made clear that in case the defendant failed to pay the any of the installment or interest thereon, comma, the plaintiff shall be liable to pay interest at the rate of 18% per annum.
My lord, defendant.
Defendant shall be liable.
My lord, yes.
Perhaps not subject to correction. Perhaps it has also gone down as plaintiff.
I've been
in the
saying
first paragraph. Grateful, Lord, extreme great.
Especially things matter. Item number 10.
My lord, from Ashika's side,
The Shah is online, my lord.
Yes.
I think for Mr. Banerjee, my lord, he is in some personal difficulty.
I'm told he's unwell, so my lord, on that ground, my lord, I don't think we can really say anything. My lord, otherwise we were ready to address, but my lord, if it's with your lordship's pledge, it can be on Monday, my lord.
Just one inquiry, my lord, with your lordship's leave. My lord, in view of the affidavit that Ashika has filed, lordship will kindly inquire as to who has filed the Wakalatnama.
There's no
on behalf
affidavit.
of the respondent.
Ashika has submitted a statement in writing. I don't think they've used
Not Ashika. I'm talking about the respondents. My lord, Ashika says that the respondents have not been appointed as trustees. So, my lord, I'm wondering who has filed the affidavit on behalf of my
Firstly, my lord, it does not lie in Ashika's mouth to comment on how I've
Who
affirmed.
is appearing for the defendant?
I appear for the respondents.
Yes.
Has he filed Wakalatnama?
Who has signed the Wakalatnama?
Lord, I'll just check for my advocate and records. Wakalatnama.
Who has signed?
Mr. Siddhant Chaudhary has authorized. He's one of the trustees. Authorization.
We'll have to want to have a look because the point of Ashika is, my lord, they are all people
point of-
self-appointed.
Lord, I'm being led by Mr. Rai. Lord, point
Not filed as yet.
point of Ashika is raised an issue which we can deal with here and now. Immediately. Here and
Who has filed the Wakalatnama?
Affidavit of valuation.
Arre, what? Advocate.
No.
No, who party? Who signed?
Siddhant,
Because
trustee.
there are four defendants.
Respondent number 3.
he's one of the
Trustee.
trustees.
One of the trustee.
Yes.
This is a resolution of the board, I believe, my lord, of the trust, my lord.
Have you included resolution? He has been given authorization.
Yes, certified copy.
Well, this is a
Point.
absolutely pointless objection taken by Ashika. My lord.
That's why this is required.
I'm not saying that.
Mr. Shah
It's an
raised.
internal decision of the trust. I don't know how a third party can say all these things. But I will refer to the trustee also, my lord, to show.
It's because of you that this has come up. You're saying invalid null.
Okay. Yeah. Mr. Shah, Monday you will be available.
Monday, I'm available, my lord.
Monday.
Monday he is
Monday.
Online করতে পারবে না? Online করে নেবে।
একটু online করে নিতে পারেন।
Come on Monday.
Monday.
That's it.
দাশগুপ্তা is
As per the request made by the counsel for the Ashika stock. What is the name?
stock broking limited, my lord.
Stock broking limited. Case adjourned. Let the matter appear on 3rd of 2nd December 2025 or
Grateful.
2024 under the heading specially fixed matter.
Grateful.
Give this. You file it in the department.
But I'll file it.
Yes, next.
The both matters.
Both matters.
This is my contempt application, your lordship. On last occasion, your lordship has directed contemners 5, 6, 7, and 8 to appear in person.
Yes, Lordship, they are present.
Yes.
Lordship, I tender my unconditional apology so far my clients are concerned. There was a direction for 5, 6, 7, 8 to be personally present in court, Lordship. All of them are present.
Yes, they know the address of the other defendant.
Lordship, may I submit one thing? My clients have given me a document which shows the property stands in the name of other property standing in the name of J. Ram, Lordship, the main contemner. May I hand over? I'm told the property worth rupees 36 crores. May I hand over that property, Lordship? I'm giving a copy to my learned friend also, Lordship.
So we will have to come back and well, as if that ওখানে সত্যি কথা বলছিল হ্যাঁ but সেটা
which was injuncted
হ্যাঁ
was arbitrary purchase by
হ্যাঁ
pursuant to the original. He brought the 5
G. Ganapati. In whose name? Flat G. Ganapati.
Lordship,
One.
it was purchased from Parthasarathi Naidu, Shudalagunta, Tirupati. It stand in the name of Shudalagunta.
and
Parthasarathi Naidu and Sudalagunta.
Yes, Lordship.
and this transfer is in violation of the injunction order.
No, no,
That's why
Lordship. This I am giving the details of the property. If your Lordship would see, I am holding the original. We have applied for the certified copy. We have got, Lordship, April 20. This is the original. I can put it in.
This is possibly a different entity, Sudalagunta
different
Hotel
property.
Limited.
Sudalagunta.
Hotel Limited. Kindly seize, Malad.
Lordship, my junior has traveled
Possibly,
from
my lord,
Chennai to
subject to
assist his
correction.
court, Lordship,
Tirupati.
regarding this.
Yes, so it's possibly a different entity.
Parthasarathi Naidu is there? No.
No.
Parthasarathi Naidu is not there.
Lordship would take page 5. His name is written Jairam Chaudhary, page 5. My learned junior has come from Chennai to assist this court, Lordship. He can read out.
Page
Page
5.
5, Lordship. Pado, just read out.
Yes.
5th, 6th, 7th line.
6th line from the
So,
top, Your Lordship. Mr. Sudalagunta Hotels Private Limited, represented by its MD, Mr. S. Jairam Chaudhary, which is the main contempt note.
read, Sana.
Jairam Chaudhary's party, yeah.
Yes, Lordship, he is the main contender. Jairam Chaudhary is the main contender, number 1.
Jairam Chaudhary. Mr. Gupta. Jairam Chaudhary is not a party here.
Jairam Chaudhary, Lordship, is contender number 1.
No.
Is contender number
No.
Jairam Chaudhary, 4. 4. Lordship would kindly see 4. Contender number 4.
Sudalagunta Jairam Chaudhary.
Where is it? Sudalagunta Jairam Chaudhary.
He's the managing director of all the companies, Lordship.
Sudalagunta Hotels Private Limited. MT of Jairam Chaudhary.
Want to read this?
Yes. So where now they are residing? 1 to 4?
এইটা অন্য একটা কোনো yes other company Sudalagunta Hotel. I'm sorry, Manoj. But if your lordship kindly takes a look at my lord's order of 17th of November 2023 once. আচ্ছা চলুন আছে and may I hand up it kindly
17th November.
17th November, my lord. And where they first appeared in the contempt.
Yes.
But kindly seize the third page, the third paragraph. Though the warrant, has your lordship got it?
Yes, yes.
Though the warrant could not be executed against contemnant number 8, but he has appeared before this court in person and has filed an affidavit stating that he has purchased the landed property measuring such and such in survey number such and such within police station such and such from S. Jairam Chaudhary, the contemnant number 4, being represented by his constituted attorney, namely Red Hills Rice Mill Owners Association, through his president D. Gopi, contemnant number 5 here. He stated that at the time of purchase, neither the vendor nor the constituted attorney informed him about the order passed by this court. He undertakes that he will abide by all orders and directions. So, my lord, this person has transferred in violation of the court order. But the knowledge.
When it was transferred?
My lord, the transfer is in 22. I'll give your lordship the exact date.
No, he has given an undertaking before this court on 17/11.
My lord, this is a subsequent fact. My lord, the injunction order.
That is different thing.
So transfer is post the injunction. Yes.
That's why the contempt is going on. Now this property is with the defendant number 8.
Yes.
Who is the defendant number 8?
The purchasers, they are.
So where is the property? He has sold or the property is still there?
Lordship, it is my specific case that the property was attached under Revenue Recovery Act.
When?
Lordship would see I have handed over the bundle on the last occasion. May I hand over again? Lordship, I have handed over
Yes,
a
I have
bundle.
seen.
It's not a distress sale.
On 14th November 2019, this property
So-
was attached.
So he has given the wrong undertaking, so let it go. Kindly come to the 17th November 2023. He has given undertaking before, he has suppressed that fact. 17 November 2023, he has made an undertaking that he will not alienate the properties with him, and whatever the order will pass, he will abide by the result of this court, order of this court. 17 November 2023, and on the basis of his submission, the court has recorded this. So the property is saved in the hand of the defendant number 8, content number 8. Now you are coming with that, stating that in the year 2019 itself, it has been taken by the government.
Lordship,
from the-
may I? 2019, the property which is mentioned in page number 3 of this order, Lordship, these are the portions from the schedule, which my learned friend has got an injunction order on 10th of September 2020. Portion of the schedule A to F, Lordship. There is a revenue attachment order in 2019 November. Thereafter, encumbrance certificate, they have asked for it. My learned friend has relied upon page 157. That also says that property was encumbered loan against due in 2020, January.
Correct.
My client has purchased because its property was attached. He purchased this property, which is part of the schedule, in the
Correct.
year 2022.
Correct.
The amount went to Red Hill, from Red Hill to the revenue recovery officer. I will show from the documents.
Correct.
He still is owning this property. He has not transferred this property to anyone else. He was not aware of this court's order, Lordship.
No, he had appeared on that day.
Appeared.
Then
Because he's part of
he could have been mentioned on that this has been resumed by the, it has been taken by the government revenue authority for realization of the
Also,
amount.
one other thing.
Why this is not brought to the notice of the court?
Correct.
Lordship would kindly take their application. Lordship would take their application, which is part of the proceeding. Lordship would take their application, page number 157. Their application, Lordship. They have relied upon one portion. They fail to rely upon other portion. Lordship would kindly see annexure F to their application, page 137,
Yes.
volume 1.
Yes.
It is, Lordship, volume 1, Lordship, page 137. May I read, Lordship? It is annexure F. Government of Tamil Nadu Registration Department, certificate of encumbrance on property. If your Lordship would see, there is a search period from 1st January 2020 to 20th March 23, much prior to the order of injunction passed by this court. Lordship would kindly turn the page over. 138. 138, Lordship would see. Lordship would see page 137 itself. It is written date of execution, presentation, registered 21st January 2020, attachment loan orders. Tehsildar, BN Kandra, Chittor district. So my respectful humble submission is in January 2020, against the loan order, this property was attached. If your Lordship would take 138, the details of the scheduled property is mentioned. 138, right hand side corner, Lordship, survey number, field number, 27912, 27913. All these are schedule number, page 51.
Correct.
So what I am humbly submitting, Lordship, my learned friend himself admits in the execution app, in the contempt application, he files this document from where it is absolutely clear against loan attachment order, the property was encumbered.
Correct.
This schedule,
Correct.
the property was encumbered.
Correct.
And revenue attached property.
Correct.
Lordship, after attachment, what has to be done? The property has to be sold off to pay the dues of 30 crores to the sugarcane suppliers.
Correct.
At that stage, Lordship, Red Hill Rice Mill Owners is an association formed in the year 85 for the welfare of the rice mill. There are 200 members, Lordship, 200 rice mill owners.
Correct.
Lordship, Jairam, we are not aware of. Lordship would see, kindly appreciate. Calcutta High Court passes an order. Property is in Tamil Nadu. Attachment order is in Andhra Pradesh. Now they approach Red Hill Rice Mill owners. Give them the power that you sell off this property. Red Hill Rice Mill owners, Lordship, finds out that there is an attachment order with regard to this scheduled property, which is the subject matter of this case, Lordship. Red Hill Rice Mill owner find out from Tamil Nadu that there is a revenue attachment order. Lordship, they take charge and they sell off. They sold off to 63 members, Lordship. Only 6, 7, 8, 3 members are before this court, Lordship. And they sell off few portion which is part of this scheduled property. And Red Rice Mill owner get that amount and deposits to Revenue Recovery Authority. 15 crores, Lordship, I handed over on that day. I have other documents also to show the entire amount went to Revenue Recovery Officer to pay the dues of the sugarcane suppliers. This is all, Lordship. And in this order, what is recorded, I have purchased the scheduled property. I'm still holding that. If after 10 September 2020 order, if my learned friend would have communicated to the collector that this is the injunction order passed against this particular land, actually we would not have purchased. Why would we do that? Unnecessarily. There are other land which we would purchase, Lordship. Lordship would kindly appreciate. And my learned friend annexes that in page 138, which is very clear. Lordship would see page 137, which I have shown. 21st January attachment loan orders. Name of the executant. So everything is clear. My learned friend only read, Lordship, in this document, page 139 the other day, and it is recorded in the order sheet also. Lordship would take page 139.
Correct.
Because it gives detail of what happened to this land. Page 139 records through general power of attorney. It was for 4th August 2022. This was sold to Red Hill Rice Owner Association. Red Hill Rice Owner Association, Lordship, was not a party to the main suit or the injunction application.
Correct.
It has to be communicated to someone.
Correct.
In order to violate your Lordship's order, first my learned friend should show that Red Hill Rice Mill Owners Association was aware of the order dated 10 September 20. And then when the order was made absolute on 13th of August 2023.
Then?
Prior to that, Lordship, everything was done on the basis of the revenue recovery officer. If your Lordship would kindly take just one document which I've handed over, which is the interdepartmental
Okay,
letter from collector to collector.
let they go for the 15 days. All the things will be settled. That's why you called them. Let them go for 15 days. They might have been enjoy the South India jail. Let they enjoy the West Bengal jail. Then we'll see.
Lordship would kindly appreciate.
Sorry.
At fault. Jairam, Sudalagunta.
Madam, you was not there when the matter initially taken. All have came here with the separate advocates. They have given an undertaking, filed separate undertaking before this court. They will pay the subsequently. They have ready to pay 8 crore rupees. Out of the 8 crore rupees, 3 crore rupees they have paid. And further, they have failed to pay. They have given an undertaking with regard to the landed property. They vanished from the court premises. Now you are coming with this document. The document was with this court, but they, in spite of that, they are giving an undertaking. On the basis of the undertaking, this court has released all the persons on condition. Let you decide if you will be in chair, what you will do.
Lordship, may I? Lordship, undertaking was given by 1 to 4 to pay off the dues.
They are also that recorded.
Lordship,
What is the recording?
Lordship, they have given an undertaking
Then?
in this order. We will not sell off this property which they have purchased.
Correct.
They will not sell off this. They have not.
You already given to the government. You already mortgage. Government has taken to sell off or directly, indirectly.
Prior to my
So what? So you could have been submitted before this court. Why you have given undertaking before this court? Though the document was there.
He undertakes that he will abide by all orders and which passed by this court. The orders passed subsequent thereafter. Lordship,
First you read the total paragraph, madam. You challenge whatever it is. This court is fed up with this all persons. They are very, I don't want to use the word here sitting in the court. Let they go for the 15 days. I am calling the persons here. Let from here only they go.
Kindly appreciate this portion of the order which my learned friend has read just now, page 3. Though the warrant could not be executed against Contempt A, but he has appeared before this court in person and filed an affidavit.
Correct.
It says he has purchased the landed property measuring about. He has purchased, Lordship, in 2022.
Correct.
2022, Lordship.
Correct.
The contender number 4, represented by, he is not suppressing anything. Whatever has happened, he has said.
Correct.
He is not aware of this court's order. Let my learned friend shows that he communicated this order.
What order? But once they have appeared before this court, what communication? They are appearing before this court. Their advocates are appeared before this court. On what is the communication further? Every day the court will go to them. Please come.
5, 6, 7, 8 are not party to the main injunction application.
We don't know, but they are the party in the contempt application. They appeared, they filed an undertaking. They have not challenged the first order.
Lordship, we were not party. We do not have to challenge.
Okay.
Lordship, order.
Then you have to face. You have to face the consequences. You have to face the consequences.
Sudalagunta.
Okay.
It was against the company.
Whatever the gunta, let the gunta come.
Decree was passed. First, the decree has to be passed. The appropriate forum is, Lordship, in my most respectful humble submission, is executing the decree.
Kindly come to the page number 4 of the order. 4, first paragraph.
Lordship, heard the learned counsel for the respective parties. Where you said the affidavit undertaking filed by contender number 458.
5 and
8.
then.
Lordship. before filing an affidavit by the contender number 4 on his behalf, as well as on Lordship, I am not 4. On behalf of contender number 1 and 2, I am also 1 and not 1 and 2. The counsel appearing on behalf of the alleged contenders 1 and 2, they submitted
Continue that.
shall pay 1, 2 and 4.
Correct.
Shall pay 8 crores. Being the full and final settlement, out of which the first installment of 1.5 crore shall be paid on 18th
So
October.
that's why he has also given undertaking.
Lordship.
Undertaking filed with the contender number 4, 5 and 8.
Before, no, Lordship, may then I.
Okay, I am not here to, I am not here to advise all the things.
Lordship, 1, 2 and
Because
even undertaking to pay this.
tell me, take the instruction whether what they will do. Otherwise, I will pass a prepared order. Because all four also, his 5 and 8 has given undertaking before this court. 1, 2, 3 is 2 has expired. 3 has expired.
Stop. Undertaking.
Okay.
Contender number 4.
4, 5 and 8. Have you gone through the undertaking?
Sir, Lordship, undertaking to what extent?
What extent?
That I will not dispose of this property
Okay.
which is purchased.
Correct.
Wrongly, right?
So wrong undertaking is filed. Wrong undertaking is filed.
They have changed their hand. They have not changed their hands for this particular property.
So you say that still he is having the ownership over the property. Yes, he can sell it. He can sell it.
Yes, he
can sell it.
No. Lordship.
He can sell it the property today. I am passing an order here in now.
He's having it.
He's having. He can sell. Let the. I will record his statement here in now.
Ask him. You ask
I will record the statement here in now on oath.
It is standing in his name, Lordship.
Come, I will record. I will bring the witness. Record the statement.
Lordship.
You tell the consequences if he's giving the evidence on oath. Tell the consequences.
The consequences.
No, then again tomorrow other advocate will come. That's why I'm telling. Now you are the fourth advocate is on record here.
Apologize for the conduct of my client, but if he says anything which is not correct,
that's why I am giving time.
Lordship, as an officer of the court, I make
that's
a
why
submission. He should not make incorrect statement in court. He doesn't understand our language, Lordship. This is the difficulty.
Who is 4? Who is 5? What is his condition? Where is the land?
Lordship, he is Mr. Dopey. He is Red Hill Rice Mill Owners Association. He has purchased on behalf of this.
Where is the land?
Lordship,
where is the land?
He is not owning any amount.
Where is the land? Whether it is in the name of the Red Mill?
Rice Mill के नाम से land है कि ना? Whether the land is in the name of the rice mill owner or to the purchaser. Lordship, 7 cents of land still stand in the name of the Rice Hill Owners Association.
I will take that also.
Yes, Lordship would kindly record.
And what is the yes? Record the what? Give the oath.
Tamil.
Lord, he said he is there.
Please help. Please translate.
I have to administer the oath. In which language should I? English.
Tell what is his name?
D. Solayappan.
Record.
D. Solayappan. Spelling?
Yes.
S-O-L-A. S-O-L-A. L-A-I-Y. A-P-P-A-N. Solayappan.
S-O-L-A-I-A-P-P-A-N. Solayappan. Son of Devan.
Son of
D-E-V-A-N. Devan.
D-E-V-A-N.
Resident of?
Malandur village.
Spelling?
M-A-L-A.
M-A-L-A.
N-D-U-R.
N-D-U-R. Malandur.
177.
177.
Number. Calcutta Post.
Calcutta Post. A-L-P-S-T.
Tiruvallur district.
Tiruvallur.
बोलिए ওথটা তো হলো না আমি বলছি আপনি ওনাকে বলান, ঠিক আছে? I solemnly affirm that
நான் சொல்வதெல்லாம் உண்மை.
whatever I depose by way of evidence,
உண்மையை தவிர வேறு எதுவும் இல்லை.
I shall speak the truth.
நான் உண்மை மட்டும்தான் சொல்கிறேன்.
No part of it shall be false.
நான் சொல்றது எதுவும் பொய் கிடையாது.
And I shall not conceal anything.
நான் எதுவும் மறைக்க மாட்டேன்.
आपकी उम्र क्या है? Age?
98, 48, 58.
58. क्या करते हैं आप? Occupation?
விவசாயம் தான் பண்ணிட்டு இருக்கேன். அக்ரிகல்ச்சர்.
उससे पूछो whether he has purchased the property bearing survey number 279/12, 279/13, 279/18, 279/19, 282/1, 282/10, 282/11, 282/12, 282/13, 282/14, 282/2, 282/3, 282/4, 282/5, 282/6, 282/9, 283/1, 283/3, 286/10, 286/2 capital B, 287/1, 287/20, and 287 by capital 2 capital A, and 289/70.
Lordship, Lordship, may I hand over a document? It would be difficult for him to remember how many. Lordship, we have made a small chart. May I hand over to my learned friend, which says, Lordship, the property held by contender number 678, 5, 6, 7, and 8. Lordship would see 8 is holding this survey number.
Let it tell whether he. That's why I given time to.
Lordship, he may not remember so many.
You do one thing. I am fixing a matter on Monday. You come with the total affidavit of assets. What the affidavit of assets he is having. What the affidavit of assets the defendant number 5 is having.
Lordship would give me some more time. Lordship.
Monday, Saturday,
Lordship, you have to
Sunday.
give me the details. If whether they are holding this detail here or whether it is lying in Chennai, Lordship, I do not know.
Today the mail.
Very well, Lordship.
Or Tuesday I am fixing.
Lordship, but give me a week's time, Lordship.
No. A week's time, then you will be. They will come to the other
Very well,
advocates.
I
You will
shall.
not come to this court. He will engage another advocate for 6 months. They will not come. Then after 6 months, then the court will take recourse of another thing. Then they will come with another advocate.
Very well, Lordship, I shall file.
For the last 2 years, this is going on.
I apologize for the conduct of my clients, Lordship. It should not have been done. It should not have been.
But one thing I should be pointing out as an officer of the court, but your lordship has mentioned several parcels of land, possibly subject to correction. He is not involved in all. There are several
That's why
deeds.
I'm asking.
There
The
are
court is
several
asking.
deeds.
That's why court is asking how many.
Yes, that is why I think I should have.
The court is not asking this.
Yes,
How much and how many.
But your lordship has mentioned the other parcel.
Because she is relying upon that.
Yes.
She is relying upon this document telling that this is earlier it was mortgage.
All these deeds are subject matter.
Subject
but
matter.
May not be particular to him.
Let us
Tuesday?
see. Very well, Lordship.
So and so appearing for the petitioner. So and so appearing for the alleged contender number 5, 6, 7, and 8. And the alleged contenders are present in person. Full stop. Though this court was full stop. The counsel for the contender number 5 and 8. 5 and 8. 5, 6, 7, 8 are present. 5 and 8 are directed to file their affidavit assets before this court after serving the copy to the learned counsel for the plaintiff on or before 6th of December 2024. Let the matter appear on 6th of December 2024 under the same heading.
My lord, all the alleged contenders should also bring the originals of the deeds. Whichever it's there,
It
kindly
is made clear that the affidavit of asset which the defendant will the alleged contempt number 5 and 7, the 4 and 5 and 8 will disclose. the same may be disclosed along with the certified copy of the original document. No, no, certified copy of the document, and to bring the original along with it. The contemptors are directed to appear in person before this court on the date fixed.
One individuals kindly restrict themselves to this scheduled property only. The scheduled property which they have purchased, Lordship.
Affidavit of assets would show.
And you give affidavit of asset, the court will consider.
Affidavit of assets, I have to disclose the other properties which are not subject matter. Lordship would kindly appreciate, Lordship.
Let me see.
The property which is the subject matter of the schedule, Lordship, which they have purchased.
Schedule nothing. That's why I wanted what are the schedule of property. They are the contemptors. It is not
Lordship,
the court is
Lordship, that with
no,
regard
no,
to
no,
the
no, no,
subject matter of this-
come on, 6.
But only one other thing, but the main persons are also
Already there.
1, 2, and 4. So if your lordship kindly
No, already there is an order.
On a subsequent date. I understand.
Lordship, another thing on the last occasion in Lordship, please to direct contentment number 8, the collector, to keep the details of the property
That
owned
date
by
is
collector
fixed.
number 8, Lordship. Lordship, details of the property owned by contemptor number 8. He is present, Lordship. He is cooperating.
As I'm telling, give the details. Then I will check
Very
the
well.
details given by the collector. What are the connivance with you and the authorities?
Grateful. Very
Madam,
well,
I
Lordship.
know
Very well,
the
Lordship.
South Indian tricks. I had a 25 years of practice on that line. I know each and every tricks of the South Indian, since the agriculture to real estate. I know how is to be trackled, how they will avoid the court. Each and everything I know. I dealt with all persons.
Lordship, let the
That's
truth
why
comes out.
the court
We
is
will
taking.
suppressing.
That's
We
why
will-
the court is taking for very first day. The court has taken the undertaking, and I told the petitioner this undertaking they will violate.
Yes.
They violate.
First day.
First day
your
I
lordship,
told
sir.
they are giving the undertaking they will violate.
Very
But
well,
the court hands were tied, so the court has to accept that
Lordship, but
undertaking.
Lordship, I understand, but so far my clients are concerned. I will prove before this court that they are not at fault.
Let
There
them
was
come,
a remedy
let them come
attachment
with the
order.
affidavit of
Pursuant
asset.
to
Let
that,
them come
everything
with the
was done.
affidavit of asset.
It is my learned friend
Not
was
to
was
take the
suppressed
court
back.
so easy.
No, Lordship, let the truth comes out.
Not the
Very well,
court
Lordship.
take so easy.
Lordship.
Yes. Next, call the matter.
Lordship, you oblige. Deeply obliged, Lordship.
Item number.
This is that rejection of plaint and amendment, Lordship is
Yes.
hearing together. Lordship, very briefly what the facts are before I come to. Well, this is a case of money lent in advance by the plaintiff, at that time Credit Suisse, now DBS Bank, to a company called Wincom Limited of UK. And the security was like in packing trade facilities, they will export the goods once they will export the goods. LCs will be opened in their favor, or on cash payment goods will be delivered. So 4 sets of bills of lading will be given. One set will be given to a coordinator or who's the defend number 4, with whom there's an agreement that he will keep the goods. The defend number 1 will go to Citibank, make the payment, get the bill of lading released, and go to defend number 4 and collect the goods. And the money will be transmitted to me. Defend number 4 was a kind of escrow for the goods. Now, this was the agreement on which we entered into the transaction. There is this. Give me 1 minute. Now, Lordship, we come to learn, we get the first inkling in 2018 that things may not go back. After all, I'm sitting abroad. So we gave a reminder to the defendant number 4 in January 18. Please, I'm reminding you, don't release the goods unless the original bills of lading are produced by defendant number 1. To give a reminder. In answer, very soon thereafter, the defendant number 4 writes to me in the US by a mail that we have come to learn that this Wincom UK is going into liquidation. And as they said, very soon thereafter, the company we find has gone into liquidation. So our only way to recover the money is from the goods. But so legally, even if the Wincom goes into liquidation, as and when I get my as and when the bills of lading are released against payment, I will get my payment because I have a secured credit and they stand outside liquidation. Like now in IBC 53 by secured credit. Then, my lord, the saga begins. From February 2018. We do not know that in the month of February 2018, this defendant number 1 files a suit in the High Court. We are served in October 2019. In this suit, they admit that they have taken out all the goods without making any payment, getting the bills of lading released. And they accuse, this is a sham case kind of, that Vincom, the goods are not very good quality. So I am not liable to pay Vincom. But then when taking the goods, they would have had to pay the money, where I am also impleaded. This is in February 18. My lord, in March 18, because of this Vincom going to liquidation, we write to the defendant number 1 on the suspicion that there may have been some connivance between defendant number 4 and defendant number 1, that you will be liable if you have taken the goods out. Then they write back in March 23rd, March 18, that the matter is sub judice. We do not know how it is, where it is sub judice. We file a police complaint on 6th of April 2018 saying that we are not being allowed to enter the godown of defendant number 4. And we are suspecting that the goods have been removed. On that suspicion, the police draws up an FIR in May 18, and ultimately there was an arrest, and they filed an anticipatory bail application, and they had to deposit, they had to pay 10 crores to get their bail.
Whether the police has seized the materials from the godown?
No, then after May 18, we then come to learn that where is that note which you gave me? Yes. That the goods have all been taken out. All been taken out by the defendant number 1. Has to be in connivance with defendant number 4. Has to be in connivance because defendant number 4 was the storekeeper, escrow for the goods. With all the goods removed, my bills of lading are lying with Citibank, original bills of lading. Not a single bill of lading taken out. In connivance, goods are taken out.
How?
Defendant number 4 just hands over the goods to the defendant number 1. Just hands over the goods. And so we filed, that's why this criminal complaint, and this is, and from the FIR, we find that when the FIR is registered, that the police registers after initial investigation that there is prima facie case. Now, this is in May 18. Thereafter, my lord, in October, keep this with me, October 19, I am served with a plaint. There I am confirmed that all the goods have been taken out by the defendant number 1. Now, my plaint, my suit is based on section 17 of the Limitation Act, discovery of fraud. When section 17 of Limitation Act applies, how far they can seek rejection of the plaint on the ground barred by limitation, because when the full discovery happens, it is the plaintiff's own perception as pleaded in the plaint. I feel that when I lodged my complaint, I was just about knowing. When the FIR is registered, I get to know more. But when the plaint comes, according to my case, it is confirmed that they have defrauded. So my discovery of fraud, it's a perception of the plaintiff, and the law requires defendant to dislodge that by proof at the appropriate stage.
What is the suit for?
The suit is for recovery of this money. Where's my brief? This is my brief. Why make it sit like me? You just take out my briefs. Kindly, my suit, Lordship, sees GA4 amended plaint is for recovery of the value of the goods removed by them, defendant number 1 and defendant number 4. But since this is a case of fraud, I have made the defendant numbers 2 and 3 were the directors of defendant number 1, persons in control also parties. Kindly see page 72 of GA, page 71 of GA 4. Paragraph 47 at page 68. Even in the amended plaint, even before amendment, it was based on fraud. Discovery of fraud. Discovery of fraud. Page 68, paragraph 47. I start getting information gradually from January 18. Limitation Act. I start discovering facts gradually from 2018 when the company goes into liquidation. But what is the law? It is the first hint is the discovery of fraud. After all, language of section 17 discovered it. Discovery of fraud. It's a personal assessment of the plaintiff.
But you had the knowledge with regard to the first suit.
First suit is served on me in October 19.
Correct.
That is, if you calculate limitation from that date, amendment, no amendment, I'm home. I'm completely home from October 19, Lordship. It is 5 months and 14 days to 14th of March 2020. When the limitation stops for 2 hours, for 2 years. And thereafter, I go for my first suit, Lordship may recall. First suit, section 12A.
So that's why Mr. Gupta has calculated on the 3 ways also.
Well, if October 19, he has not done it. So for my disservice of plaintiff, if he did the October 19.
That is not the knowledge. That's a clever drafting. The knowledge of the plaintiff is much prior. That is Mr. Mitra's knowledge.
He has taken all 3 parts.
From knowledge.
That is my learned senior friend's knowledge, not the client's knowledge.
So knowledge, if knowledge was the factor, I agree with Mr. Gupta. Can you see section 70? Is it knowledge? Unlike other provisions, though, it is discovery. Knowledge is, first accrues, there are 3 categories. Cause of action arises, first arises, and discovery of fraud. Mr. Gupta knows very well, discovery of fraud is not first knowledge of, I have the first whiff of some fraud happening. Discovery is my perception.
When the FIR was lodged?
FIR was registered, my lord, in May 16th, May 2018. Even from that date, I am home. When they first give my notice, I get to know, I get some idea. If I give from the first day of notice, from that day, if you take, there may be some difficulty. But at the first hint, I'm not supposed to file. That's not section 17. After all, section 17 is very clear.
Fraud, yes.
Dr. Kelly, may I just read out section 17?
Yes.
Where the case of any suit or application for which a period of limitation is prescribed by this court, by this act, the suit or application is based upon the fraud of the defendant. The knowledge of the right to sue is founded on fraud. Because my original contract is against Vincom. Then C, the suit for application is for relief. C doesn't apply. A and B.
Suit for application based upon the fraud.
And B is
knowledge of the right or title on which the suit application is founded is concealed by fraud.
The fraud. Now, Lordship kindly sees below that the period of limitation shall not begin to run until the plaintiff or applicant has discovered the fraud. So, Lordship, there the judgments are they discovered the fraud or mistake or could with reasonable diligence have discovered it. Reasonable diligence have discovered it. My lord, they can legitimately say that with reasonable diligence I could have discovered from the date their plaint is served on me. So that is in the plaint that case is for the first time we come to learn an admission from them that they have taken away the goods.
Yes.
So, coupled with, even if
yes,
the admission part, because there's some averments in the plaint here, in the affidavit filed even thereafter. So, discovery of fraud. And that is not a case which is brought in by amendment for the first time. So, Lordship, I have elaborated it by your first time. Lordship kindly sees page, the plaint, this application, paragraph 29. Na?
GA. GA4.
In this GA4, Lordship sees page 61. So I have referred to the plaint earlier. This is not a new fact I am stating. He showed as if the plaint I mentioned for the first time there. In October 19, copies of the above referred civil suit filed by the defendant number 1, Calcutta High Court on 16 February against Vincom and the plaintiff here were formally served upon the plaintiff. The civil suit has been filed by defendant number 1 claiming from Vincom certain alleged losses suffered by them for non-delivery of the entire contracted quantity of the goods, due to which losses were suffered since the price of the commodity fluctuated. Defendant number 1 also claimed a provisional injunction. So it is pertinent to know that in the suit, the defendant number 1 expressly admitted to having received the goods. So the pleading is there. It's not for the first time. I have said, my lord, I have elaborated on this in the proposed amendment, discovery of fraud. Kindly come to page 69, the red mark portion.
Yes.
The last 3 lines I am coming. The plaint in the said suit was signed and verified by defendant number 2 on behalf of defendant number 1. A copy where this copy. So this is already referred to. This plaint was served upon the plaintiff here in October. 1st October, I said as an elaboration of what is there earlier. When it was fully confirmed beyond doubt in view of the defendant's own admission that the defendant had fraudulently misappropriated the goods. This is, but the plaint is there. The plaint admission, that's there. So the Order 7, Rule 11, rejection of plaint is a far cry. I've given the elaboration in the plaint which has been referred to earlier has happened in the proposed amendment.
But page 55, paragraph 16. Page 55, paragraph 16. On 14 March 2007, suspecting the defendant had taken possession of the goods while notice assignment request of the payment legal notice addressed to the defendant intimated that regarding the assignment to the so
on suspecting. So whether that will be discovery of fraud, that's because this is the section 17 case.
Okay.
Kindly see the next paragraph, paragraph 17.
In response to the paragraph 17, I shall place in response to this aforesaid legal notices, the defendant number 1, by letter of 23rd March, while not denying that they had taken possession of the goods or their obligation to pay the full price under the goods, stated that there was no mutual contract between them and the plaintiff, and that all queries must be directed to Vincom. The response to the legal notices also mischievously mentioned that the subject matter of the plaintiff's legal notice was sub judice before Indian courts without actually disclosing that a suit had been filed in the Calcutta High Court, including against the plaintiff on 16th February. The defendant number 1 had mischievously and deliberately asked the plaintiff to put all its queries to Vincom Limited, knowing full well that Vincom Limited sometime on or about January 24th gone into liquidation. Now see next paragraph. Paragraph 18. Under the aforesaid circumstances, on 6th April 2018, the plaintiff, on the apprehension that the goods entrusted to Bhaumik Agency were misappropriated, filed a criminal complaint. Whether that will, section 17 will start from that date. And any order on...
Yes. Then
the complaint, Lordship will see page 57. The complaint was ultimately taken for investigation by the Westport Police Station under the Port Division Calcutta. Copy of the complaint. Para 19. On 16th May 18, after a preliminary investigation, the Westport Police Station, Kolkata, lodged the FIR number so-and-so against these persons. Copy is the next. After the commencement of the criminal investigation, the plaintiff also became aware that the defendant number 1 had in fact filed a suit on 16th February But if it's May 18 also, I'm home. 16th February 18 against Vincom and also the plaintiff, which is currently pending in the Calcutta High Court. The defendant number one has in the civil suit expressly admitted to taking possession of the goods, thereby confirming that they have in fact taken possession of the goods, but without making any payment towards the same to the plaintiff. Defendant number one's bank also returned from time to two times several bills of leading to the plaintiff, indicating the bank had not received instruction. On May 22, 2018, the police arrested the defendant number 4 when he was produced before the chief judicial magistrate. All this is within limitation period. 24 Parganas, a statement was made that defendant number 1 has been an employee of Bhaumik agency for the past 2 decades. Furthermore, defendant number 4 was also formally appointed as the director of Softel, having the same register of so. Para 22. On May 25, 2018, an anticipatory bail application was moved on defendant by the defendant numbers 2 and 3, being directors of defendant number 1 before the Calcutta High Court. Calcutta High Court, after the hearing, passed an order directing the police to not arrest until further orders. It also directed the defendant number 2 to cooperate with the investigation while imposing restrictions on leaving the city and ensuring deposit of passports. On the same day, the police arrested one Pawan Kumar Didwania and father of defendant number 2, presumably while they is not the directors. Now, Lordship, this is not a cause of action for money lent in advance.
Yes.
And seized goods were only 1 crore worth.
So it will take time. Census suffering for the plaintiff, census suffering for the defendant. The counsel for the plaintiff has argued at length in connection with GA4 of 2024, but due to paucity of time, hearing could not be completed. Fixed matter on 10th December.
This is part heard matter, Lordship.
Yes, part heard.
Agreed.
Part heard is already there.
Lordship is there.
Grateful. Yes, next, call the fixed matter.
Just in the previous matter where Mr. Mitra was appearing, there was an order passed. An earlier amendment had been allowed to change the name of the plaintiff because there was a merger. We had to re-verify the plaint. Today was the last day for re-verification. We were just hoping if your lordship could kindly extend our time so that
Why your office is so, in every case you are not doing anything. In every case, extension of time, filing this.
I'll tell you.
All time you're making the same prayers.
May I just say why? Because this amendment is pending, which your lordship is hearing.
Which amendment is over?
No, this
number 1.
No, there's a substitution application.
There was a substitution application because the name
existence had ceased to exist.
Yes, because the plaintiff had merged with another entity, so there was a substitution.
Come on there.
If your lordship may kindly extend the time, then because this amendment is to be allowed. So if this amendment is allowed, then both
come on the next, we'll see.
Grateful.
Before the 12 noon matter is taken up, my lord, the next item number 16.
Yes.
My lord, it's a review petition, my lord. The affidavits are complete. Now, my lord, if your lordship is pleased to fix it on any day, but it's my duty to point out, my lord, from the same suit, my client had also made an application under Section 8 of the Arbitration and Conciliation Act. That application was dismissed. The appeal is pending. The appeal court has made certain observations, my lord, trying to possibly settle it's a family dispute. But if your lordship is pleased to keep it on some other day, my lord.
Item 16.
Item 16. I appear for the plaintiff respondent, my lord.
Census appearing for the plaintiff, census appearing for the defendant.
I am for the defendants number 1 to 4.
1 to 4, huh? Full stop. It is submitted that in connection with review 41 of 2024, pleadings have been completed. and paid for fixing the matter to some other date. In view of the submission made by the counsel for the parties, let the matter appear before after vacation.
After vacation, my lord, if the appeal court in the meantime, my lord, disposes of the matter,
let the matter appear on 9-10 को देखो टाइम है 3 बजे 4 बजे 2 बजे जनवरी at non-commercial commercial day na 10th January.
10 January is a Friday, my lord.
10 January at 2 p.m. Yes, call the matter.
7 and 8 of the commercial sexual.
Yes.
Not just one last. Yesterday, I cited that Supreme Court judgment of 54 Supreme Court.
Yes,
I think I did not mention the correct page within it. Your Lordship, just bear with me on that. It's page 38 of the printed copy. Paragraph 37. Page 38. The pages on the top left, and paragraph 37, last 5 lines. I'll just show that. The majority judgments, therefore, are defective on the face of them in that they did not effectively deal with and determine an important issue in the case on which depends the title of the plaintiffs and the maintainability of the suit. This, in our opinion, is certainly an error apparent on the face of the record. Yes, sir. I'm sorry I didn't have the page. I tried finding it, but sometimes in court, my lord, you get a little flustered on time. So, my lord, to proceed further, yesterday, the argument which I've made and which I'm not going to go into is that the fundamental point of breach of the agreement of 22nd February was expressly not decided, and that vitiates the award. Now, my lord, to go to the next point, which is on this issue, where we had said that the determination of the question of breach of 10th May was actually a matter extrinsic to the pleadings and therefore something that the court really tribunal could not have gone into. And I'd cited the Grinley's judgment. My friend in his reply, my lord, said that, look, an issue was raised on that point. So you were aware that it was going to be taken up. And even if it was not strictly in the pleadings, since you had noticed, that point doesn't survive. I'm dealing with that. Lord, I submit that that does not fully appreciate with respect why we had said there is no jurisdiction. Just bear with me on that. Shortly, I'll deal with it. My lord, the necessary consequence of the failure to determine point number 1, the breach of the 22nd February order, is that there could be no award for damages of breach of that. Because if you don't determine whether there has been a breach, who has been a breach, you cannot give any award of damages for breach of that.
Yes.
Now, my lord, why do I say that? If your lordship recollects, on 27th April, when the reference was made, the court said 2 things. The plaintiff said, sorry.
Yes.
The respondent, that's OMPL, said that, look, I'm not required to deliver the goods. If I deliver the goods and I succeed in the arbitration, then I should succeed to get the difference between the present market rate and the rate at which I was giving. On our side, we said that, look, if we succeed in the suit, you're bound to deliver to us, so no question of damages arise. And it is in that context that 5 crore bank guarantee was given at the undertaking. Now, since the tribunal failed to decide who was in breach, that second part really couldn't come into play. And
so that's why your main point is with once the
yes, of course, everything flows from that. I agree with you.
Tribunal, if this court held,
yes,
the tribunal has not decided the issue with regard to the contract.
Right.
Because
everything flows from.
Because as per while deciding the issue, though the issue were framed, but while deciding the issue, the tribunal stated that it is not required.
Right.
It is not. So that is the one issue with regard to the breach of the contract.
Yes.
If that the court held that yes, the tribunal has not decided with regard to the whether any of the parties has breaches the contract.
Right.
So,
yeah, my lord, I see. But my lord, since there were 3 subsidiary points, I'm dealing with them. But I appreciate what your lordship said, that is the fulcrum point.
Yes.
If I lose on that, the rest of my points don't fit.
Correct.
If I win on that, the rest also really flows
Automatically.
I appreciate, my lord. But just very briefly, I'm not going to exceed that 30-minute limit.
No problem.
No,
you take your own time.
I would just like to deal with the points. It shouldn't be that I've not dealt with the reply and the other points. So, my lord, any such finding on that 5 crore or the difference really posited a determination of who had committed breach of 22nd April. Now, when the arbitrator awarded damages in this particular case, he went not on 22nd February, but on who committed breach of 10th May.
Order.
10th May order. Now, my lord, let us just consider, therefore, it was a question of award of damages, deours the question of the original contract. Now, what is the effect of that? Let me just see.
That's why I wanted to put the question to you. What would be the effect of the order passed by the, if we go?
Yeah.
If this court will go by the arbitrator. Yes. Contract is there. Need not to, because already the court has framed the timeline. You have to do something. This is to be
as a working arrangement.
Working arrangement, and any of the parties has violated the order. That's why the arbitrator has decided. So what would be effect of that? The order passed by the High Court.
It would mean, just to answer that immediately before going, is that the arbitrator had necessarily to decide that question. Who committed breach?
But taking into the first point together.
Yes, that's the first point really. My lord, the whole matter gets vitiated because the essential reference was on that. I'll show your lordship how the orders came before the arbitrator and why they are not really a substantive reference. Let me just give your lordship this, my lord. The reference was made on 28th of April 2022. At that time, the 10th May order didn't even exist. So disputes regarding that could never have been referred in that sense. Now, how did the matter proceed? The statement of claim only dealt with, that's our claim before the arbitrator, only dealt with the issue of breach of 22nd February 2022. And our claim was that since you are liable to deliver to me on 21st April and you didn't deliver to me, I claim the difference between the price of the goods on that date and the contract price, and I claim 10 crores. Now, my lord, comes the slight twist here. We also added additional claims for expenses that we claimed we had suffered as a consequence of the orders of 28th April and 10th. And what were the claims? Interest, bank guarantee charges, and LC charges. But those were consequent additional amounts consequent on the first claim. That's the way. Now, what did the defense do? It's important. No? It's at 366. I'll read it. But let me tell your lordship. The defense recorded in its claim all the sequence of events. And then it said that on 14th April, we had terminated the contract and returned your money. So there was no question of us being liable to deliver the goods. That was its main claim. They made no claim for damages on breach because their case was they were not liable to deliver. Simpliciter. But in view of the working order, which said they have to give us the goods, they said that, look, if I succeed and I have to give you the goods at this price, I will claim a difference. And that was the claim. Then they said, my lord, in that statement of defense, that assuming you are at fault and you are at breach, and we as defendants have not committed breach, I was restrained from dealing with the goods from 25th April to 14th June.
Yes.
Yes. Therefore, we should claim the difference on the date on which, when we could deal with the goods compared to its market value. That was it. But the most important thing is, even the defendant only related that to a finding on breach of 22nd February. Therefore, it was not an independent claim. I've got the page numbers. It's quite clear, my lord, it's not. The claim was posited on breach being found in their favor. Then it went on. Now, on these pleadings, The three issues were raised. Issues 2 and 3 did not arise independently. They were arising as a consequence of issue number 1.
Correct.
That is how the pleadings went to the arbitrator. But what the arbitrator did was very peculiar, my lord.
Yes.
He discarded issue 1 and then treated issues 2 and 3 as independent issues. That is why the arbitrator's discussion and order is contrary to the pleadings and is contrary to the case of the parties. That is why Grindley is attached, not simpliciter by going into the point. If, let me ask and put it differently. Suppose he had gone into issue number 1, held we are at fault, and then gone into issue numbers 2 and 3 to determine what additional damages were caused, he would have been acting within jurisdiction. The absence of jurisdiction arises because issues 2 and 3 were in the pleading of the parties consequential issues.
Subsequent to.
Yes. No, consequential in the sense that you decide this, then you decide that. Yes. Now, the arbitrator, by discarding issue 1 and treating issue 3 as a substantive issue, acted contrary to the pleadings of the parties. So that is the point, not merely that you went into it. I just wanted to clarify that he would have been entitled to go into it as a consequential issue.
Yes.
He was not entitled to go into it as an independent substantive claim because that was not what the parties came before him. So, my lord, the mere fact that issue 3 was raised or that he could have otherwise decided it is not the argument.
If suppose,
Yes. Yes, of
if
course.
suppose,
Yes.
if suppose the arbitrator would not have been framed the issue and directly decide that. Sometimes it's happened.
Yes.
Sometimes it's happened.
Yes.
So what would be effect? If
decided the first point,
yes,
he would be totally justified.
correct.
Even
No,
if he didn't
that's
raise the
here
issue.
what the arbitrator, as per your argument, what the arbitrator initially taken the 4 issues.
Yes. 3 issues.
3 issues. First issue with regard to the contract, other 2 issues with regard to the orders of the
Yes.
court.
Yes.
So then subsequently whatever
The first 3 are the
taken.
relevant ones.
Taken. Now your contention is that the contention it is in the record also. The arbitrator has left the issue.
Expressly not decided.
Not
Decided
decided.
not to decide.
Not to decide.
Yes. In other words, yes.
It is on record.
Yes.
But if suppose the arbitrator would not have been framed the issue and directly his could have been decided on the basis of the record, what would be the risk?
So long as he decided that first point. Well, the framing of issues is a matter of form. The matter of substance was that this point required to be decided. So whether he framed an issue or not, if he had in fact decided the first point, that who was responsible for breach, the award would have been valid. It would not meet. I am not suggesting that the framing of the issue is of any consequence. The point had to be decided. As the Supreme Court says, my lord, the relevant point.
That's why I'm asking.
No, so I agree with my friend. If it was just a matter of form or saying it could be decided by some other issue, all that is okay. I'm not going on the form. I'm on the substance. That the fulcrum point, the point of reference was not decided and decided not to be decided.
Okay.
Now, therefore, my lord, the only point I want to make on the second point is that it's not merely because the arbitrator could not have decided on the 10th May, but he could only have decided on the 10th May as consequential to item 1. What he did was he deleted item 1 and went on 10th May as an independent substantive cause.
Yes,
of
got
action.
you, got you.
And that is why it's contrary without jurisdiction.
Yes.
And that is why it's contrary to the pleadings of the parties. So the response of the other side that the issue was raised, that's not an answer. The issue was raised consequential, treated differently. So, my lord, that's the second point which I'm. The third point is this issue of the award of damages, which he has done in 2 counts, 5.6 crores being the difference on 25th April and 21.98 lakhs being the difference on 14 June. Now, first of all, my lord, as I said, this really is non-consequential because once you don't decide the question of breach, what could you award any damages to any party? But let us test it. It's also unintelligible. I'll tell your lordship why, my lord. Because there can only be one point of assessment of damages. There cannot be multiple points of assessment of damages. what the arbitrator here does is, up to paragraph 54, he lays down what they have established. In paragraphs A and B, he says they have established a difference of 5.6 crores on 25th April when the first injunction went. In paragraph E, he says they have established a difference of 21.98 lakhs on 14 June when the injunction was vacated. Now, from 55 onwards, the matter went a little different. In 55, we argued that there can only be one point for the assessment of damages, that is the date of breach. And if I did not take delivery on 21st April, that could have been the only date for breach. The arbitrator then cites a whole lot of judgments on breach. And he says that in the facts of this case, when they could not have sold the goods from 25th April to 14 June, the correct date must be the difference on the date of 14 June. And then he assesses that it's 21.98 lakhs. However, in the award, there is no award for 21.98 lakhs. And the award is only for 5.6 crores. So it's like saying the whole reasoning from 55 to 58. He doesn't follow.
Yeah,
Can we look at the award minute? 5 minutes. Just a few paras.
733.
Volume 6. Just 5 minutes virtually to make it clear. Paragraph 55, 54 first. Page 816 is paragraph 54.
Yes.
And your lordship sees, sorry, yeah, 54. He says, after taking into consideration, the following facts are established. A and B deal with the difference between 25th April price and the market price. And he says that comes to 5.6 crores.
Yes.
Then he goes to E. The C and D are minor intermediate. E, he says the difference between 14 June and contract price is 21,98,700. So those are the two.
Correct.
Then, my lord, in 55, he notes our argument that the only date which is relevant would be the date of breach, which is 21st April 2022, the date for delivery under the contract.
Correct.
He then cites a whole lot of judgments that goes on up to 822.
Yes.
And then he says, bottom line, in the second last para on 822, in the opinion of this tribunal, the claimant being fully conscious that on consent of parties, the respondent was restrained from disposing of the goods till 13 June, it could not before that date terminate the contract, therefore the contention, etc. And then, if your lordship goes over the page, some more judgments. And in paragraph 58 at page 826.
Yes.
This is after all the law, this is the conclusion. Applying the above principles to the facts of the present case, the tribunal holds that the respondent should get the difference of contract price and price of the goods in the market on the date next to vacating the interim order of 14 June as loss suffered for the breach committed by the claimant. In fact, as it appears from the two consent orders passed by the High Court, the division bench demanded undertakings from parties and also assessed the rate of interest payable by the losing party to the successful party. Then it adjusts and it awards the claim. Now, item A is the 5.6 crores as per A and B.
Yes.
Item E, which should have been the 21.98, is not there. There's just no award made. So there is no consequential award actually made pursuant to para 58. I'll tell your lordship how this happened. It's a little complex. When the initial statement of defense was filed, it had only A, B, C, D.
Then thereafter,
they amended it in
Correct.
August by adding E.
Correct.
When the matter came up for argument,
Yeah, okay.
counsel said, I want to drop E. The arbitrator says, no, I disregard that concession. I'll go into the matter. But he has not granted E again.
Because he has considered the submission of the advocate of the respondent.
But then paragraph 58 would make no sense. Paragraph 58 is after all the law, he says they would be entitled to get the difference on 14 June. And that difference he doesn't award. So right from 55.
So where is their amendment?
That amendment, sure, it's in their amended statement of claim. It's at, I've got the date. It's in the second version. Yes, would your lordship see 477? Added by the amendment is item E. 477.
Yes.
E. Difference damages for the difference in the market price on 14 June, 21,98,700. Lordship has seen that?
Yes, yes.
That was added by the amendment. Arbitrator in para 58 says, this is the test I'm going to give. But he doesn't award it at the end of the day. It's an unintelligible award. He just doesn't. He only puts some that earlier para 54AB.
54AB and E.
No, he doesn't put E. He says in 58.
E is contrary, yes.
Says that he is only granting that, but he doesn't pass an award in those terms. The operative award only covers AB. It doesn't cover E. And my friend, I believe, said that A and B is not damages, it's in equitable consideration.
Correct.
But where is E? That means he's not awarding any damages at all. There's an error apparent. Para 58 is not reflected in para 59. It's unintelligible. The whole of paras 55, 56, 57, 58, running from page 817 to 827, all result in para 58. And that is not there, that E is not there only in the award. And A and B is there, although there is no reasoning for that right from 55 to 58. So apart from the fact that no award could have been made, even what is made on its own terms is unintelligible.
Vudu, 607.
607. Let's see. So what is that? The one where he drops the claim, 8608.
Yes.
But the arbitrator says, I'm disregarding that and granting it. 608 is the minutes where that concession was made.
That's why.
Right? And then in the award, he says that although he may say this, I'm not bound to accept it. I ignore that. That's at 814. Para 51. Middle of the page, 814. It may be mentioned here that advocate had submitted on instructions from his client, he was not pressing the claim in para 47E.
Read with 44.
Yes, as reflected in paragraph 2 of the minutes of the 8th sitting. The above concession, in the opinion of the tribunal, the above concession should be ignored because the respondent had filed 2 statements. But this amendment came in the second statement. The arbitrator seems to feel it was there in some earlier statement. But whichever way it goes, my lord, how do you explain para 58, 55 to 58 on page 827? It's ununderstandable. 5 pages of discussion, citing of all the law, concluding in 58 that the difference on 14 June, which is paragraph E, should be allowed. Then in the award that is not there, and instead pair A and B on which there is no discussion at all, suddenly comes up. My friend may say it's on equitable grounds. The arbitrator does not give any such indication. If it was an equitable grounds, where is the legal ground? No damages are awarded. So apart from the fact, my lord, I go back to the main point is no question of damages arose because he didn't decide who was in breach. Even what is decided is unintelligible.
Okay.
That leaves me with the last point, Miller. This issue of the LC. I think it is of the least importance because once those first 2, 3 go, really it's not relevant. But just to tell your lordship what happened. My lord, if your lordship looks at the order which is set out here, just give me a moment. So your lordship doesn't have to go beyond this. In the 28th April order, it's set out at page 789 in the award.
Yes.
On the top, claimant will amend the site LC into a usance LC upon a written request from the respondent within 7 working days for the balance contract value against following documents. And also kindly read F. The amended LC will be discounted by the claimant through the claimant's bankers under the claimant's limits within another 3 days after submission of originals by the respondent to the banker of the claimants, and discounting charges will be borne by the claimants. And G, respondent undertakes to start giving delivery to the claimants after receiving the balance consideration through the usance LC. These are the 3 clauses.
Correct.
Now, therefore, my lord, the scheme which the court order directed was,
Yes.
you ask for a usance LC.
Yes.
2. Secondly, when he gives the documents under the LC, I was to arrange for the same to be discounted by my bankers and the amount on discount being paid to him. And on that, he was to give me delivery. Now, what he said was that, no, I'm not agreeable to a usance LC at all. It must be a usance LC payable at site. Now, that's especially contrary because what would happen if it was a usance LC payable at site, he would require the money under the LC immediately. That's not the scheme.
But unless the materials is not delivered, how the usance LC can be revoked?
No, not revoked. No, what he meant was that when he produced his documents under the usance LC, he should be paid immediately. And the question of usance was between me and my bankers. That is the argument made. And that is what he urged here. Now, that is directly contrary. There is no doubt that the payment was to be made before delivery. No question about it.
That's why.
Payment to him was not to be made under the LC because the LC was usance. It was to be made under clause F by our discounting these documents with our bankers. See F, my lord. The awarded amended LC will be discounted by the claimant through the claimant's bankers under the claimant's limits within another 3 days of submission of originals by the respondent to the banker. So what was the scheme? The LC had to be only a usance LC. But when he produced the documents, I was to discount those documents on my limits from my bankers, pay him the money, and only then get delivery.
Correct.
What he insisted was the LC itself must be payable at site, not a usance LC. Now that is directly contrary to A, because it's only a usance LC. So he invented this theory of a usance LC payable at site.
Yes.
But there's nothing in A which requires the LC to be payable at site. Only F says that on discount he is to get the money. So his insistence that you open a LC payable at site is directly contrary to the terms of the order. And the arbitrator invents a new type of LC where he says usance LC payable at site. A doesn't require a usance LC payable at site.
The usance A is the claimant will amend the site LC into the usance LC.
So therefore, the only LC was to be a usance LC.
Correct.
Then how was he to get the money? He was to get the money under F.
Upon written request to the letter to the respondent within 7
He was to only require the LC to be changed to usance.
Correct.
Now, what he insisted was you change the LC to usance but payable at site. Now, that is directly contrary to A. He is confusing F with an LC payable at site. F is not that the LC would be payable at site, but that I would discount the usance LC and I would pay him the money from my bankers.
Yes.
So the finding of the arbitrator was, and I'll show your lordship, after a whole lot of correspondence, he says, just give me 1 minute. Yes.
Because the clause 42C,
Sorry,
clause 42C,
42C.
790, page 790.
Let's just look at it. 42.
Page 790.
790.
Yes. 790 in the middle.
Clause, the words drafted site
Correct.
to be replaced by the words drafted usance. Now mark this. Provided that the beneficiary will be paid at site.
Correct.
The LC doesn't provide that. Under the LC is getting it at site. They gets it from discount under F. My lord, if it was to get it under the LC, then clause A would have so provided. F provides that LC is at usance only.
Correct.
But you, the claimant, will discount the documents with
After
your
producing the
bankers
document.
and pay him within 3 days. So his insistence on a LC payable at site is directly contrary to the requirements of this order. But the arbitrator reads it as you read it with F, and therefore it is required to be at site. Well, now just see this one part.
Yes.
Where he says,
Paragraph 37, 790. According to the claimant, the request made with.
well, this, etc.
Yes.
However, now look the 5 lines later. However, the respondent would be paid within 3 days of the claimant to discount the LC in terms of paragraph 3, and on such discounting made, LC issuing bank would release payment is not correct. Discounting bank has to release payment, and payment would come to me and I would give it to him. Look at F. Well, just read F with para 37. F is on 36, the other page.
Yes.
The amended LC will be discounted by the claimant through the claimant's bankers under the claimant's limits within 3 days of submission of the documents by the respondents. And then we would give the payment.
The respondent would be paid within 3 days of presentation.
So the arbitrator is completely wrong in thinking that this LC was to be discounted by him and he was to get the money immediately. I was to discount it and I was to pay him the money. F is very clear. Who is to discount? Claimant is to discount. Discount with whom? Claimant's banker. And then that is to be paid to him.
Within 3 days after the submission of the original.
Yes. So originals are given by him.
However, the respondent would be paid within 3 days for the presentation of the document. 3 days being the time available to the claimant to the discount of the LC in terms of the paragraph 3 of the order.
Available to the claimant to discount the LC, not to the respondent. If it's at site, he would be getting it immediately from the bank. No question of my discounting or my doing anything. Therefore, clause F has been misunderstood by the tribunal. F doesn't mean he's to get it at site. F only means I have to discount and pay him within 3 days. But the LC remains a usance LC only. This, my lord, according to me, is the smallest of the points because after the first 3 come through,
that is
this becomes
subsequent.
irrelevant. But I'm addressing it because it's there.
Subsequent. So the tribunal holds that the respondent has complied with the first part of the condition mentioned above, issuing the appropriate request letter within the time fixed by the division bench in the tune of the order. Yes. Next.
So everything the tribunal goes on F to misconstrue A. And look at paragraph 44, page 806, his ultimate conclusion.
Eight hundred?
806 at paragraph 44.
Yes.
From the above interchange of emails, the tribunal is convinced that the respondent has by its email dated 23rd May complied with the first part of the order. The additional sentences of requesting of amending the site LC into a usance LC is in conformity with the directions. And what he explains is the next page at 807, last paragraph. In the request letter sent on 23rd May, the respondent is instructed to amend the LC on the basis of the order of the division bench. Clause A mentioned above to convert the LC from site to usance was subject to clause F. F doesn't deal with the nature of the LC at all. F deals with my discounting of that LC in under my. This type of usance LC is not uncommon. Usance LC payable at site is all completely outside the record. Clause F, my lord, doesn't deal with the nature of the LC at all. It only says that on him giving the documents, I was to discount them against my bankers and give him the money.
Correct.
So the LC was not to be changed into a site LC.
Discounted by the claimant to the claimant's bank.
So he's not involved in that. I have to do it. Where is the question of the LC becoming at site? So the arbitrator, by going ahead and saying that F A is subject to F, A deals with LC, F deals with discount by me. They're two completely different things. It's not, I am not discounting under the LC. I'm discounting under the limits with my bankers.
Yes. That's all. Thank you.
Greatly obliged.
Thank you.
Not going into any niggling details. These four issues are the dominant point.
Thank you. Thank you.
My lord, that's Dean Millard and I wouldn't call it re-arguing, but re-emphasizing. My lord, Dean Millard.
He's being polite to me.
So, my lord, the crux of the Millard challenge, as Millard, Mr. Chinoy Millard has Millard indicated, is that the main issue which was to be decided was whether there was a breach of the original contract. Now, Millard, I do not know, and Millard, he of course paid me a compliment that Millard, that was perfunctorily Millard dealt with Millard in my Millard arguments. But Millard, with the greatest of respect to my learned friend Millard, I had Millard drawn your lordship's attention to what the award says, Millard, when it doesn't deal with those issues. And Millard, also Millard, the provisions, Millard, of Millard, the Code of Civil Procedure, and Millard, decision Millard, which I had Millard cited, that all matters Millard need not be decided. Two decisions. Yes, Supreme Court in Delhi. Millard, I believe Millard, there is no problem Millard with the propositions there. Now, Millard, my learned friend Millard in rejoinder Millard has relied on Millard 3 cases, if I'm not mistaken. Millard, the first is Millard, the decision Millard of Millard, the Supreme Court, Millard, in a Section 11 petition. It's 2010, 3 Supreme Court cases, 267. Yeah, Millard, that's Millard. Paragraph 8, Millard, was Millard relied on. Millard, which says Millard that Millard, it's the dispute as subsisting. Millard, the interpretation of Millard this case is that the dispute which was subsisting as on the date of the reference is to be Millard decided by the arbitrator when Millard there is an order of reference, and Millard any subsequent disputes Millard will Millard have to be Millard in the decided in Millard subsequent references, because Millard the arbitration agreement does not perish Millard with one Millard reference. Millard, that's Millard. Now Millard, I'll deal with, my lord, this case, my lord, on, my lord, the facts itself, which shows, my lord, it's wholly irrelevant as far as this case is concerned. But, my lord, this decision was rendered, your lordships will find, on 17th February 2010. So really, my lord, it cannot be, my lord, treated as a precedent.
Before the amendment.
Yes. Now, my lord, kindly have a look at the act once, and I'll just cite one case. Arbitration. My lord, the section 3A, my lord, was introduced. My lord, the Supreme Court and the High Court shall have the power to designate arbitral institutions which have been graded by so-and-so, so-and-so. Provided that in respect of High Court, where no, etc., provided further concerned from time to time, review the panel. And then, my lord, this is, my lord, how similar.
Just sorry.
3A.
21.
No,
Which act?
96 Act.
Which act?
Now it's deleted, I think.
Yeah, correct.
So I couldn't figure out. Sorry, apologies.
Yes. Now, my lord, what is in
Which act you are referring, Mr. Mukherjee?
Yes, I've given.
What ones?
Oh, your lordships, my lord. Oh, sorry.
I don't have that. It was deleted later on.
Correct. Now, my lord, in fact, my lord, just give the latest slide. My lord, kindly have a look. My lord, 3A, my lord, was, my lord, inserted, my lord, in August 2019, but it's yet to be notified. That's why probably it's not there.
It's not in the
Yes. Yes.
Yes, yes, it is there. It is there.
Yes.
That's why it is not notified.
Yes. Now, my lord, what's the date of this?
2024.
Now, my lord, what is important, my lord, is, my lord, earlier, my lord, section 11, my lord, used to be, my lord, the Chief Justice or his designate, my lord, who would, my lord, decide. Now, apropos that, my lord, there's one decision, my lord, I wish to cite, that this cannot be, my lord, used as, my lord, a precedent. 2015, one Supreme Court cases, page 32.
Yes.
And, my lord, the judgment was delivered, my lord, by a good friend of ours. Now we can call him a friend, my lord.
Oh.
Ali Rohington.
It's prolific on arbitration.
Yes, ma'am. Now, my lord, kindly come, my lord, to, my lord, paragraph 16 at page 41.
Yes.
Now, my lord, after, my lord, setting out, my lord, the passage, my lord, from SBP's case,
Yes.
kindly come to, my lord, page 43, my lord, just under the quote, my lord, just after the quote. It is obvious that section 11 applications are not to be moved before the court as defined, but before the Chief Justice either of the High Court or of the Supreme Court, as the case may be, or their delegates. This is despite the fact that the Chief Justice or his delegate have now to decide judicially and not administratively. Again, section 42 would not apply to applications made before the Chief Justice or his delegate for the simple reason that the Chief Justice or his delegate is not court as defined by section 21E. The said view was reiterated somewhat differently in Pandey. Then 17. That the Chief Justice does not represent the High Court or Supreme Court, as the case may be, is also clear from section 1110. The Chief Justice may make such scheme, etc. The scheme referred to in the subsection is a scheme by which the Chief Justice may provide for the procedure to be followed in cases dealt with by him. This again shows that it is not the High Court or the Supreme Court rules that are to be followed but by a separate set of rules made by the Chief Justice for so and so. Then, my lord, after my lord setting out of the section, kindly come to my lord it's obvious that 11th was necessary in order to be clear that Chief Justice of the High Court will only be such the Chief Justice within whose local limits the principal civil court is situated and Chief Justice of that High Court which is referred to in so and so. This subsection also does not in any manner make the Chief Justice or his designate for the purpose of section. Again, the decision of the Chief Justice or his designate, kindly note, this is what I rely on, not being the decision of the Supreme Court or the High Court, as the case may be, has no precedential value, being a decision of a judicial authority, which is not a court of record. So, my lord, it is not to be treated, my lord, as a precedent. Now, my lord, kindly have a look at that case, my lord, which is, my lord, with the greatest of respect, my lord, is not applicable at all. Kindly come to paragraph 2, my lord, at page 269 of 2010 TSCC 267.
Yes.
The applicant, I'm just wanting to show your lordship, my lord, the claim which had been made. The applicant makes the grievance that a number of its invoices were not paid or only paid in part by the respondent, and on demands being made, respondent did not even give any satisfactory reply for non-payment, part payment. Failing to get any positive response from the respondent, despite applicant was left with no option but to invoke the arbitration clause under the agreement. It accordingly addressed a notice to so-and-so invoking arbitration on the disputes broadly set out in the notice and nominating. The applicant further states that respondent did not respond in the manner, etc. Mr. Gaurav Agarwal, learned counsel appearing for respondent, accept the provision for arbitration. He also acknowledged that disputes raised arose under the agreement and were fully arbitrable. Nevertheless, he resisted the applicant's prayer to refer the disputes raised in the arbitration notice to arbitration on the plea that the applicant had already invoked the arbitration clause, albeit in connection with a different dispute earlier arising under the agreement. Now, my lord, I pause here. So, my lord, the defense was don't refer it because this arbitration clause has been invoked once. Already invoked. Therefore, this dispute cannot go to arbitration. Mr. Agarwal submitted that the remedy of arbitration under clause 28 was a one-time measure and it could not be taken recourse to repeatedly, even though the disputes may be different and unconnected to each other. Learned counsel further submitted that the arbitration was an expensive proposition, and even though respondent was liable to bear only half of the expenses, financial burden caused by arbitration in terms of fees, etc., was onerous. Hence, arbitration clause in agreement envisaged one single arbitration for all disputes and not repeated arbitration for different disputes arising between at different times under the same agreement. Gist of respondent's objection is contained in so and so, so and so. Then, my lord, para 6, the plea raised by the respondent voices a real problem. It is unfortunate that arbitration in this country has proved to be highly expensive, time-consuming, etc. Then clause 7, my lord, is set out. 28. The plea of the respondent is based on the words all disputes occurring. Mr. submitted that those two words must be understood to mean all disputes under the agreement that might arise between the parties throughout the period of its substance. However, he had no answer to what would happen to such disputes that might arise in the earlier period of the contract and get barred by limitation till the time comes to refer all disputes to at the conclusion. The words all disputes in clause 28(3) can only mean all disputes that might be in existence when the arbitration clause is invoked and one of the parties to the agreement gives the arbitration notice. In the present form, clause 28 of the agreement cannot be said to be a one-time measure, and it cannot be held that once the arbitration clause is invoked, remedy of arbitration is. So the defense was, you've invoked it once, you cannot invoke it again. He said, no,
it can
it's a subsequent dispute which has arisen. Now, my lord, so my lord, this is a totally, my lord, different situation here. Here, my lord, the first order, my lord, of the, my lord, division bench, my lord, which was, my lord, passed, and, my lord, the second order, my lord, both refer, my lord, everything, my lord, to, my lord, arbitration. Correct. Whatever dispute. So, as on date of both orders, my lord, is what, my lord, has been referred. Correct. So, my lord, it's not a case, my lord, that, my lord, only, my lord, the April order and not, my lord, the May order. My lord, it's, my lord, with the greatest of respect, my lord, cannot, my lord, be, my lord, the correct argument. Now, my lord, my learned friend relied on a Calcutta High Court decision.
Yes.
My lord, which is, my lord, 2017 SCC Online Calcutta 169. My Lord, Justice Mukherjee's judgment, my Lord, paragraph 10. Now, my Lord, here, my Lord, I'll just give your Lordship, my Lord, the facts. My Lord, the railways, my Lord, had, my Lord, obtained supplies, my Lord, from a contractor whose, my Lord, design was supposed to be approved, my Lord, by our RSDO, my Lord, which is, my Lord, the, my Lord, specified agency, my Lord, to check technical specifications. My Lord, the supplies were made, and, my Lord, part of the supplies were found to be defective. So, my Lord, the railways rejected, my Lord, those supplies and said that though they had paid in advance, they wanted a refund. Now, my Lord, the defense, my Lord, which was taken, my Lord, by, my Lord, the supplier was the specification which you are insisting upon and on the basis of which you have rejected were specifications which were introduced by you unilaterally. And therefore, your rejection is bad, and you are also liable to lift whatever else we have manufactured or pay us the value for that. My Lord, the arbitral tribunal held, one, that there was a unilateral modification, and two, my Lord, held, my Lord, dismissed the railways claim for refund and said the supplier had suffered damages because there was a unilateral modification, it could not. Now, my Lord, the railways, my Lord, had actually raised another very important point. It was that there was no modification at all
in the contract
to the specification. There was nothing unilateral.
Correct.
My Lord, what was issued, my Lord, was, my Lord, what is the circular which was issued was, my Lord, what is meant by the specifications, elaborating on it. Now, my Lord, that issue was the crux which had to be decided as to whether there was a modification which was unilateral or there was no modification.
Correct.
Because if there was no modification, then railways, my Lord, would, my Lord, get, my Lord, a refund. And, my Lord, the supplier couldn't claim anything.
Correct. It is within the purview of the contract.
Correct. So, my Lord, that in that context, my Lord, kindly come to, my Lord, paragraph, my Lord, 10. In fact, 8 I should read. I have examined the award. I am able to say that the learned arbitrator has not addressed the correct questions while making and publishing the award. The learned arbitrator has merely held that there was a modification to the contract and that modification was made unilaterally by the railways without the consent of the respondent. The petitioner had already manufactured the goods according to the specification in the purchase order. RDSO had wrongfully rejected the goods on the ground that it did not conform to standard prescribed, was his finding. In my opinion, now this is important, in my opinion, the correct questions were not addressed by the learned arbitrator. The contention of the railways was that there was no difference in the technical. Kindly note that there was no difference in the technical specifications between the original purchase order and the modification advice. The original purchase order specification that stated that the goods had to be manufactured according to the RDC or specification so and so. The modification advice only made a clarification or amplification of the specification.
Correct.
So there was no modification at all. If the brake blocks were manufactured according to the specification, it would also conform to the standard mentioned in the modification advice. Otherwise, according to the railways, how could out of 47,000 items initially supplied, only 19,000 were stated to be defective? If the railways by their modification had introduced an entirely different set of standards, then all goods ought to. Mr. Chatterjee went to the extent that the award shocked the conscience of the, in my opinion, when the learned arbitrator does not address the real dispute or issues between, he's trying to decide something which is not referred, which is when he's not, which is not referred to him, when he does not address the real dispute or issues. Now, my Lord, this case, my Lord, on, my Lord, the facts, my Lord, has no application here. Now, let us see, my Lord, what were the real issues. Now, your Lordship seen, my Lord, the various issues, my Lord, which were framed. Both the consent orders, my Lord, are referred to there, as well as, my Lord, the original contract. Now, my lord, it is not the case that the arbitrator did not address the issue, my lord, of breach of the original contract. Kindly have a look at the award. He addresses it and says this need not be decided because of what I'm deciding in, my lord, issue number 3. Kindly have a look at, my lord, the award once. 1 minute from the note.
No,
Yeah,
Mr.
I've got
Mukherjee,
it.
733 is the issue. What the main contention raised by Mr. Chinoy?
Yes, yes, I've got it, my lord. That 733. I'm just showing your lordships what, my lord, the learned arbitrator, my lord, has, my lord, held. Yeah. My lord, kindly take, my lord, the award once. Just give me a moment, my lord. It's
783 bottom.
no, I'm not. It was in a note here. Where is that order 20? Just find that. Yeah. What is there? What note have you given me here?
That is the note.
This is what we filed.
Yeah. No, we've not filed it.
No,
No note.
kindly just give me a moment, my lord. I seem
Yes,
to
it's no problem. Take your
into the award now. Rakesh, have you done? Seven 33. 783. And it first shows where are the issues? 733, right? 732 are issues. Yeah, yeah, that's what I'm. Lord, kindly come to Millard. Volume 5. Millard 7, Millard 32 and 33, Millard. 732, para 16, Millard. Are Millard the issues? Millard, which are Millard?
Yes, that are the issues.
Yes. Now, Millard, kindly come to whether there was breach of the terms of the contract admittedly executed, and if so, who has actually committed, whether the terms of the first consent order, etc., and whether terms of second consent. Now, Millard, I come to Millard, the page where Mr. Chinoy was, Millard, dragging me. Millard 7.
783.
7. Yes.
That was the crux argument of
Yes.
that.
Now, Millard, kindly come to Millard. $783.
Yes. Paragraph 28.
Yes. Now, my lord, before, my lord, that, my lord, we need to read, my lord, para 26 and para 27. By applying the principles laid down in the above decision, this tribunal holds that the effect of the two consent orders before the Honorable High Court is that the seller, by accepting the advance price over again from the purchaser, and the purchaser by again tendering the advance price, which was earlier returned to it by the seller, both agreed to extend the period of performance with further condition that in the process, if the value of the goods fall in the market and at the same time the seller succeeds in the long run, the purchaser would be bound to compensate the seller for the loss suffered by the seller due to fall of price in the market because of the fact that by the injunction order, the seller was restrained from selling the goods to a third party at the higher market price. Thus, the fact that added amount and security clause were added would not amount in itself to superseding the original contract, as these relate to payment under the original contract and put the promisee in the same position as if the contract had been originally performed. This tribunal further finds that the original agreement was not superseded, but was only sought to be enforced, the manner of performance being different, and consequently section 63 is applicable. So now, my lord, this is the fine. Now, my lord, kindly come. Therefore, the date of performance of the original contract dated so-and-so has been extended by consent of the parties through first consent order dated so-and-so, passed in the first miscellaneous appeal. In the self-same way, the extended date fixed by the first consent order dated so-and-so was further extended by the parties through second consent order dated so-and-so in turn. Therefore, the first two issues framed by this tribunal have lost their significance, and it's not that it was ignored completely. You are aware that these issues are there, but, my lord, the arbitral tribunal, my lord, comes to a finding that therefore the first two issues framed by this tribunal have lost their significance after the passing of the second consent order and need not be decided in this proceeding. In place of those, issue number 3 framed in this proceeding so-and-so, and, my lord, is the real issue to be decided. Now, my lord, this is the finding. Is the real issue to be decided in this proceeding, and issue number 4 would be slightly varied as follows. The issues 5 and 6 would remain the same, and this tribunal will so. So, my lord, aware of these issues, my lord, after arriving at, my lord, findings, discussing, my lord, judgments, my lord, the tribunal has come to, my lord, a finding that the real issue today is the third issue.
Correct.
Which is why 1 and 2 need not be decided, because otherwise I'd return the money. The court said, no, you take back the money, and then it is to be decided, and gives a working mechanism how, my lord, LC is to be opened, how payment is to be made, and how delivery is to be made. And if in the meantime, the seller, my lord, suffers, then, my lord, he is to be compensated.
That is the consequence.
Yes.
But the question is that, see, why the court has referred to the arbitration in terms of the arbitration agreement?
Absolutely.
If in terms of the what the arbitrator has to see with regard to any violation, any breach of the contract of the arbitration clause of the contract. And the first question which the arbitrator has raised, a specific question was raised whether there was a breach of terms and contract dated so and so. And subsequently here it is the tribunal lost its significance after the passing.
Correct, because it identifies what the real issue is.
So whether without deciding whether in the contract the terms of contract are breach or not.
No, my lord, your lordship's right. But, my lord, 63 has been invoked.
Correct.
So, my lord, time for performance has been extended.
63 is invoked whether the within the parameter of the arbitrator without going into the condition.
No, that's what was argued also. That's what was argued also. My lord, at the end of it, my lord, your lordships, my lord, are not sitting in appeal. My lord, yes. Now, my lord, that's where my learned friend is seeking to, my lord. My lord, is really.
That's why. Only
so,
that's why
the question is.
That's why I told Mr. Chino with regard. Once you have raised the question, you stick on that. Subsequently,
Yes.
not.
Yes. Now, my lord. So, my lord, the arbitral tribunal, my lord, says, my lord, that is the real issue.
Okay.
My lord, that, my lord, has to be found to be completely perverse. My lord, that finding.
So only the issue number three has taken.
That's the finding.
Correct.
That is the real issue.
Whether the
arbitrator, my lord, hasn't forgotten about issue 1, hasn't forgotten about issue 2, hasn't forgotten about issue 3, but then says by virtue of the court orders. Do I have
because if then again you kindly come to the page 783 paragraph 28 and read with 733 the issue. If okay, ignore the one accept your argument. Now come to the issue number 4. If we ignore the one, now it can be covered the issue number 4. Whether the breach committed by the party in view of the issue number 1, 2, and 3 would be enable the other party. Then it might be covered for some. But kindly come again, you read this paragraph 28 is the real paragraph 28 in the middle portion.
Yes.
The issue number 4 should be slightly varied as follows.
Yes.
Whether the breach committed by the party in view of the issue number 3 again.
Yes.
So
It's
again,
issue number 3.
It has ignored the issue number 4 and issue number 1.
No, 4 and 5 and 6 are there. 4 has been varied because of, my lord, 3 being treated as a real issue.
Correct. No, 4, 5 and 6 with regard to
Yes.
settlement and the interest.
Yes. So 5 and 6 remain the same. 1 and 2, my lord, they say lost significance because 3 is the real issue.
Okay.
If 3 is the real issue, then 4 needs to be varied
Okay.
to be decided to arrive at a just result.
Okay. Next.
Now, my lord, here, 1 minute. My lord, I had, my lord, submitted before your lordships that, my lord, if, my lord, the arbitral tribunal, my lord, comes to a conclusion that issue number 3 was the real issue, my lord, then, my lord, it has to be, my lord, satisfied that this was completely perverse and shocks the conscience of the court. If that is not the case, my lord, then, my lord, there is no question of interference. And, my lord, here I had submitted, my lord, that, my lord, in any view of the matter, if, my lord, a finding on any one or more of the issues is sufficient for a decision in the matter, and that was the decision here, my lord, there need not be a finding on each separate issue.
Okay.
And that is exactly, my lord, our submission. My lord, even if, my lord, 5 were, my lord, crux issues, but, my lord, on 1 it could get disposed of, my lord, that's good enough.
Correct. That is the settled law.
Yes.
One issue is decided covering all, so need not
No,
to
it doesn't have to cover all. It decides the case.
That's why.
Because, my lord, what happened here, which is very important, my lord, they obtained an injunction on the basis of a specific performance claim. That was continued because specific performance was to be pursued.
Subsequently,
then what do? They file a 17 and then they file a statement of claim only claiming damages.
correct. That you are going. That
Yes,
you have
so, my
taken
lord,
note of.
there, my lord, in fact, my lord, if that is the case, so, my lord, I had, my lord, cited, my lord, Order 20, Rule 5, Order 14, Rule 2, and, my lord, the Supreme Court and, my lord, the Delhi High Court cases,
Yes.
my lord, which your lordships had.
That I have taken.
So, my lord, here, my lord, it's not that the arbitrator, my lord, has, my lord, forgotten, my lord, to decide something. No, he's aware of it. But he's saying the real issue today, my lord, because of what has happened, because of the orders of the division bench,
Yeah.
and which says all these issues. So, my lord, whatever's happened in April, whatever's happened in, my lord, May, my lord, will be decided by the arbitral tribunal.
Yes.
And, my lord, the protection is given to me, my lord, by, my lord, the guarantee.
Okay.
The protection, my lord, is given to me. Then, my lord, the next, my lord, point, my lord, which my learned friend argued, my lord, was what was decided was damages as on June, but what was given was, my lord, as on the date of the interim order. Now, my lord, kindly come back to the award, my lord. My lord, paragraph. My lord, paragraph 54 onwards, I want to show your lordships. At page, my lord, 816.
Yes.
After taking into consideration the materials on record showing the admitted rate of goods in question as would appear from the uncontroverted documents marked as so-and-so, as also the consent order so-and-so, the respondent has been able to successfully establish the following facts. Kindly see, my lord. the market price of the goods in question on April 25 was so and so, and the respondent is, so what have I been able to establish? Entitled to get damages for being unable to sell the goods at what? At such price due to the order of injunction against it on the representation of the claimant that it would purchase the goods at the contractual rate. Then, my lord, B, the contract price of the goods being so and so, and the fact that the respondent could have sold the goods even at the rate of so and so, it was therefore entitled to the difference being so and so. Consequently, it would receive an additional amount of so and so. So there's a clear finding on this as well. Now, my lord, kindly come to my lord E. I want to show your lordship E, my lord. As would appear from documents marked as JJ to the market price on so and so, respondent is accordingly entitled to difference between market price of goods on so and so and contract price. So, my lord, there are, my lord, A, B, and E. My lord, which, my lord, arbitral tribunal's finding is I'm entitled to 5.6 crores as well as 21 lakhs so and so.
Correct.
Then, my lord, Mr. Chaudhary's submissions are noted, my lord, in para 55. Then, my lord, the submission, my lord, Mr. Chaudhary, learned counsel appearing on behalf of the claimant, has said that contended that even if it is assumed for that the termination of was illegal, in that event, respondent would be entitled to no damages because market price was also higher than the contract and as such no loss. While making the Mr. Chaudhary treated date of breach as date when goods were to be delivered, but not delivered by the respondent. So in support, my lord, cases, my lord, are considered. Now, my lord, kindly come to, my lord, para 56. Similarly, the provisions contained in section 57, etc. There is no quarrel with the above provision laid down by the Supreme Court that ordinarily the above principle, but every case has some distinguishing features when the general proposition of law cannot be applied. In the present proceeding, in the opinion of this tribunal, the following conduct of the claimant should stand in the way of the claimant to avail of the benefit of general law mentioned above in the way suggested by Mr. Chaudhary. This is addressing the entire issue.
Yes.
This tribunal has already held in para 26 that the effect of the two consent orders before the Honorable High Court is the seller by accepting the advance price over again from the purchaser and the purchaser by again tendering which was earlier returned to it, both agreed to extend the period of performance with further condition that in the process, if the value of the goods falls in and at the same time seller purchaser would be bound to, etc., etc. And my lord, that passage I quoted, my lord, goes up to my lord, section 63. Then, my lord, it talks of the conduct, my lord, which I had placed. I'm not troubling your lordship, my lord. Subclause B, subclause C. C is important. Curiously, when the suit for specific was permanently stayed, asking the parties to buyer in its state instead of paying for specific performance, restricted its prey to damages by terminating by its written notice through email, alleging violation of consent order at the instance of the seller. In this written notes of argument, so and so. Then, my lord, in the opinion of this tribunal, the claimant being fully conscious that on consent the respondent was restrained, it could not before that date terminate when the price of goods was falling in the market. Therefore, contention that claimant could not have expected to wait indefinitely, etc. Now, my lord, kindly come to, my lord, clause, my lord, D at page 824, which is the most, my lord, important. This tribunal, I'm sorry.
Yes.
This tribunal now on merit having found that the buyer itself is guilty of non-compliance of the second consent order, it is the duty of this tribunal to restore to the seller the loss suffered by it for the order of injunction imposed against it. That's 25th April.
Yes.
Then, my lord, now settled litigant cannot take benefit of interim order after having lost on merit, and benefit must be restored to the other party. So, my lord, 5.6, my lord, is also dealt with here. As also, my lord, is, my lord, the, my lord, 21 lakhs. And, my lord, para 58, my lord, even for, it's not, my lord, 21, my lord, is, my lord, the quotation from the judgment relied on by the learned judge. In view of the appellants are entitled purely on equitable ground without going into any other legal issue, and appeals deserve to be allowed in seniority list. Then, my lord, on this basis, also, my lord, the claim, my lord, which was introduced by way of amendment, my lord, was, my lord, found to be, my lord, justified. But my lord, when granting it, my lord, the arbitral tribunal did not grant that, but only gave my lord 5.6, which was also my lord the date of my lord the order being unable to sell, which we had established. That is also found established. In fact, my lord, if my lord, my amendment was being my lord ignored, and my lord, if I had my lord not withdrawn it and it had not been granted, I could have complained that even that should have been given to me.
You have not filed any.
No, I haven't, because I withdrew that claim, my lord.
Yes.
So, my lord, those are my submissions, my lord. And my lord, one judgment I wanted to give, my lord, I had given my lord a scope of my lord section 34, my lord, the latest judgment of the Supreme Court, my lord, on 27th of September 2024. It's 2024 SCC online SC 2632. Yeah, of course. My lord, all the cases, my lord, have been considered.
Yes.
My lord, para 20, my lord, kindly have a look. Conclusion: in view of the above position and law on the subject, the scope of the intervention of the court in arbitral manner is virtually prohibited, if not absolutely barred, and interference is confined only to the extent provided. Very, my lord, now. And the earlier cases, my lord, I had cited, your lordship has Chenab, I think, my lord. Konkan Railway and Chenab, my lord, I had, my lord, cited. Because here, my lord, it's been sought to be argued, my lord, as a really, my lord, the greatest of respect, as an appeal, my lord, from, my lord, the award. My lord, that, my lord, is not the.
Yes. Thank you.
Obliged.
We will file a note of submission.
Both
within, say, a week.
Both the parties.
Only on what we've said. No new judgments.
No new
points.
judgment, no new
Only
points, only the alter argument.
A week, okay, fine.
Week, okay. Sure.
Yeah.
So and so appearing for the petitioner, so and so appearing for the respondent. Hearing concluded. The parties are directed to file their written notes of argument by 10 days, 1 week.
But 10 days is even
10
better.
days, 10 days better, we'll get
That's
another
why.
week.
If it's possible.
Within 10 days, list the matter on, today we are on 10th of December 2024 under the heading to be mentioned for filing written notes of argument.
Greatly obliged.
Obliged.
Thank you.
for the plaintiff, my lord. My lord, we were tendering evidence, my lord.
Yes.
My lord, a small point on which my lord had asked me to check the law as well. I had tendered or I had filed an affidavit under Section 65B of the Evidence Act, my lord. My lord, it said that because of the Adhiniyam coming into force, that
Is your client in court?
yes.
My lord, if a submission is being made, perhaps the witness may step out of the courtroom.
No, only this affidavit, not with regard to the evidence.
Certainly. So, my lord, I am tendering the 65P. My lord, I'm relying on the repeal and savings provision of the
What
the
65?
Adhiniyam, my lord.
I am not aware of any such affidavit. Nothing's been served upon us.
My lord, we had served the affidavit of evidence. I'm serving the affidavit under Section 65B.
No, you can't. My lord, I can't be surprised with these documents like
No,
this.
on the last occasion he wanted to file. This court has raised one objection after the coming into force of this Bharati Sakshi Adhiniyam. If the after the Bharat Sakshi Adhiniyam, whether the 65B will available or 63 of the Bharati Sakshi Adhiniyam.
Fair enough. But my lord, if whatever they wish to file, my lord, I should be given a copy.
I'm giving you a copy immediately.
Because this is the 65B, that is nothing to do. Only he has to prove the electronic document.
No, but then I can obviously cross-examine the witness.
Certainly, certainly.
The court has not taken on record still.
My lord, if I may indicate, Section 170 of the Bharatiya Saksha Adhiniyam. My lord has it.
Page? Section?
Section 170, the last section, my lord. ये section पहले दिखा रहे
170.
The Indian Evidence Act 1 of 1872 is hereby repealed.
Correct.
Notwithstanding such repeal, if immediately before the date on which this adhiniyam comes into force, there is any application, trial, inquiry, investigation, proceeding or appeal pending, then such application, trial, investigation, proceeding or appeal shall be dealt with under the provisions of the Indian Evidence Act as in force immediately before such commencement, as if this adhiniyam had not come into force. My lord, what I submit, my lord, is that when this suit was instituted, my lord, the Evidence Act was in place. The plaint had been drafted basis how it was appreciated the facts would stand proved under the Evidence Act.
Correct.
So, my lord, this is very much a proceeding that was instituted prior to the commencement of the adhiniyam.
Okay.
So therefore, my lord, it is my submission, my lord, that Section 65B, my lord, affidavit can be validly submitted, my lord.
Okay, give the copy to him.
My
Give the copy to him.
lord, I have served the copy.
Yes.
So, my lord, now
Witness is
may I...
present? Witness is present?
Yes, my lord. The witness is present, my lord.
Yes, start.
Also, my lord, may kindly note, on the previous occasion, exhibits A, B, and C had been marked. Because I did not have exhibit D with me at that very moment, my lord, I had sought deferment of the cross-examination. However, in respect of exhibit E, I had shown the documents to the witness and the witness had given statements on it. So I am going back to exhibit D. Let it be marked. Then we'll come back to exhibit E, my lord.
D, what D? Subject to objection.
No, I have not tendered D yet.
Where is D?
Wait. All right, gives me.
Only on that day, 3 documents were exhibited.
Yes, my lord.
What is the last evidence? I'm going to give the last evidence.
Question 50, checks, my lord, checks had been tendered.
Checks had been tendered, my lord, but the checks hadn't been marked. Because, my lord, that would have become exhibit E as per my affidavit of evidence. So, my lord, it said that you get all the documents and do it in the correct order.
C is the check.
Yes.
No. C is the e-way bill.
But it is already exhibited.
C has been exhibited. My lord.
Correct. Checks have been exhibited.
Checks have not been exhibited.
Yes, 3 checks are tendered and marked as Exhibit C collectively.
Oh, my lord. I apologize then.
It is marked as exhibit.
Exhibit C, my lord.
C.
Question 50.
Question 50.
Then the checks are marked, my lord.
Yes. Now you proceed further.
Certainly. I am showing you two documents.
Oath. Witness is on oath. Yes, sir.
I am showing you two documents appearing as PD4 collectively in the judge's brief of documents. Can you tell this court what are these documents?
These are the test certificates of the materials which are supplied to the client.
They're supplied to the clients. What document? What are you showing about?
PD4.
I'm showing as incorrect certificate. Look up your name in the deposition. It's louder.
PD4 and PD5. Only
PD4 of the judge's documents.
One document.
Two documents, my lord. Pages 5 and 6.
That's a 5.
Oh, PD4 and PD5. I
That's
apologize,
a-
my lord.
The Gupta, examination in chief.
Because he's the senior one.
Tell the court. Tell the court.
Okay. Wait, I'll correct that after. Let me finish.
My friend must get his due share, even though he's doing the examination in chief. His senior's name is going in as the lawyer who's conducting the chief. Not he must get his due recognition.
Yeah.
My lord, I'm immensely grateful to my learned senior who happens to only be opposite.
Yes.
So,
Problem is that you persons are conducting. One is appearing. But giving the cheat, you are giving the 10 persons.
and we're giving the senior's name first.
Senior's name first.
That ought not to be done, Malad. The arguing
can be done?
counsel's name comes first.
But what can be done?
Senior could be sitting quietly in the corner. His name should come second.
No, but it is the practice going on here.
Okay. PD4 or PD5 দেখিয়েছিলাম।
After the
শুধু
proceeding,
PD4
Malad,
না,
it can be
PD4 and PD5.
after the proceeding, it may be corrected.
Thank you. Are these the originals of the document?
No, these are the Xerox copy of the documents.
Leading question. Malad. Asking Malad if it's an original or not is a leading question.
No leading question. Let it be. Xerox.
I'm not hinting the answer to him. In fact, he's answered in the negative.
I have no written statement in the matter, so I'm going to take every point possible.
Certainly, I will always.
The court is here if the leading question will be there. Yes.
So one can see that this is a Xerox copy. It's not the original.
Where are the originals?
The originals have been given to the client along with the materials.
Why were the originals given to the client?
The material has got a special specification and the test certificates are issued by Steel Authority of India Limited, and the original goes to the client for his clarification.
I see two stamped endorsements.
Yes.
In these Xerox copies.
Yes.
Which page are you? 5 and 6. Could you tell the court what are these stamped endorsements?
This is a stamp in which the name of the client, the material, the bill number, and the date is given along with the certificate, so the certificates are not misused with other products.
So the certificates are not misused with other products.
Who made these endorsements?
I made this endorsement.
Were the originals of this test certificate handed over to the client?
Yes.
Already it has come.
Good. My lord, I seek that these two documents be marked as Exhibit D collectively.
But subject to objection.
Why?
Not proved. Malad, if I in detail explain, my lord, he'll try and cover it up. So kindly, I'll argue it later. Subject to objection, my lord will decide.
With objection. Exhibit D. Exhibit D, subject to objection as the documents are Xerox.
And not prove.
Not prove you, that is argument.
And the test here, very well. And the test laid down, not met. Very well.
That is the argument.
Yes,
it is proven. Because I find in the original side, it is very easy to lead the evidence. If you go to the district judiciary and evidence, each and document has to be proved through the witness.
Yes, my lord. Yes.
Look, the majority of the statements proving the document, we tend to place in the affidavit of evidence.
No, the affidavit of document, affidavit of evidence with regard to the facts and what the document you relied upon. That's all. With regard to only by marking the document as exhibit will not say that document is proved. Document is to be proved as a whole.
Certainly, certainly.
So for the provement of the document, there are procedures.
Certainly.
How the document is to be proved.
Marking an exhibit means the court will consider it.
Court consider. It is judicial notice. But at the time of argument, both the party can argue whether it can be taken as a evidence or not.
Lord, on SCC online, there is an article written by the son of the former Chief Justice, Mr. Chandrachud Jr. on this point. It's so clear, and it just anyone reads, it will clarify basic concepts.
That's why I'm facing here. Here, you all persons. Plaintiff comes, all document exhibited, close. That is not the if this document, suppose this document, now it is Xerox, how it is to be proved?
Yes. Yes.
I will not disclose how it is to be proved.
Certainly.
Neither can I now get into that discussion.
Okay.
Again, I've contemplated this as well under Section 65.
Next.
I am showing you three documents appearing as PD9, PD10, and PD11 in the judge's brief of documents, being page numbers 10, TO, 15 of the judge's brief of documents. Would you tell the court what are these documents?
These are the check written or check dishonored advice which has been issued by the bank along with the dishonored checks.
Yes.
Who retrieved these documents?
These documents were sent to us by the bank. Sent to us by the bank.
Exhibit C টা দেখান একবার। Exhibit C.
C, that is D.
না চেক গুলো তিনটে চেক। তিনটে চেক আছে তো?
Yes.
Kindly tell the Honorable Court whether these dishonor reports pertain to or relate to any of these checks that have been shown to you.
Yes, all the three documents are related to the checks, and the check numbers are also given in the document.
Checks and the check numbers are given to the documents.
Given in the document.
Lordship, I seek that these be marked as Exhibit E.
collectively.
Collectively.
The only original?
Originals, my lord.
Subject to objection.
What objection?
I will argue later, my lord. Kindly give me some. I'll argue it later, my lord.
No.
My lord,
The bankers evidence.
no, my lord, contents have to be verified. My lord.
See, this is a check on dishonor.
No, but it's, my lord, it's where the original.
Dishonor of check.
Originally तो tender कर रहे हैं.
Oh.
Xerox ने tender.
Dishonor notice.
Original being tendered.
Original is tendered.
Exhibit D টা আরেকবার দেখানো মানে ওই যে টেস্ট সার্টিফিকেট গুলো
Yes.
You have stated in your previous answer that you made these stamped endorsements.
Yeah. Yes.
After the making of these stamped endorsements, did you have these documents photocopied?
Yes.
Are these documents which are in front of you those photocopies?
Yes.
Lord, he's leading the witness one after the other. Every answer is a yes or a no. I mean,
My lord, if I'm not hinting at the answer, he can very well say, if I hint at the answer, that's a leading question.
He's fully a leading.
You could have been put the question another way, sir.
I understand my friend may not have done.
My lord,
as
it
much.
is the first time. I
Fair
apologize.
enough, but anyway,
The question some other way.
If I rephrase the question,
I wouldn't have been as stringent if I had a written statement. Here, I don't have a written statement.
certainly,
So
certainly.
I will take every.
I appreciate where he's coming from. Certainly. I rephrase the question.
Question.
What are the question? What is the question? No.
Leading question.
No. Put some other way.
Certainly.
Is the question going in with my objection? Oh, your lordship
I am
is
not taking.
Yeah, he's not taking. Lordship is not taking. Certainly.
So these these scanned copies have been mailed to the client also.
Yes.
Along with the
What is the
scanned copy
question?
of the
Let the
bill.
question fall.
Let the question
No,
come.
I'm just clarifying.
Yes, question come.
Did you retain any photocopies of such document?
Let me ask what version of the document is this?
No. I'm asking him
and
because
then he'll answer.
Okay.
No, my lord.
I am putting. You told that the original has gone to the client.
Yes, sir.
How this photocopy is with you?
Before sending the original to the clients, we have.
How the photocopies is with you?
I asked him if he had photocopied it. He answered he has photocopied.
How the photocopies is with you?
Because when we purchased the material from the company, Steel Authority, they gave us only one copy of the test certificate.
Correct. Test certificate
And then
only
we
one
make
original will
several
come.
photocopies of the same and give it to several parties.
Okay.
To several parties.
Yes.
Suppose, can I explain?
Yes.
Suppose I purchase 20 tons of material. So I get a single copy of the test certificate. I might have sold to his party 10 tons, 5 tons to some other party. So I have to issue another 5 to some other. I have to issue the test certificate with the endorsement to all the parties.
Okay.
Along with the sale bill number and the date of dispatch.
Sale bill number
And the date. Okay.
My lord, my question simply at this juncture is this. After making the stamped endorsement, did he make a photocopy? Yes.
No, he is telling correct. He is telling that the certificate, the authority has issued the one original certificate.
Certainly.
If it is a 10,000 metric ton of the goods and they are issuing only one certificate, and it is not that they are giving the 10,000 metric ton to one of the party. That 10,000 materials have been issued to the several parties. So he is telling that original they are taking the Xerox copy, and whenever the material is sent, they are giving the one copy to them and keeping the one copy to with. That is
that much. I just want to ensure that much has gone down.
that has come. What he stated. क्या वही बोला है तो?
From the company still already they gave us one copy of the test certificate and then make several photocopies of the same and gave it to the several parties. Suppose I purchased 20 tons of materials, so I got a single copy of the test certificate. I might have sold 5 tons of 5 tons to some other party. So I have to issue another 5 tons to some other, and I have to issue the test certificate. That the endorsement to all the parties along with the sale bill number and the date.
Number the date. Yes.
But the last part that I want is he retains a photostat copy of the stamped original.
You can't say what your witness wants. What's wrong with you?
I still have a
Certainly not.
photocopy in my office for my reference.
Correct.
Look.
You have, prior to that, Exhibit E, you have referred page number 10 to 15. 10 to 15.
Of the judge's brief. 10 to
15 you have referred, PD 9.
PD 9, 10 and 11.
11.
10 to
Correct.
15, my lord.
But only 3 documents you have given to the witness.
The dishonor reports, my lord.
Ah.
These are the dishonor reports.
But you have referred 3. You have
59?
referred page number 10 to 13. Page 10 to 15. Correct. Only report is page number 10.
Page number 12.
Page number 12 and page number 14. What about the other 3
My
documents?
lord, these are the counterfoils, my lord, that we are not tendering. They have come in.
So why you mentioned there?
So then should I say page number 10, page number 12 and page number 14 alone only? Grateful, your lordship.
ऊपर जो बोला है ना 10 to 15, not only 10, page 10, PD 9, page 10. Exhibit E जो exhibit हुआ उससे पहले. Page
number 10 to 15.
No, 10, 12 and 14. Yes.
Yes, sir.
I am showing you a document marked as PD 12 in the judge's brief of documents at pages 16 and 17 of the judge's brief of document. Kindly tell the court, what is this document?
This document is the notice which was sent to Surya Electricals and Engineers Private Limited.
Surya Electricals and Engineers Private Limited.
Mr. Sanjay Memani, the director of the same company.
Mimani, the director of the same company.
And Mrs. Surekha Memani, again the director of the same company.
Rekha Mimani. M-I-M-A-N-I. Mimani.
By my advocate.
By my advocate.
On which date was it sent?
It was sent on, it was made on 11th of October 2022.
This document was sent by Mr. Amit Sharma, advocate. Who is Mr. Amit Sharma, advocate?
Amit Sharma is again one of my learned advocates. And it was sent under my instruction.
My lord, I'm not being very strict, but he can't say things like this person has sent it. My lord, this is my lord.
Who has sent?
Who has sent this?
Mr. Amit Sharma has sent this.
Who is Mr. Amit Sharma?
He is my advocate.
I know. This is my first time.
Even mine.
I apologize, my lord. Who is Mr. Amit Sharma?
Amit Sharma is the learned advocate.
Under whose instructions was this letter prepared?
This letter was prepared under my instructions.
Kindly come to the second page of this document. What do you find in the bottom left-hand corner?
These are the receipt of the Indian Post
From whom did you get these postal receipts?
These postal receipts were issued by the Indian Post when the courier is or the speed post is sent to someone.
How did you specifically receive this?
This was given to us by Amit Sharma, our advocate.
To what do these postal slips pertain? To what do these postal slips pertain?
These are the I think the slips are the proof that the notice has been sent to the client.
Clients. I think.
Kindly turn the page. I am showing you a document marked as PD 13 in the judge's brief of documents, appearing at page number 18 of the judge's brief of document. Can you tell the court what is this document?
This is the tracking report of the speed post sent to the client, and it is downloaded online by the Department of Posts.
Who downloaded this document?
I downloaded this document.
Where from did you download this document?
The website of Departments of Post, Ministry of Communications, Government of India.
There is a consignment number mentioned.
Yes.
In this document. To what consignment does this number pertain?
This consignment number is the same as in the speed post receipts in page number 2, attached in page number 2.
My lord, kindly marks the tracking report, the postal receipt, as well
You
as.
have not completed the question of your legal notice.
Subject to objection.
You have not completed the.
My lord?
You have not completed the question of the legal notice, how it will be exhibited.
My lord, I don't have a written statement, my lord. If your lordship, my lord, runs a coaching
My lord, I've
class here,
shown that it is.
my lord, I'll have
Lord, I've
nothing
shown
left.
that it has been sent.
Then, okay.
Hmm.
He's not the author.
No, I've asked him under whose instructions was it prepared? Under my instructions, by my advocate, it was
Correct.
prepared.
Then-
My advocate sent it. He has given all of it, my lord.
Then,
My lord,
legal notice dated 11th October 2022 be marked as exhibit.
If, my lord.
Huh? F with objection. Subject to proof.
My lord, I bow down humbly, my lord. As my lord knows, I am doing this for the first time, my lord.
You were from the chamber. Come to the court with ready. How the evidence is to be led. Day before yesterday also, I have given a big lecture to one of the senior advocate here. I was supposed to send the name to the ministry. This is going on. You all persons are not known how the evidence is to be led and coming to the High Court and leading the evidence. Every time the court will not support.
My lord, I
How
humbly
the
bow down,
document
my
will
lord.
go to the you have pointed out section 170 of the Evidence Act, but you have not gone through the other act. How the other portion of the Evidence Act, how the evidence is to be led.
My lord, I apologize very humbly, my lord. My lord,
Once the advocate has been registered as an advocate, there are 3 Brahmastra. CPC, IPC evidence.
my lord.
there was a downloaded document, my lord, electronic document.
That's what I'm telling. No, with regard to the notice also, there is mere on instruction, it will not prove.
Correct.
My lord, may I ask further
Take time,
questions,
you
my
go
lord?
to the senior, take instruction otherwise.
My lord, may I ask further questions?
Yes.
In respect of which matters was this notice issued?
You're going on the wrong. It's better you take time and come back.
Take time. Who is the trial conducting lawyer? Consult, sit with him, take instruction, come how the evidence is to be led.
Going on the wrong path, you take time and come back.
My lord,
Making argument in the High Court is different. Leading evidence is different. Not even a High Court. In every court, leading evidence is very difficult, and you will be in trouble when he will start cross examination.
Certainly, my lord.
Your witness will be in trouble.
Certainly, my lord. My lord kindly defers it then.
Come with them. Take instruction from your senior. Sit with some advocate who is conducting the trial. Then come.
My lord,
Otherwise, you are.
My lord, I apologize very thoroughly, my lord.
I am tempted to help, but I cannot.
This court also cannot.
My lord.
Not. क्या हुआ? नहीं नहीं नेगेटिव नोटिस with objection हुआ ना?
With objection subject to proof.
And what the document need not to prove, you have put several questions on that document.
Lord, I am trying to follow something that I have been taught and I have only seen happening in theory, my lord. As my lord can imagine, as a junior who's been enrolled merely for 2 months, my lord.
रहने दो उसमें क्या देखें जब
2
next time
months.
लाएगा
I've
तो
been
दे
in court
दे.
for 5 years now.
क्या
You're
बोला?
failing in law college.
I was.
I'm seeing my friend in court for 5 years. He says
My lord,
he
with
can-
a tie, my lord. My lord, I enrolled only 1 month ago, my lord.
No, that's correct. 1 month or 2 months, that is not. See, practicing in the court is only the experience. I find now. See, evidence is going on. None of the juniors is sitting here. How the juniors will learn how the evidence is going? Evidence hota, chalo, we'll go back to outside. That is, nobody is sitting in the evidence during the evidence. And evidence, if you have wanted to practice in the original side in the High Court, evidence is must.
Is everything, my lord.
Yes, so and so appearing for the plaintiff, so and so appearing for the defendant. Plaintiff witness is present. Present, examination chief resumed. During the examination, how many today? Exhibit? D to F. We are marked with objection. With objection? No. D to F. We are marked, out of which कौन सा objection में है? D objection नहीं हुआ ना? सब objection में है? कौन सा objection नहीं? Out of which exhibit D and F have been marked with objection. Full stop. Counsel for the plaintiff. Praise for time. Accordingly, examination chief is deferred. List the matter. The commercial matter?
Yes, my lord.
Commercial.
List the matter on क्या टाइम देखो है जनवरी में हाँ 6 January 2 p.m.
My lord, may I request, my lord, that it be some other date apart from 6 January, my lord. I will not be in the country, my lord.
So when you will be back?
My lord, I'm coming back on the 6th of January.
देखो और कब है 6 के बाद 13 January at 2 p.m.
My lord, I'm grateful.
Come ready so that he will start the
My
cross
lord,
examination.
last 2 documents I will come ready. I will finish it off on that day, my lord. My lord.
Grateful. Grateful.
Item number 17 of the commercial case.
Lord, I am for the defendant, Lord, I am for the plaintiff. Lord, here,
Lord,
insofar as
Lord, there are 3 applications, my lord, 2.
Item number?
17.
Yes, my lord, GA 1 and 3, my lord, filed by my learned friend. And my lord, 4 and 5, my lord, are my application, my lord. GA4, my lord, is an application, my lord, for referring the dispute to arbitration, my lord.
Item number 17.
Yes, my lord.
GA4.
Yes, my
What
lord.
is the GA1?
GA1 is
is
injunction
for-
application.
Yes, injunction and security.
Injunction granted? No.
Injunction was granted.
Yes,
That
interim.
interim order was passed. That
Yes.
interim order is subsisting. Yes, it's
Yes,
continuing. It is to expire today.
Okay. Then GA2.
GA2
GA2 is not here.
GA2
is-
वाला
So they leave deep change. Like.
कहाँ निकलना है? कहाँ में? अपोलो में कितना बचे?
we don't have any idea as to what is
GA2 is not here.
Yes.
GA3.
GA3 is by application for judgment on arbitration.
And GA4?
My lord, 4 and 5 are my application, my lord. GA4, my lord, is an application, my lord, for referring the dispute to arbitration.
And 5?
And 5, my lord, a connected application, my lord, for production of agreement, because the original agreement is lying with them.
So pleadings completed?
No, my lord, in respect of 3, my lord, pleadings are completed. My lord,
That
friend
can be
will
heard
file
out. That can be
reply,
heard
my lord, and I will be filing my objection.
What about
my
the
lord,
4?
so, yes, my lord, 4, my lord. My
Insofar
lord,
as 4 is
friend-
concerned, I was to file my opposition. I have served it. My lord, it was delayed by 2 days. That is why I couldn't file.
My lord,
But I'm carrying it. I've served it. My lord, after 2 days of the date of expiry. My lord, they have not filed
my
any.
lord, I'm not
GA4
taking.
you filed affidavit?
Yes, my lord. But
Yes.
may I
And
file
GA5?
GA4 and 5? May I file my
Yes,
affidavit in opposition?
my lord, I'm seeking only my short extension, my lord, to use a reply, my lord, to
GA1?
GA4 and 5, my
For
lord.
GA1, they have chosen not to file any
Yes,
affidavit.
Yes. Short extension, my lord, to use a reply in respect of GA4 and 5, my lord.
So appearing for the defendant. Plaintiff has filed an application being GA Form 1 of 2024, praying for interim order. Full stop. Counsel for the defendant submitted they will not use any affidavit in connection with GA1 of 2024. Full stop. The plaintiff has also filed an application being GA3 of 2024, praying for judgment upon admission, in which the defendant has filed affidavit in opposition.
Opposition,
I'm
yes.
filing my reply.
Yes.
In which the pleadings have been completed. Let the affidavit in reply be kept with the record. Defendant has filed an application being GA Com 4 of 2024, praying for referring the matter to the arbitration. Plaintiff has already filed affidavit in opposition. Defendant prays for time to file affidavit in reply. Let affidavit in reply be filed within a week or 2
Yes, my lord, within a week.
Within a week from date. The defendant has also filed an application being GA5 of 2024, praying for production of original agreement.
Yes.
In which the plaintiff has already filed affidavit.
Yes.
Full stop. The defendant prays for time to file affidavit in reply. Let affidavit in reply be filed within a week from date. List all the matter for hearing. All connected application, that is GA1, GA3, GA4 and GA5 along with CS number CS Com 652 of 2024
2024.
6th January 2025 at 2 p.m. for hearing.
Insofar as the suit is concerned, they have not filed any written statement. I've got the report from the registrar.
Yes, my lord, because my application is there, my lord.
That is
obviously,
not,
my lord.
They
I
could
cannot
have
file
filed a written
WS,
statement taking this point. Kindly makes this suit as an undefended suit.
Counsel for the plaintiff has handed over the report issued by the Deputy Registrar Legal dated 26/11/2024, wherein it reveals that defendants are not filed the written defendant or defendant.
Defendant, sole
Defendant has not filed written statement till 26th of November 2024. Counsel for the plaintiff praying for fixing the matter in the list of undefended suit. Full stop. It is fine from the record that full stop. It is yes. What is the submission? Do not file the written statement.
Well,
Lord, obviously, my lord,
they
the
could have
Section
taken
8
the Section 8 point in their written statement. It is always without prejudice.
Correct.
Always without prejudice.
In view of the above, let CS number CS.com 652 of 2024 be placed in the list of the undefended suit and list the matter on 6th of January 2024.
My lord,
It was
kindly
made clear that the suit will be taken up for hearing after the disposal of all applications.
The interim order is expiring today.
Also
Kindly
for
makes
the
it
plaintiff-
absolute because they have chosen not to file any
For
affidavit.
the plaintiff submit that the interim order granted earlier is going to be expired today and submit that as the defendant has not choose not to file affidavit in opposition, wait for confirmation of the interim order. Yes, what is your instruction?
my learned friend is already enjoying the interim order. Let
That
all
be-
these
that be
applications be
confirmed.
taken up together.
the above?
That be
Yes, let-
confirmed.
Let the interim order granted earlier, which is going to be expired today, is extended till 10th of January 2025 or until further order, whichever is earlier.
Grateful.
At the report be kept.
Grateful.
But I'm also carrying affidavits of service insofar as service of GA 4 and 5 is concerned. But I'm not filing it when it's not required.
They are appearing.
Yes, they are appearing. But they
we have
did not
accepted.
appear quite a few times. That is why all these measures have to be taken.
Yes, next.
Grateful.
Grateful.
I appear on behalf of the plaintiff. Your Lordship uses the last.
Not the only thing, my lord,
Last
my,
order.
the principal sum in regard to the settlement, my lord, we are trying to settle. We have agreed to pay the principal sum by the last week. We need time till the last week of December. You'll pay the
Kindly
pay the
uses your
principal sum.
Lordship's orders, previous orders on
Defendant is ready to pay the principal amount of 22 lakhs 59,000.
Yes, in view of the settlement, we are ready to pay the principal sum.
This is not a.
You are on the date. In the meantime, you will pay. That's why it is.
And your Lordship, this is not the first time. Your Lordship kindly peruses the previous orders. They have taken
Even if
adjournments
they
time
get
and
a
again.
decree here
So
and
I've
now,
always-
they will take probably 2 months to get it drawn up, and that is also there, my lord.
That's why, okay. I will pass an order. Drawn up.
Secure it.
By the drawn up, you pay the amount. They will not. They will file. They will not file the execution.
That my lord, we are undertaking
Think
to
other
pay.
way also.
We are undertaking to pay. Our undertaking is recorded
Lordship has been
by my
kind
lord's
enough to
order.
accommodate them.
Undertaking, it is stated that my client submit that the defendant is ready to pay the principal amount itna on or before 29 November 20.
And your Lordship had fixed it
29
today because they had.
the only thing, my lord, what has happened, my lord, my client, the company does not have properties. My client's personal properties are there in Bihar. He has gone to Bihar. He is negotiating with buyers, and that is taking some time. That is
Lordship-
the only thing.
Lordship, I oppose your Lordship kindly peruses
For
your
which I'm
Lordship's previous orders.
seeking this much indulgence, nothing else, my lord.
Lordship kindly peruses your Lordship's previous orders. 10th of September, they took ground on the time that they will enter into a settlement. They do not even approach my client, your Lordship. Even if there was a bona fide shown that they had approached my client, offered to pay, asked for time to pay, Lordship, nothing, absolutely nothing. Your Lordship, they come to court and ask for time on the ground of settlement, but they don't.
I
And your Lordship
think our
was kind enough
terms are-
not to record their submissions that they are ready and willing to pay and would pay by the next date, just for the convenience of the parties. But your Lordship, on the last occasion, your Lordship was forced to record this in your Lordship's order because on the previous occasions also they have taken time on the ground of settlement. And your Lordship, they prior to vacation, they had said that they'll file it on 15th of November. Yes, your Lordship, I am ready to do the matter. Lordship, they have not even approached my client nor my AOR. Lordship, let them produce any letter or document that they have.
I have to take instructions from my advocate on record, but this is
But
my
on the last occasion you have submitted before this court.
that is there. The only difficulty is that to sell the property, I have to negotiate the price.
Okay, I will dispose of their application. I will dispose of the application. In the meantime, you will sell. You pay the amount. They will not initiate the execution proceeding. That's enough.
Your Lordship,
that,
any letter
probably
they show that they have
this
offered
amount
me.
is without the interest. That is why, but that is the only thing.
But Rohit,
That
if
is
you are
the
not paying the interest, is to be.
But my lord will
You are taking time and again and not again asking the interest will not be awarded.
this is my personal property. This is not even the property of the company. I am showing my.
The court cannot go into that whether it is a personal
Lordship,
property
the
or
case is
company
against the
property.
proprietor. It's a sole proprietorship
Either
concern.
either you fight on merit, either you pay the amount. 2 ways.
Right.
And now you have, before the court, you have submitted that you will pay the amount.
And Lordship was kind enough not to record it on the previous occasion when they had submitted that they'll pay it
Yes,
within
we have-
15th of November. And Lordship, any document to show that they've even offered me something or took time that they are not able to pay.
Could have been
Nothing.
given 10 lakh rupees by that time.
My
The
the-
court
the-
can extend the time. Are you okay? I am fixing Monday. Pay the 10 lakh rupees.
10 lakhs,
Lordship.
10 lakhs. I'm told that by the end of December, the entire money will be.
I am
But
fixing on Tuesday. If you pay the 10 lakh rupees, then I will adjourn the matter. Otherwise, I will pass a prepared order.
Lordship,
the
kindly.
only thing, unless the property is sold,
Lordship, this is for injunction for security, order 38.5 for security. And your Lordship, they have
security
admitted.
interim order is passed, my lord. That
Lordship,
is there.
I will direct to deposit the amount with interest.
With
let it
interest,
be
my lord will
deposited.
kindly not to deposit by the end of December, my lord can direct
With
me.
interest.
With interest, my lord will not do so.
Not both.
But
hot and cold.
otherwise, I
Appreciate. On the one hand, my learned friend is submitting that he does not have the money in his bank account. Your Lordship today has granted an injunction on the operating of the bank account without keeping a sum apart. Today, my learned friend in court is submitting that he does not have that much of money in his bank account. So today, me as the plaintiff is left remediless because he's saying I'll have to dispose of property to pay the sum. So he admittedly does not even have it in his bank account.
it is not my property. It is not even my property.
Then how will he pay me?
That is why I'm seeking some time so that this property can be.
And also, personal assets is a non-issue. Your Lordship, defendant is a sole proprietorship concern. I have not filed a company. I have not filed a case against a company. His personal assets are to be sold.
My lord will kindly give me some time, some breathing space, my lord.
Sense suffering for the plaintiff, sense suffering for the defendant.
But in that case, if my lord is taking up the matter on merits, I'll show my defense.
What defense? What defense you show in the after the order of 26th of November?
26th of November. That is in view of the settlement, my lord.
Correct.
Otherwise, I've pleaded in my affidavit in opposition.
Once you pleaded before the court, you will pay the amount. How you can go again?
And Your Lordship, this is not the first time. Even in their reply to my demand
Once
notice, they
you
have
submitted
stated.
before the court, you will pay the amount. How you can now go to the merit? You are not able to. You are not liable to pay the amount. You have submitted in the court.
That is in view of the settlement between the parties, my lord. Subject to your lordship's.
Your Lordship, may kindly hear me then, because this
Suffering for the plaintiff, suffering for the defendant. The matter was listed on 26th of November 2024, wherein the learned counsel for the defendant, on instruction from his client, submitted before this court that the defendant is ready to pay the principal amount of rupees 22,59,740 and further submitted that if the matter is fixed on 29/11/2024, the defendant will pay the said amount in the meantime. Today, when the matter is taken up for hearing, the learned counsel for the defendant submit that the defendant pays for time for payment of the amount till the month of December 2024. Full stop. Consider the submission made by the counsel for the respective parties. This court finds that time and again the defendant is taking time, though the defendant has admitted with regard to the principal amount. Accordingly, the defendant is directed to deposit the principal amount of rupees 22,59,740 before the registrar of this court. Before the registrar origin site on or before 6th of December 2020.
6th December will not be possible. My lord.
2024.
Kindly, I was humbly seeking for time till the last week of December. I'll be able to deposit it.
Okay, क्या बोला ऊपर last line, last paragraph. Okay. नहीं, okay, हटा दो. Learned counsel for the defendant in open court further submit that if the time is granted till the 23rd of December 2024, the defendant will pay the entire amount. In view of the submission made by the counsel for the defendant, the case is adjourned No, recorded 20 November, 20 December. ऊपर जो 23rd बोला ना, 20 December. List the matter on 23rd of December 2024. It is made clear that by that date, if the defendant failed to pay the said amount to the defendant, the defendant is liable to pay the interest also.
Lordship, may I kindly extend the interim order.
The interim order granted, which was granted earlier, the interim order is extended till 24th of December 2024 or until further order, whichever is earlier. Come, otherwise interest I will put.
Yes, yes. Otherwise consequences has to follow.
ठीक है.
Deep.
Lordship, will your Lordship be pleased to extend the interim order till January because it's the last day, I believe.
Come on then.
Very well,
Because 20th it will be taken automatically.
well,
He has to pay the amount. If the amount is paid, then we'll see to that.
Grateful, Lordship.
19 matter I appear for the petitioner matter. Well, in this matter, on 4th of November, your Lordship has been pleased to pass an interim order.
Huh?
On 4th of November, the interim order was passed. Interim order is expiring today.
So what can be done? Vacating?
No, extension. I am praying for extension.
My lord, I appear for the defendants, my lord. Lordship has passed an interim order with threefold restrictions on my client: not to raise any construction, not to change the nature and character of the suit property, and not to create third-party interest. Now, my lord, originally they had, my lord, their case here is that we have, my lord, defaulted. They had initially filed a suit before the city civil court that got dismissed. From there, an appeal was preferred. In the appeal, as an interim, my lord, occupation charges were directed to be paid. That has been recently modified by division bench presided over by Justice Sen. And we have, my lord, appeal is also disposed of. Nothing survives on that claim for eviction, which was there already, my lord, as a relief in the city civil court suit. And the rent remains 4,000. But anyways, I have to put all this, my lord, by way of an affidavit. I have not preferred any vacating, my lord. Gives me 2 weeks time, my lord, to put in an affidavit, and my lord hears out the application.
Bring all the documents.
Yes, my lord, I shall.
So I am vacating.
No, my lord, you will kindly extend the interim.
Appearing for the plaintiff, appearing for the
My lord, make it 3 weeks, my lord.
And reply within 1 week, my lord. Within 1 week, you shall file the reply.
For the defendant pays for time to file affidavit in opposition. Let affidavit in opposition be filed within 3 weeks, comma, reply, if any, there to be filed within a week thereafter. Full stop. List the matter on commercial matter.
Commercial. Because, my lord,
List the matter on 7th of January 2025. The interim order, which is going to be expired today, is extended till 10th of January 2025.
My lord, kindly keeps the point of maintainability of the suit.
Further order, whichever is earlier. Counsel for the defendant raised the point of maintainability of the suit. The same is kept open.
Taking a cue from what your lordship just now observed, because it's an eviction suit, the property actually has to be used for trade and commerce. My lord, only one thing, my lord, 1 week thereafter takes us to 27th for his reply, which would be during vacation. My lord, gives them time till 3rd, my lord, otherwise filing would be difficult.
Time to file affidavit in reply na? Is extended till 3rd January 2024. This
and my lord, the affidavit of service, my lord.
affidavit till 3rd January 2024.
Grateful, my lord.
This on 7th bola hai na? Affidavit of service we kept with the report. Yes, next.
Lord, I'm appearing for the petitioner. Lord, this matter appeared on Tuesday. Lord, I had filed a new GA application for reimposition of the interim order, which had already expired. Lord, in your lordship directed that the new GA be also placed.
What is the GA number?
GA2, my lord.
Aaya, nahi aaya. Yes, what is the GA? GA2?
Lord, GA number 2, my lord. Lord, if your lordship recalls, my lord, your lordship was pleased to pass an interim order in August.
August 9, 2024.
August 9, 2024. The interim order expired in September 12, 2024.
September 12.
Lord, I had explained.
Sustained for dealing with the account without keeping aside of 13,30,000.
Yes, Lord, now, my lord, this matter appeared on 4.
Affidavit of service. I will serve the copy.
Yes, my lord, will kindly seize. Lord, this application has not been served, but the first.
No, with regard to the.
Yes, my lord, will
plaint
kindly.
And all these things, you have complied with the order.
Yes, my lord, will kindly seize the order dated 4th of October 2024. My lord, on that particular day, the matter appeared, and my lord, we had filed the affidavit of service, which is on record, my lord.
Okay. So,
Lord, now, my lord, the situation is this, my lord, the defendants are not appearing despite service. My lord, this was a transaction where we had, my lord, advanced money with an understanding, and there was a contract by virtue of which they were to supply goods within a period of 4 to 6 weeks from the date of the contract which was issued. My lord, admittedly 10 lakhs received, my lord, payments not made, my lord, payments acknowledged, my lord, the goods not delivered.
Send the copy. Send the copy.
This new GA application will serve and come back, but your lordship will kindly, my lord, considers the interim order.
When it will be, when, how soon you will serve?
But 1 week, because the parties are in Delhi, my lord, so I'll take
Since appearing for the plaintiff, none appears on behalf of the defendant. What about the writ of summons? Writ of summons lodged?
Lord, it is, my lord, it's stuck with the department because of, my lord, some defects which were there.
Why you're not rectifying the defects?
Lord, that's in the process of rectification.
Files are pending in the department. No advocates are going to rectify the defects. I will one day I will call all the suits and it will be dismissed.
I'll indicate it to my advocate on
Leave all the practice, earlier practice. Now, once the interlocutory court, but this is also, remember, this is also a suit court. So many thousands of matters pending in the department, not rectifying the defects. One day it will be listed, the whole day I will sit for that only.
I've
Especially
been
fixed
telling
matter.
them. But we'll take necessary steps, my lord, which
Defendant, full list. The plaintiff has filed an application being GA Com 2 of 2024. Praying for reimposition of the interim order dated 9th August 2024. It is found that the application is not served upon the defendant. Will counsel for the plaintiff prays for a week time so that the plaintiff get an opportunity. Plaintiff may serve the application upon the defendant. Let the matter appear on 10th of December 2020.
Wait.
Under the same heading. Next.
This is my application for judgment on admission. On the last day, the defendant did not appear. Well, Lordship, I prayed for time so that the defendant could file an opposition.
Have you served?
But the copy of the order has not been. I have served the application. The last order.
Occasion, no?
No, last order there was a direction on me to serve. Well, that has been done today morning. Well, that does not count.
So,
Lordship will kindly adjourn the matter so that they can.
so appearing for the plaintiff. None appears on behalf of the defendant. Counsel for the plaintiff prays for time. Accordingly, case adjourned. Let the matter appear on 13th December. Next.
Grateful.
My lord, I appear for the plaintiff petitioner in this matter. This is the matter where lordship had, my lord, initially, my lord, granted us an interim protection. My lord, share sale contract 6 crores and 92 lakhs and odd. Lordship had exercising power under 151 directed them to furnish security.
What has happened to the
My lord, they preferred an appeal from the main order. This appeal was taken up last week. My lord, there is initially the bench felt that some kind of security should be provided. Mr. Bachawat took some time, my lord, to seek instructions. They ultimately did not agree to provide any security, so the matter was heard last week. My lord, an order has been passed by the division bench, my lord, for the purpose of valuing the shares which were the subject matter of the share sale contract, to assess whether those shares can be provided as a security to secure my claim. This is the order which has been passed. My lord, we have really not, my lord, made our submissions on that day. Now, my lord, there are two applications which have come, which are there, my lord, before your lordship. One is GA1, which is the main application. My lord, I just need to point out one fact, my lord. Till date, my lord, possibly there is no direction to use an affidavit in GA1. So, my lord, kindly provides for that. And so far as GA3 is concerned, that is the application which we took out for the purpose of, my lord, seeking orders on the bank to disclose what is the status of the bank account, how much money is lying in the bank account. Now, they have filed an opposition which we have received only yesterday, my lord. In that opposition, they have only said, my lord, I'll show only one page from that opposition. File it.
Yes.
My lord, this application was already considered by your lordship. Your lordship was of view that since an appeal is already pending, therefore your lordship directed us to only disclose whether that specific amount has been maintained or not, and that we have disclosed on in this affidavit that the specific amount on which the injunction was like the amount which we had, that amount has been maintained throughout the injunction period.
My lord, if lordship kindly takes one paragraph from that affidavit, they need to file the opposition, my lord. I don't know whether they
Opposition guy. Yes.
From last night.
My lord, this was received by us last night. Kindly comes to subpara N at page 8, my lord. Page 8 of the affidavit.
72 lakhs.
My lord, kindly see 72,000. My lord, kindly seize the, my lord, averment. We say in compliance with the order of injunction, defendants 1 to 4 have not operated the bank account in Federal Bank. However, as on date of order of injunction, bank account had a balance of a sum of rupees 72,822. Now, my lord, we had sought for kindly now seize my prayer, my lord, once in, my lord, the notice of motion in GA3, my lord.
Yes.
My lord, prayer B kindly sees, my lord, we wanted a direction on the manager and operations head of the Federal Bank to give the following particulars. This is in respect of that bank account which lordship had, my lord, passed an order of, my lord, injunction. My lord, subpara 2 of C is particulars of any other account maintained by respondent numbers 2 to 5 with the Federal Bank CRM. This information in the affidavit, my lord, on a cursory glance, my lord, I don't find, my lord, subject to being corrected by my learned friend. Whether
My
this
lord,
has
if
been
my senior friend is moving the application, then can I seek an adjournment for today because I'm being led by Mr. Shubhashish Sen Gupta and Mr. Ranjan Bachawa. Both of them have not come to court due to some personal difficulty, and they are also aware of it.
When the appeal is
my lord, it's coming up on 2nd of December.
not disposed of.
Not disposed of. That report has been called for, a chartered accountant has been appointed. My lord, in the meantime, if lordship considers this should not, my lord.
Let the appeal come. Let the appeal come.
Injunction order is still today. But the injunction order may be extended, which is still today.
But that is up modified note.
No, it's not touched.
Suffering from the. What about the affidavit? You will file affidavit.
In GA1, let them use an affidavit. my lord.
Yes, my lord, you can give affidavit direction.
Suffering for the plaintiff, suffering for the defendant. Counsel for the defendant prays for time to file affidavit in opposition in connection with GA1 of 2024. Let affidavit in opposition be filed within 2 weeks.
My lord, if 3 weeks
3
can be
weeks,
granted.
comma, reply if any there to be filed within.
My lord, it has to be, my lord, 2 weeks. Otherwise, we, my lord.
2 weeks thereafter. List the matter. List the matter on 10th of January 2025.
The interim order.
Interim order granted earlier is extended till 14th of January 2025 or until further order, whichever is.
My lord, in GA3 kindly permits me to, my lord, extends the time to file reply because they have
GA3.
GA3 is my application seeking directions on
Affidavit.
they filed opposition. We have been served yesterday. Kindly extends the time to put in the reply.
The defendant has filed affidavit in opposition in connection with GA Form 3 of 2024. After serving the copy to the London Counsel for the plaintiff, Counsel for the plaintiff prays for time to file affidavit in reply. Affidavit in reply we filed
2 weeks,
2 weeks. List the matter on.
This can be taken up this side of the occasion.
10. Come with the appellate order, then we'll see.
Very well. If there is any order, substantial order, we'll come and mention.
Otherwise, it will be settled itself.
Very
grateful, madam.
Next.
Lord, item 23, my lord, it is basically settled, my lord, matter.
Settled.
So we need some time to file our
deed of settlement.
Not deed of the MOU which has entered into LOC because the formally one affidavit has to be there. So
Suffering
let
for
it
the
be on the next Friday. So in meantime,
suffering for the defendant.
Yeah, next Friday.
It is submitted that the matter has been settled between the parties and prays for time to file the memorandum of settlement. In view of the submission made by the counsel for the parties, the case is
Lord, there is a memorandum of settlement, But
It
there
is
is a
out of
small
code on
issue,
the
out of
stamp
code
paper.
they have
It
done
is
it.
not in format. Your
However, we have the only amount which we were required to pay, we have paid it. They have given us possession,
Terms of settlement,
except the two
Terms of
shops.
Terms of settlement. Let the matter appear on 6th of December 2020.
Deeply.
Non-commercial.
I appeared for the defendant number 1.
Yes.
I was cross-examining the plaintiff's witness.
Oh, that one. Today it will be completed.
Let's see.
Yes.
Let's see how it goes.
Otherwise, he will say, March come, I have been transferred.
What is your name?
सुदीप कुमार
आप हिंदी में बोलेंगे छोटा करके धीरे धीरे ठीक है
ये कल्याण 345 नहीं है ना? है
Yes.
May I proceed? To exhibit 7/1 and exhibit 7 take to the ওই লাস্ট দিন এরকম একটা এই যে এরকম এই 7 আর 7/1 একসাথেই আছে না 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 পেপার বুকে নেই এই আলাদা করে আগের দিন
Yes, sir.
Yes. Mr. Kumar, would I be correct in saying that the operational loss referred to at exhibit 7/1 are described at Annexure 1 to exhibit 7?
क्या वो सही बोल रहे हैं कि जो ऑपरेशनल लॉस है वो एग्जिबिट 1 of 7 में दर्शाया
Exhibit 7/1.
एनेक्स्चर 1 to the 7 में एग्जिबिट 7 में दर्शाया गया है
इसमें नंबरिंग नहीं रेफरिंग टू ये वाला
No. Annexure 1. That's Annexure 2. Actually, it's wrongly stitched. You come to the next page.
Annexure 1 दिखाइए उसमें.
That's Annexure 2 you're losing.
क्या ये है ऑपरेशनल लॉस एनेक्स्चर 1
हाँ.
Yes.
Okay. Now, would you agree with me that the purpose of the remittance as described in exhibit 7/1 was reimbursement of operational losses as also writing off of bad and doubtful debts of the UK branches of the Central Bank of India 4 7/1 4 into
क्या आप हमसे सहमत होंगे क्या रेमिटेंस का पर्पस जो डिस्क्राइब किया गया है एग्जिबिट 7/1 में
reimbursement was reimbursement of operational losses and writing off
bad and doubtful
Dates.
the UK branches of Central Bank.
Perfect.
Yes.
Yes.
Now, would you also agree with me that the writing of bad and doubtful debts referred to at Exhibit 7/1 is described at Annexure 2 to Exhibit 7?
Annexure 2 Exhibit 7 में क्या ये bad और doubtful debts दिखाया गया है?
हाँ.
Yes.
Now, do you find in the said Exhibit 2 the name of SL Setia liners against entry? Sorry, Exhibit Annexure 2. Annexure 2. Annexure 2 to Exhibit 7. Annexure 2 to the name of SL Setia liners against entry number 12.
Yes.
Yes.
Now, do you find that in Exhibit 7/1, against Exhibit 7/1, in the first page, against entry number 3, the beneficiary is described as, within quote, Bank of India, 16 Finsbury, Finsbury, 16 Finsbury Circus, London, quote close. Whereas in the second page, the beneficiary is described as the Central Bank of India with the same address.
First page में beneficiaries Bank of India 16 Finsbury इसको दिखाया गया है और second page में Central Bank of India और same address को दिखाया गया है. क्या ये सही है?
हाँ.
Yes.
That's a fact. Can you please explain about this difference in description?
क्या आप ये explain कर सकते हैं क्यों ये दो?
ये बैंक ऑफ इंडिया में जो सेंट्रल बैंक की अकाउंट मेंटेन थी उसके डिटेल पे भेजा गया था.
The Central Bank of India account which was
maintained
at Bank of India, it was sent in that account.
That's all. Next. Now, shown second paragraph, Exhibit 7. Second paragraph, Exhibit 7. Can you tell us as to what the bank meant within quote? We have made provisions in these accounts, quote close.
Exhibit 7 में second paragraph में जो लिखा है we have made provisions in these accounts, इसमें बैंक क्या मीन करना चाह रहे हैं आप बोल सकते हैं?
जब भी कोई अकाउंट एनपीए होता है या नॉन परफॉर्मिंग होता है
when account becomes a non performing account,
तो उसके अगेंस्ट में हम लोग प्रोविजन करते हैं.
we raise a provision against that account.
यहाँ पे उसी का जिक्र किया गया है.
This has been mentioned here.
Now, according to you, when was the account pertaining to SL Setia liners as described at entry number 12, Annexure 2, Exhibit 7,
marked as a non-performing asset by the Central Bank of India?
कब इस एसएल सेठिया लाइनर्स के अकाउंट को जो एंट्री नंबर 2 में दिखाया गया है उसे एनपीए घोषणा किया गया था?
12, Annexure 2.
एंट्री नंबर 12 एनेक्सचर 2 में जो दिखाया गया है, कब उसे नॉन परफॉर्मिंग?
एग्जैक्ट डेट याद नहीं है, लेकिन 31 दिसंबर में वो एनपीए था।
I do not remember the exact date, but on 31st December year 1986, it was a not performing account.
So, according to you, if I understand you correctly, by December 31, 1986, the account pertaining to SL Setia Liners was already a non-performing asset with the bank. Am I correct?
Yes.
Now, you have already stated, you have already deposed that Annexure 2, আচ্ছা এগুলো সব রোমান 1 মানে ইয়ে না আই মানে রোমান উইটনেস বলেছে sorry, you have already deposed that Annexure 2 to Exhibit 7 pertains to accounts which were described as being written off in Annexure 7/1. Can you please, sorry, I stand corrected. Exhibit 7/1. Can you please tell my lord as to when the account pertaining to SL Setia Liners was written off?
SL Setia Liners का अकाउंट कब रिटर्न ऑफ किया गया था?
As per the records, provision 31/12/1986 को किया गया था.
As per the records, the account was
provision was made on
written off on 31st December 1986.
Would you be able to tell us the date when it was written off, when the date was written off in this account? ना बोले छे is a provision किया गया था, specific date of being written off.
एग्जैक्ट डेट नहीं बता सकते, लेकिन ऑन एंड आफ्टर 31st December 1986 हुआ.
I cannot tell the exact date, but it is on and after 31st December 1986.
Okay, fine. Yeah. Shown Exhibit 1/19. This is the second additional judge. Shown Exhibit 1/19 being the counter affidavit on behalf of Central Bank of India in SLP number 12758 of 2015. Please consider paragraph 4HH of the affidavit at internal page 15, running page 56. Top. Can you please tell us as to whether the bank's contention, comma, as described in the paragraph under reference, comma, was upheld by the Honorable Supreme Court?
बैंक का जो कंटेंशन है जो इस पैराग्राफ में उल्लेख किया गया,
पैराग्राफ नंबर
HH, only HH.
Interpretation of law.
No, he's
He is saying whether these contents are made, whether it has been held. He would say, I don't know.
whether it was been upheld, but the question of
मच ओवर लीगल मैटर है तो हमारे लॉयर बेटर बता पाएंगे इस बारे में.
Yes, yes, that might be your answer.
हमारे lawyer my lawyer can say that better.
That's the cue.
No, that's not the cue, brother. Interim tomorrow he'll take out a judgment and say what.
It's an exhibited document.
Just shuru. Done. Okay. Kindly shown exhibit shown exhibit 3/2 DD40 page 170 volume 1.
Volume 1.
Exhibit 3/2 DD40.
Sorry, volume 2. Volume 2. Page 173, huh?
Appearing at page 173. Yes, sir.
Kindly consider paragraphs 5, subparagraphs 1, 2, 3, and 4. Do you find that it is stated in this affidavit that within court decrease paragraph 4, page 175, running page 175. Within court, decrees were obtained in both the aforesaid matters. Court closed. According to you, is this statement of fact correct?
क्या आपके मुताबिक ये स्टेटमेंट सही है?
ये लीगल मैटर्स हैं, हमारे लॉयर बता पाएंगे.
हाँ.
ये लीगल मैटर्स हैं तो इस बारे में हम एग्जैक्ट नहीं बता पाएंगे कि क्या है. पूछना क्या चाह रहे हैं.
These are legal matters. I cannot say that. My lawyer can say that better.
So you are not aware as to whether decrees are obtained in the matters against SL Setia and Drumpless Limited.
तो क्या आप ये बोलना चाह रहे हैं कि एसएल सेठिया लाइनर्स लिमिटेड और ड्रम्पलेट्स के अगेंस्ट डिक्री हुआ था या नहीं, आपको पता नहीं है?
I cannot say.
I cannot say.
I cannot say. Is it the contention of the plaintiff that RBI permission for set-off was unnecessary as the bank account of SL Setia Liners Limited was allegedly transferred from London to Bombay?
As RBI permission was not contained.
That RBI permission for set-off was unnecessary.
बोलता था ना तो आरबीआई का परमिशन क्या जरूरी नहीं था मुंबई से लंदन ट्रांसफर करने के लिए?
That's a wrong question.
What was the question?
Question was that no more contention of the plaintiff that RBI given a permission for setup was unnecessary as the bank account of HON'BLE Liners Limited was allegedly transferred from London to Bombay.
सर परमिशन अकाउंट ट्रांसफर के लिए नहीं, वहाँ जो लॉस हुए थे उसको भरने के लिए किया गया था.
Question was that whether the money that was transferred, since it was a foreign account, once it was transferred, so no more permission was required. And the question that was translated was for transfer from
Oh, that I.
whether a permission is required.
Question ta ekbar purun, arekbar question ta purun English.
If the contention of the plaintiff that RBI permission for setup was unnecessary as the bank account of HON'BLE and Liners Limited was allegedly transferred from London to
No, English in English is perfect. I mean, whatever I want.
English is
The
perfect, but the
plaintiff का ये
translation
कहना है कि
I'm sorry, সেটা catch করি.
एसीएल सेठिया लाइनर्स लिमिटेड का जो अकाउंट था वो लंदन से बॉम्बे ट्रांसफर किया गया था, उसके लिए आरबीआई का परमिशन जरूरी नहीं था.
नो अननेसेसरी था, जरूरी नहीं था नहीं बोले. इट वाज अननेसेसरी टू ऑब्टेन परमिशन.
कोई जरूरत ही नहीं था परमिशन का.
सर आरबीआई से 2 बार परमिशन की बात की गई थी, एक स्टार्टिंग में 1985 के राउंड में.
From RBI, for 2 times permission from RBI was sought. For the first time in the year 19.
Second time 1985.
For the first time in the year 1985.
Somewhere around 1985.
Somewhere around the year 1985, and for the second time.
Second time 2006 में आरबीआई की परमिशन की जरूरत नहीं थी. तो आपका क्वेश्चन कौन सा है?
And in the second time in the year 2006, the permission was not necessary.
Was not required. Was not required. And
what is your question?
For 2 times permission from RBI was sought. But somewhere around the year 1980, for the first time somewhere around in the year 1985, and for the second time 2006, the permission was not
required.
For the second time, the permission was not required.
Why was the permission required according to you in the year 1985?
1985 में परमिशन को क्यों जरूरत था? परमिशन का जरूरत क्यों था?
आपके मुताबिक
फॉरेन का अकाउंट था और फेमा रेगुलेशंस के अकॉर्डिंगली परमिशन आरबीआई की लगती थी किसी फॉरेन अकाउंट को.
As it is a foreign account, according to the FEMA.
According
to the FERA Act, permission of RBI is required for any foreign account.
Yes. Would I be correct in saying that Drumpless Limited has nothing to do with your case against RK agencies?
क्या अगर मैं बोलूं कि ड्रम्पलेस लिमिटेड का आपकी केस से कोई लेना देना नहीं है, जो आपने जो केस फाइल किया आरके एजेंसीज के अगेंस्ट उसमें कोई लेना देना नहीं है, क्या ये सही होगा?
I disagree.
I disagree.
Yeah?
Disagree.
I disagree. Oh.
He thought it's
For a split second, I thought.
Taken chance.
So apprehensive.
For a split second, I thought I heard, yes, sahi hai. I couldn't believe my ears. I suggest that the stand of the plaintiff in England was inconsistent or is inconsistent with the stand of the plaintiff before this honorable court as far as the subject fixed deposit is concerned.
I disagree.
Now, would you agree with me that till date, about 15 employees of the plaintiff bank, including you, have deposed in connection with the matters between the plaintiff, ARC agencies, and SL Setia Liners Limited?
I cannot confirm the exact number.
Yes, of course. Now, would you agree with me that most of these affidavits and depositions on behalf of the plaintiff would show that according to the deponents, the plaintiff have held decrees against SL Setia Liners Limited and Ranjit Setia. Do you agree?
क्वेश्चन आस्ते आस्ते बोलूं हिंदी में बोलूं ना
Would you agree with me
क्या आप मुझसे सहमत होंगे
that most of these affidavits and depositions on behalf of the plaintiff,
ज्यादातर एफिडेविट्स और डिपोजिशंस
on behalf of the plaintiff,
प्लेंटिफ के जो एफिडेविट्स और डिपोजिशंस है
would show
ये दर्शाएंगे कि
that according to the deponents,
डिपोनेंट्स के मुताबिक
the plaintiff has held decrees
प्लेंटिफ ने डिक्री लिया है
against SL Liners, SL Setia Liners, and Ranjit Setia.
एसएल सेठिया लाइनर्स और रंजीत सेठिया के खिलाफ
Okay. It's also in cross-examination, but I think my learned friend is
This is
seeking
documentary.
he is seeking the opinion of the witness, which is not
If
whatever
it
is
a
in the
decree,
document.
if it is a decree, it is a decree.
More to do with my counterclaim.
No, what to do?
I
but-
cannot elaborate, my lord, any further. Lordship would kindly allow me this much. I would not ask any.
No comment.
Yes?
No
comment. No comment.
No comment. Good. Do you agree if a contention is made? Would you agree if a contention is made that the plaintiff has held decree against SL Setia Liners Limited or Ranjit Setia?
No comment.
No comment.
No comment.
No comment.
No comment.
No comment. Fair enough. I suggest that the plaintiff never obtained the decree against either SL Setia Liners Limited or Ranjit Setia.
I disagree.
I disagree.
That's very simple.
Matter of record.
वो भी तो matter of record. I suggest that Ranjit Setia neither owned nor controlled either SL Setia Liners Limited or Drumpless Limited.
I disagree.
Have you personally seen any evidence which would show that Ranjit Setia either owned or controlled SL Setia Liners Limited or Drumpless Limited?
क्या आपने कोई एविडेंस देखा है खुद से जिससे ये साबित हो सके कि रंजीत सेठिया ओन या कंट्रोल करते थे सेठिया लाइनर्स लिमिटेड को?
बहुत सारे डॉक्यूमेंट्स हैं फाइल में. बहुत सारे डॉक्यूमेंट्स हैं फाइल में.
There are several
It shows
documents. There are several documents in the file which shows that
Ranjit Singh Setia
that Ranjit Singh Sethia used to
control both the management of
control and own used to control both the managements of
SL Sethia Liners and
Sethia
Drumpless.
Liners Limited and Drumpless Limited.
Totally fine. Which file are you talking about?
कौन से फाइल के बारे में आप बात कर रहे हैं?
ये जो सारे हम लोगों ने कोर्ट में प्रेजेंट किए एग्जिबिट्स हैं और बाकी जो हैं उनके बारे में.
Court exhibit. Okay.
I am talking about all the exhibits which we have filed on, before this court, learned court.
Okay. Now, shown exhibit.
Which file are you talking about?
Shown exhibit. No, page 64. Yes. Exhibit A by 26 being PD 26. Oh, first volume ta din, huh? Hey, first volume. What are you?
Okay. Page number.
दो नंबर
62. 62.
Volume 1. It is spiral bond.
Volume 1 देखा होगा नहीं? Page number?
Page number 62 to 66.
Yes.
Do you find that page 63, running page 63, that it is stated that a date of 31 within quote likhun data 31.12.1985 is stated?
Yeah.
Is mentioned.
वहाँ पे
page 63.
Page 63.
You can take my copy if you want.
Exhibit है वो?
Yes.
Sir, question again.
क्या आप ये डेट देख पा रहे हैं यहाँ पर?
Mentioned है.
हाँ, mentioned.
Yes.
Yes. In what context is this date mentioned?
कौन सी कॉन्टेक्स्ट में ये डेट मेंशन किया गया है?
Account marked for adjustment.
Account marked for adjustment.
So, would I be correct in saying that as on 31/12/1985, the amounts mentioned as balance outstanding was already due?
तो क्या मैं ये समझ सकता हूँ कि 31/12/1985 को जो अमाउंट मेंशन किया गया है आउटस्टैंडिंग था वो?
हाँ.
Would I be also correct if I say that by 31/12/1985, the bank had already made provision for adjustment in this account?
हाँ, पिछले डॉक्यूमेंट में प्रोविजन इसी के बारे में.
No, whatever you say. So your answer?
पिछले डॉक्यूमेंट में जिसमें हम लोगों ने भी बात की थी उसमें प्रोविजन का जिक्र था और ये अकाउंट और ये अमाउंट का जिक्र था.
On the previous document there was a mention of the provision, and in this document there is the mention of the amount.
So do I take it that as the account has been marked for adjustment even as on 31/12/1985, the concerned account was already a non-performing asset in the books of the bank?
तो क्या मैं ये समझ सकता हूँ कि 31/12/1985 को जो ये अकाउंट था वो ऑलरेडी प्रोविजन के लिए था, ऑलरेडी
नॉन परफॉर्मिंग था।
परफॉर्मिंग का। यस।
I take it that KC Setia 1944 Limited is the only guarantor of, or rather was the only guarantor of SL Setia Liners Limited.
केसी सेठिया लाइनर्स लिमिटेड 1944 वाज द ओनली, क्या ये ओनली गारंटर था, एकमात्र गारंटर था एसएल सेठिया लाइनर्स लिमिटेड का?
You can look at the entire document.
आप डॉक्यूमेंट देख के जवाब दीजिए।
नहीं,
नहीं,
इसमें और भी लोगों का है शायद। 7th पॉइंट में लिखा है several reminders were sent to SL Setia Liners
Whatever you
and
want
its
to do.
guarantors.
He said no.
No. That's the only thing.
प्रिंसिपल पार्टीज और भी थे, आईके सेठिया, एसके सेठिया,
There were many other parties like IK Sethia, IK Sethia,
एसके सेठिया,
SK Sethia,
and RS सेठिया।
RS Sethia.
Kindly shown page 66.
Yes. On page 66.
Do you find in the writing against entry number 6 that KC Setia 1944 Limited is stated to have guaranteed the outstandings of SL Setia Liners Limited and none other?
आप ये देख पा रहे हैं?
क्वेश्चन
क्या आप ये एंट्री पेज नंबर 66 में 6 नंबर पॉइंट में क्या आप देख पा रहे हैं कि केसी सेठिया 1944 लिमिटेड केसी सेठिया
guaranteed the outstandings of SL liners and non-owners.
केसी सेठिया लाइनर्स लिमिटेड, केसी सेठिया 1944 लिमिटेड guarantees and none other are guaranteeing outstanding of SL Setia Liners Limited and none other. क्या आप ये देख पा रहे हैं?
यस
Yes.
नीचे लाइन में एक लिखा है मिस्टर आईके सेठिया,
Yes, whatever he says.
मिस्टर आरएस सेठिया।
Yes, it is recorded in the down portion.
In the down portion, it is written that
मिस्टर आईके सेठिया,
Mr. IK Sethia,
मिस्टर आरएस सेठिया
Mr. RS Sethia,
and Mr. SK Sethia
and Mr. SK Sethia
facing bankruptcy
are
guarantors. आगे का लाइन पढ़ा नहीं जा रहा।
Guarantors of
Are guarantors
पढ़ने वाले एलिजिबल नहीं।
eligible.
Then that should also go down, that he says it's illegible. Question? Shouldn't be question mark.
Are guarantors, full stop.
No, my lord, it's not stop. There are other words also. He says it's eligible. I can read at least a part of it, but of course my witness cannot read it. This is an internal document of the bank. They can of course produce it.
Are guarantors
Of KC Setia 1944. Lordship would find that 1944 is there. Anyway.
are guarantors. After that, it is eligible. उसके बाद में क्या लिखा हुआ है, पढ़ सकते हैं नहीं पढ़ सकते, बताइए।
गारंटर्स के बाद क्या लिखा
आफ्टर guarantors what is written?
है 1944 लिखा है, लेकिन उससे पहले क्या है नहीं आ रहा।
There is writing 1944,
1944 limit.
1944, but in between what is written, I cannot say.
Off also. Off.
Off. But is telling that
This Xerox copy is better.
guarantor of. Okay, the argument. No matter. Guarantors question, and he stated that there's one word 1944, but in between I can't say. Yes, next.
Yes.
That's all.
No.
Yes.
Mr. Ghosh told me that he will take only 15 minutes.
Mr. Ghosh has not come. He is now overpowering Mr. Ghosh.
So that is physically possible, but I don't think.
Only will they take denial and something in last occasion. Okay, continue.
Now shown exhibit A33. First additional judges will pay spiral bomb. Wait. Yes. A33 being DD86, page 108.
Yes, sir.
Am I correct in saying that except SL Setia Liners Limited and KC Setia 1944 Limited, the bank had made claim against no other party in this matter?
क्या मैं सही हूँ अगर मैं बोलूँ कि एसएल सेठिया लाइनर्स लिमिटेड और केसी सेठिया 1944 लिमिटेड के अलावा बैंक ने और किसी भी खिलाफ
क्लेम नहीं किया,
किसी के भी खिलाफ कोई क्लेम नहीं किया इस मामले में? क्या ये सही है?
Disagree.
I disagree.
Has the bank ever made any claim against Mr. R.S. Setia or R.S. Setia / Ranjit Setia in connection with the dues of SL Setia 1944 Limited, SL Setia Limited?
क्या बैंक ने कभी भी आरएस सेठिया और रंजीत सेठिया को कोई क्लेम किया है, कि पास कोई क्लेम भेजा है एसएल सेठिया लाइनर्स लिमिटेड के जो ड्यूज है उसके वजह से? उन लोगों से क्या कोई क्लेम किया है बैंक ने?
एसएल सेठिया लाइनर्स के मेन कंट्रोलर आरएल सेठिया ही थे, इसीलिए वो उनको जा ही रहा।
the main controller of SL Setia Liners Limited was Mr.
RS
Setia. Then
ठीक है, उतना ठीक, नहीं
के बाद क्या बोले?
नहीं वो उतना ही ठीक।
That's it. I will take, my lord, one more short date, any short date, not
What further?
Yes, yes, there is something. There is something. Few more, literally few more, but we need to wrap it up. Many.
This is the last witness, only witness. One witness more.
Anuk, no, ওরা তিনটে witness আনবে তো
Offenses and suffering for the plaintiff. Offenses and suffering from the defendant. Plaintiff witness is present.
You are in doubt or
Cross-examination
you will be leaving?
Most probably I will burn down.
due to resumed. Stop. Counsel for the defendant.
এই
Raised for
ছুটির পর
time
করবি তো
to further
না, না,
cross-examine
এটা
the
এক
witness on the next
সেদিন
date.
বলো
According to cases adjourned. Let the matter. Then after vacation.
Yes.
Let the matter appear on.
No, you
and be
can't.
married after before vacation. Any day, any day.
Before vacation, that is not time.
No,
date. Give the date. How much? One day you will completed?
Yes, yes, yes.
January.
দাদা একটা
पीछे देखो आप
সেকেন্ড সপ্তাহে দিন
15 January at 3 p.m.
Winter is only for 1.5 months, Milord. Let us enjoy it. Oblige.
Yes, next.
My lord, I am on
I
behalf
appear for
of
the plaintiff.
respondent. I am being led by Mr. Bagman.
Who?
I am being led by Mr. Bagman.
But I appear for the plaintiff. On the last occasion, Lordship had passed an interim order. We had served the.
You are for the defendant. You are for the plaintiff.
Yes, my lord.
Yes. Today is the first date after the
First day
interim
after
order.
the interim order.
Notice served.
Yes, my lord, it has been served. I appear for-
Yes. What is the submission?
I am being led by Mr. Bag. He'll appear online. He was there in the court in the morning, my lord. But
But if they want to file an opposition to my application, that's all.
my lord, for GA1, we'll file.
File affidavit.
But may I file the affidavit of service?
So and so appearing for the plaintiff. You are appearing for all defendants.
Fully, but defendant number 1, my lord.
1. What about the other defendants? 3 to 4? 2 to 4? Have you noticed served?
Yes, but all of them has been. So, well, defendant number 2 to 4 are the directors of defendant number 1.
Directors of the company. Directors of the company. So, appearing. So and so appearing for the plaintiff. So and so appearing for the defendants. Full stop. Counsel for the plaintiff prays for time. Counsel for the plaintiff has filed affidavit of service. Let the same be kept with the record. Defendants prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks, 3 weeks.
My lord, kindly make it 3 weeks, my
3 weeks, comma, reply if any there to be filed within 2 weeks. Thereafter, release the matter on 7th of January 2025. The interim order granted earlier is extended till 10th of January 2025 or until further order, whichever is earlier. Yes.
Great.
25, Lordship, I appear on behalf of the petitioner.
Mm.
It is my suit, Lordship, by an order dated 18th of October 2024. I was granted an interim order, and fortunately, that interim order is expiring today. Lordship, I have with me the affidavit of service. I'm filing my affidavit of service. Lordship, this is a suit for redemption.
Where is the interim order? By which order interim order was granted?
18th of October 2024. This
During-
was passed during the vacation, Lordship.
Vacation?
Yes, Lordship.
Where is the date?
18th of October, Lordship, I have also annexed the order in my
That's
affidavit.
correct. Where is it? Till today?
No,
No.
Lordship, it says
4 weeks after the reopening.
Reopening.
Let the matter appear after the reopening.
Yes. And interim order also, Lordship, the
Alienating the suit premises for a period of 4 weeks from the date of reopening.
Yes.
So reopening of 4 weeks over. When their court was reopened.
4th November. Then I'm covered, Lordship.
4th November. Yes, then where is affidavit of service?
Affidavit of service, Lordship, I have filed. Lordship would kindly see there's one company who has been made a party. The company
All received.
All received, excepting for respondent number 2, who is a company. And Lordship, I have checked from the MCA. The address, the company is very much active, and the address where we have served is the address where the company is still functioning from. If your Lordship kindly takes my affidavit of service, Lordship, the second track record is of that of the company. The consignment number is ending with 2400. Lordship, towards the bottom, your Lordship would see it is written item returned, addressee left without instructions. So that is the comment, Lordship. But I've checked from the MCA that the company is very much active. Now, Lordship,
It was served to the directors.
It was served to the directors. They have received.
On the same address.
Huh?
On the same address.
No.
Directors' address are different.
Director address is different. Director address is
Malaya apartment.
LR Shoroni. And the company's address is in Kamak Street. Incidentally, the suit premises and the company address is in the same building.
Okay.
So, Lordship, I was praying firstly for extension of the interim order, and secondly, if your Lordship would kindly grant me leave to cause substituted service upon the respondent number 2.
What about the writ of summons?
Writ of summons, I am told it has been issued.
What is the report? It has not come.
It is not with me.
So appearing for the plaintiff, then appears on behalf of the defendants. Plaintiff has filed affidavit of service, wherein it reveals that the notice in connection with GA Com 1 of 2024 was served upon all the defendants except the defendant number 2. Counsel for the plaintiff submitted the defendant number 2 is a company. Defendant number 2 is a company, and in the portal it is showing that still the defendant number 2 is having the company inside address as mentioned in the cost title. But in spite of the same, the notice could not be served and it was written unserved up to the plaintiff. Counsel for the plaintiff prays for substitute service for service of notice upon the defendant number 2. The counsel for the plaintiff further submitted an interim order granted on 18th of October 2024 is going to be expired on 4th of December 2024. Accordingly, she prayed for extension of interim order. Heard the learned counsel for the plaintiff. The interim order granted earlier is extended till 10th of January 2025 or until further order, whichever is earlier. The plaintiff is granted leave to publish to serve notice upon the defendant number 2 by way of substitute service by publishing the notice in the English daily newspaper, the Statesman, and in the daily newspaper Sunmark.
And will file the affidavit of service. And will file the affidavit.
And to file the affidavit of service on the next date fixed.
Much obliged.
Release the matter on 10th of January 2025. Next.
I am appearing on behalf of the defendant in this matter. We have filed an application for extension to file my written statement. I have.
Matter.
Yes, Your Lordship.
How many days delay?
No,
my lord, the 120 days.
120s are not very over. Not yet. The first
You are for
extension.
the defendant, plaintiff.
I'm for the defendant, Your Lordship.
You are for the
A defendant.
sole defendant.
Yes, Your Lordship. Sole
The
defendant.
written statement.
Written statement has not been ready yet, Your Lordship. I am praying for some extension.
120 days going to be over.
Much later, February, Your Lordship.
February.
February 25.
Feb.
So when you will file?
We will file within December, Your Lordship.
You file it, then I will take.
Your Lordship, kindly extend the time.
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. The plaintiff has filed, the defendant has filed the present application being GA Com 3 of 2024, praying for extension of time to file written statement. Counsel for the defendant submitted. The writ of summons was served upon the defendant on 9th of October 2024, and the defendant has entered appearance on 5th of November 2024, but on 5th of November 2022, the counsel for the defendant has approached the learned advocate on record with all the documents to prepare written statement, and the written statement is under preparation. And if the time is granted to file written statement, the defendant will file the written statement within
December, Your Lordship.
2 weeks from date.
Within 8 weeks, Your Lordship. I prayed for some time in my master summons.
Then cost is to be paid.
We have the time, Your Lordship.
What? 30 days. After 30 days, cost. Provisional. Go through the provision.
We have time till February, Your Lordship.
That is 120 days.
120 days.
And then 30 days here and thereafter.
Now, in granted time, the defendant will file the written statement within the outer period of 120 days.
I'm grateful, Lordship.
Considering submission made by the counsel for the defendant, the defendant is granted liberty. The time to file a written statement is extended till 2nd January, till 3rd January 2025.
Grateful, Your Lordship.
The GA Com 3 of 2024 is disposed of.
27, my lord, I appear for the defendant number 1, 2, and 3.
Plaintiff, my lord. Right to file the WS was closed, and thereafter on being made.
Before my learned friend begins, my lord, I want to bring to the notice of the court. My lord, the matter was mentioned by my learned friend, and my lord, no notice was served upon us. And your lordship was pleased to pass an order dated 25th of November 2024, my lord, in a way to, my lord, commence with the evidence. My lord, kindly takes up, my lord, GA5, my lord, order dated September 24, 2024, passed by your lordship.
Page.
My lord, this is the order passed by this court. My lord, this is the order dated September 24, 2024.
Yes.
And this is in respect of GA number 5. Now, my lord,
We had categorically.
may I just finish? Now, my lord, kindly sees, my lord, the order which was recorded. My lord, we had raised a preliminary objection, my lord, with regard to the jurisdiction. Now, my lord, the question of jurisdiction has to be determined at first. So, my lord, there was a direction. My learned friend chose, my lord, to file an opposition. But as on date, my lord, we haven't received any opposition. I do not know, my lord, whether he wants to file an opposition or not. If he doesn't, my lord, I am ready to proceed with my GA5. So, subject to, my lord, whatever he says, my lord, I will not stand in the way, my lord, if he seeks for time. But since...
Now, my lord, should I say, my lord?
That's all?
Yes, my lord.
Yes.
My lord, so far, first of all, my lord, GA5 is concerned, my lord. It is when the matter appeared in Lordship's list, my lord, and the matter was taken up, but we had categorically mentioned, Lordship, that is now on virtual recording, that about GA5. GA5 was not there in the list on that date. It had categorically fell from your lordship. That is not here. No order need be passed, because our categoric submission was GA5 had already been infructuous for the reason that in both the parties, defendant, the chance of written statement was closed owing to the statutory period that is coming in. Thereafter, my lord, lordship, after considering all the aspects, may directed the matter to appear as undefended sometime in January, my lord. Now, my lord, kindly, if your lordship sees, they have raised the issue relating to jurisdiction. I have gone through the application, my lord. Jurisdiction itself is a mixed question of fact and law. Lordship, one paragraph seemed to be little funny, my lord, I must say, my lord. Paragraph 14, in the conceptus of the facts as aforesaid, a pure question of law regarding the jurisdiction of this. So, my lord, for the importing the pure question of law, they needed to categorically state some facts. And, my lord, if your lordship kindly go through paragraph 11, 12, 13, lordship, the point of jurisdiction they wanted to platter, my lord, the fact is already ipso facto coming in. It is the question of fact and law both to be gone into for, my lord, considering or even framing of the issue, my lord, even on the jurisdiction. My lord, on the jurisdiction, my lord, but at the end of the day, the issue should be framed, issue should be decided. It is no question, my lord, when there is a point of law that only can be decided as preliminary issue. Moment a fact need be gone into or any issue that goes tangent with the fact, any issue, even on law, goes tangent with the fact, that doesn't remain anymore the issue on law, that to be gone into on the preliminary basis. So, my lord, it is, my lord, in my respectful submit, it is already on the factual score, my lord, that should be gone into, my lord. And, my lord, so far the filing of the affidavit is concerned, my lord, in our respectful submit, if it is false from your lordship, and even yes, if we had taken a deduction for filing affidavit, if it falls from that side, my lord, definitely that we can get it in the record by way of affidavit. But in my respectful submission, my lord, this application has also been infructuous, my lord. So far, it is categorically restricted to the observation, to the prayer and observation on their part, that an order or direction for framing of appropriate issue as to whether the Honorable Court has jurisdiction to try, entertain, determine the instant suit, and the court may be pleased to dispose of the said issue as a preliminary issue at the very threshold. So, these are the language of the code. Order 14, my lordship will find all this language. Those are very meticulously one after another that can be placed for making a prayer. But so far the context of the application, is concerned, whether that goes or if it goes with the fact taking with it. That is, my lord, the crux question here, my lord.
Now what you want?
My lord, according to me, my lord, and my lord, as my lord, Junior says, my lord, that they have not filed any WS, their chance has been closed. But there is no question, my lord, of framing of the issue from their end as per order 14, my lord. So if your lordship, if it falls from your lordship, my lord, I can come with a short affidavit, my lord.
Yes.
Or otherwise, my lord.
My lord, may I just indicate one thing? Lord, whatever my learned friend is saying, my lord, the question of WS not being filed, my lord, your lordship will find from the order, my lord, my WS was closed. Lord, our contention was that it was found within time, but this is the view of the court. But since this is not filed within 120 days, my lord, my right goes. Now, my lord, this right, my lord, is an independent right. Whether the court has jurisdiction or not, my lord, is a question which is preliminary in nature. My lord, if the court is of the view that this court lacks inherent jurisdiction, whether territorial or pecuniary or any other, my lord, then your lordship would.
See, your chance for filing written statement gone. Now you file this application, subject to correction.
No, this was filed much prior than this.
Whatever it may be,
As on the
But this cannot be equated with the WS, my lord.
That's what I'm telling. Let this application be come with the suit. Your right for the cross examination is there. You cross examine
But
the point.
In one matter, lordship has done it with me also.
Correct. But the question, my lord, this has to be, my lord, taken into consideration.
If you cross it, see, this is the correct. You have raised the question of jurisdiction. Correct. Now they are telling that a work order was issued from here. You are telling that the work order was issued from
Those are all, my lord, admitted from records. My lord, nobody cannot improve the records.
That's why if it is not, during cross examination you can cross examine on the document with the
So
plaintiff.
that would only prolong the proceedings, because if your lordship, my lord, on a preliminary issue, if your lordship is prima facie satisfied, that, my lord,
Once you have not your written statement is not on record. Now
Correct.
you filed an application.
Now, my lord,
for
kindly
issue.
appreciates.
Without the written statement, how the issue can come into force?
My lord, kindly appreciates. My lord, let us not go by the nomenclature. If, my lord, there is no written statement and I file an order 7 rule 11.
That can be.
Lord, if this application is treated in that nature,
How it can be treated as a debt?
Because, my lord,
You are not asked for the dismissal of the suit, rejection of the
no, my lord,
claim.
I can understand, my lord, the couching of the prayers is perhaps not correct.
Correct.
But in any moment, my lord, your lordships can, my lord, take it up as a preliminary issue. My lord, that's the only question.
Preliminary issue can be taken if the party you filed the application. You could have been moved the application prior to that when the suit was taken as an undefended suit.
Lord, this application is
And you are
pending
not
for a very long time, my lord. Kindly see the
pending,
last order.
you're not
My lord, the
pressed.
order was passed on 24th of September
But you are not pressed
2024.
the application.
My lord, how can I praise, my lord?
Today
My lord,
the
how can I
application is
praise, my
only
lord?
for
Because,
purpose
Lord,
today,
kindly
now the
appreciate.
today is the suit is at the stage of undefended. If you want, I will take the matter along with the suit. You have a right to cross-examine. You
That right I will always have. But my lord,
clear.
kindly appreciates, my lord,
What is
this order was passed on September 24th. At that point of time, my lord, my right existed. He said, my lord, he is going to file an opposition, which he did not. Thereafter, this GA was never taken up by this court.
Suffering for the plaintiff, and suffering for the defendant. Full stop. Defendant has filed the present application being GA Form 5 of 2024, praying for a direction for framing a preliminary issue with regard to jurisdiction of this court. Jurisdiction of this court to determine the issue raised by the plaintiff. Full stop. Counsel for the plaintiff submit that the defendant has not filed the written statement within the prescribed even after the outer limit of 120 days. Accordingly, this court has closed the opportunity of filing written statement by the defendant, and this court picked the suit as undefended suit for witness action in the month of January 2025. Full stop. Counsel for the defendant submit that the defendant has filed the present application for framing of the preliminary issue. Considering the above, this court find that this application and this court find that though the suit has been placed in the list of the undefended and for witness action, but the cross-examination of the plaintiff witness is not closed. It is with the defendant. He be interested to cross-examine the plaintiff witness at the time of examination of the witness, he can cross-examine. Accordingly, this court is of the view this application can be taken up for hearing along with the suit. Let GA 5 of 2024 be placed along with CS number so for CS 494 of 2024.
Objection.
Next.
Grateful. No, his right to file any objection is closed. That may be recorded because, my lord, if there is something.
It is found that in the month of September 2024, the plaintiff has taken time to file affidavit in opposition, but till today, the plaintiff has filed affidavit in opposition.
In the meantime,
Accordingly, time to file accordingly, chance to file written affidavit in opposition by the plaintiff to the application is closed. Next.
Malad is closing the right, Malad?
Yes. You persons are first arguing the matter on merit, then you are coming to the affidavit in opposition. You could have been arguing.
Yes, that's what I'm saying.
Next.
No, Malad, I had said, Malad.
Okay. Next.
Malad, then, Malad, Lordship, we will argue for the dismissal of this application, Malad. For this application,
I have kept
on that day, Malad, when Malad,
I have kept the along with the suit. Let it cross examination if the
because my chance is getting closed, Lordship. In the meantime, I can use our opposition.
What purpose should be served?
I know, Malad.
You are the senior persons. What purpose should be filing affidavit? That is to be decided.
Yes, Malad, I know. Malad. Sometimes, Malad.
But already date along with the suit.
Lordship, this is my application for extension of time for filing written statement, my lord.
Yes. When you receive the who is the plaintiff?
My lord, on the last occasion, my lord.
When you receive the writ of summons?
Writ of summons was received on 20th September 2024, my lord.
Hmm.
It's stated in my paragraph 4.
So, when the date was?
My lord, the time was given till 17th of October 2024, my lord. It was in between the annual puja vacations, my lord. And thereafter, on the opening day, it had to be filed.
Who has given time?
My lord, in the writ of summons.
Writ of summons, when the writ of summons was served?
20th September
Where it
2024.
is? Where you mention?
My lord, I had mentioned in my paragraph 4, my lord, at page
Paragraph
5.
4.
Paragraph 4, my lord.
20 September 2024.
Yes, your
So
lordship.
30 days has been over on 17th October.
Yeah.
2024.
2024, my lord.
Correct. Your written statement is ready?
Yes, my lord, it's already served, my lord, already served, my lord.
Affirmed.
Affirmed, already served upon
It
the.
was affirmed.
My lord, it was affirmed on, my lord. November, my lord. 8th of November 2024.
8th of
November 2024, my lord.
within 120 days.
Yes, within 120 days, my lord.
How much cost?
I'll be praying for no cost, my lord.
Suffering for the defendant, none appears on behalf of the plaintiff. Defendant has filed an application being GA Com 3 of 2024, praying for extension of time to file return history. Counsel for the defendant submitted. The writ of summons was served upon the defendant. Sole defendant?
No, my lord. There are 7 defendants.
All
my lord.
defendants?
All defendants, my lord. I'm appearing on behalf of all the defendants.
So all it was served on the
Yes,
same day?
yes.
Upon the defendants, huh? All it yes, huh? Counsel for the defendant submitted. Defendants have received this writ of summons on 20th September 2024 and 30 days for filing the written statement expired on 17th of October 2024. Counsel for the plaintiff submits that and defendant submit that as the writ of summons was served during the puja vacation and as such the defendants could not contact the advocate on record and to give proper instruction and the documents so as to enable the advocate on record of the defendant to file written statement. He submits that the written statement has already been drafted and affirmed on
8th of November 2024.
8th of November 2024 and also served upon the counsel for the plaintiff. Considering the submission made by the counsel for the plaintiff, this court find that the defendants file the present application within the outer time of 120 days and has also affirmed the affidavit of the written statement within the outer time of 120 days. Dependents are directed to file their written statement. There is no counter claim?
No, my lord, there is no
File
counter.
their written statement within a week from date,
Sure,
subject to scrutiny by the department. GA number so disposed of. Next.
This is an application where the plaintiff had sought for copyright infringement injunction application. We were in reply. Mr. Thakkar was leading me in this matter. We were to cite certain judgments and distinguish their judgments.
That book, publishing?
The book, yes. The 2 books, the 2 books. But I'll perhaps need much more time than what is required. Now, being 10 minutes left, the end of the day.
So,
but I can
Thakkar is
start.
giving reply. Na?
Yes. Yes,
How much time will take?
I'll take some time, at least half an hour, because 4 points have been argued by us. Really, firstly, that what right survives after the death of the original copyright holder, and thereafter.
Suffering for the plaintiff, suffering for the. Is the parted matter?
Yes,
Yes,
your
Lord,
lordship,
yes.
parted. Lordship would kindly fix a time, if possible. This is
January.
pending. Then your lordship, whenever your lordship fixes it,
January I am fixing it.
grant some precedence to this. Does not fix it in January, grant some precedence to the matter. Since it's pending for over a year, your lordship.
To paucity of time, the hearing could not be, it is not possible for the court to take the matter for hearing today. According the case adjourned, let the matter appear on. Give the date in the month of January, first week. 6 January at 6 January 3 p.m.
6 January 3 p.m. Very well, your lordship.
January 2025 at 3 p.m.
Great.
Great. Yes.
Great.
Number 30.
Lordship, I am appearing for the petitioner. This is my application.
I am for the plaintiff respondent in this matter, my lord.
Milord, it might come back to your lordship, Milord. I had addressed your lordship on the question of recalling of an order passed, Milord, where, Milord, my junior has accepted the written statement. Then I brought it to your lordship's notice that the address was wrong and no writ of summons was at all served. So therefore, I had asked for recalling of that order. I had made my submission. I've completed my arguments. My learned friend was in the process of arguing. Yes, I've completed. On the last occasion, Milord, I am told, though I was not present,
yes,
my lord's desire was that the records were inspected and it was found that the writ of summons was not served.
Yes. Inspection was carried out.
No, no, Milord, your lordship had seen and asked for a report, Milord. না তুমি কি বলতে শুরু করলে না বললে আমি তোমার জাজমেন্টস দেখাবো আপনি বললেন না আমার মিসকমিউনিকেশন
Yes.
Yes, my lord. Well, I'll come. Well, I was under the impression,
They should.
Lordship will kindly shift it, madam.
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. Counsel for the department has submitted the report. Let the same be cut with the record. Counsel for the defendant, counsel for the plaintiff, prays for time. Considering the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear on before vacation.
Any date, madam, your lordship.
Give the. Okay, let the commercial matter.
It's a commercial matter.
Let the matter appear on 20 December 2024.
20th December, ma'am.
20. As parted, huh? Yes, next.
One. Oh, gosh. May I desire that we mark it because I have completed part hard if it could be marked.
Part hard.
My lord, 31, I appear for the petitioner, my lord. On the last occasion, your lordship was pleased to pass an order for filing of affidavit.
इसके बाद ना interim order का. Yes.
My lord, your lordship was
You are appearing for
the petitioner, my lord.
Hmm.
GA6, my lord.
GA6.
Yes, my lord.
What is for?
That is for
GA6 for?
My lord, for judgment upon admission.
Affidavits completed.
My lord, the other side has not given affidavit. My lord, we have written a letter, no reply, no extension has been sought.
Olomi Roy.
My lord, the Abir Das is the advocate on record.
So what can be done? 10 minutes or no? 8 minutes. If you will complete within 8 minutes, then I will take.
No, my lord, next day it can be heard out, my lord. They don't want to file.
So-and-so appearing for the plaintiff. None appears on behalf of the defendant. Plaintiff has filed an application being GA-Com 6 of 2024. Praying for judgment upon admission.
Yes, my lord, judgment upon admission.
By an order dated 23rd of September 2024, this court directed the defendants to file affidavit in opposition within 2 weeks after Puja vacation, but counsel for the plaintiff submitted in spite of the intimation given to the defendant, advocate on record of the defendant on 18/11/2024, no affidavit in opposition is filed. Considering the submission made by the counsel for the defendant, counsel for the plaintiff, let the matter appear on second January 2024 for hearing of GA6 of 2024. Yes. Interim order.
For item number 35, my lord, the plaintiff, my lord, on 8th of November, my lord, interim order was extended. Today, the interim order is expiring, my lord. This
item number
35, my lord. I'm the plaintiff.
Which for the other side?
Your lordship, I appear on behalf of the respondent in item number 35.
GA4, they have filed.
I am for the petitioner in the application and the defendant in the suit.
They have filed GA4 for rejection of the plaint, my lord, on the account that this should not have been filed in the commercial side.
That is the issue, my lord. I have already filed an opposition. They have filed reply yesterday. It is ready for hearing, my lord, to finally
And what
fix the
about
date.
the injunction?
Injunction is expiring today, my lord.
No, what about the pleadings completed?
Yes, my lord, pleadings completed.
Pleadings are complete.
Yes.
So your injunction application.
My injunction application is GA1. They have not filed opposition. Their right to file opposition was closed, my lord. They have
No,
not
no, your
filed.
lordship, it was not closed. We filed in our opposition with respect to the we filed in GA4 after this, your lordship.
My learned friend
Our
is confusing,
affidavits
my
in
lord.
GA4 are complete, your lordship.
No, with regard to GA1, have you filed the affidavit in opposition?
No, your lordship. With GA1, we have not. That right was closed, your lordship. My friend, learned
That
friend
is what I am saying, my lord. Their right is closed.
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. Plaintiff has filed an application being GA-COM 1 of 2023, praying for interim order. Defendant has filed an application being GA-COM 4 of 2024, praying for rejection of plaint. It is submitted that with respect of GA-COM 4 of 2024, pleadings have been completed and ready for hearing. As regard GA1 of 2023, the defendants have failed to file affidavit in opposition, and as such, the plaintiff could not file affidavit in report. Counsel for the plaintiff submit that the interim order granted earlier is going to be expired today and paid for extension of the interim order. In view of the submission made by the counsel for the respective parties, the interim order which is going to be expired today is extended till 7th of January 2025 or until further order. Let the matter continue in the list.
My lord has recorded the GA1 was filed for injunction, my lord. That was filed for judgment upon admission, my lord.
Judgment upon admission.
GA1.
So what is the injunction? Where is the injunction?
Injunction was obtained in the plaint itself, my lord. What I filed because my lord, the amount that was laid down.
Plaint itself then.
In the GA1, yes, in the application itself is with the player, but my lord, the application for judgment upon admission, my lord.
GA1 है ना? Judgment upon admission as well as interim.
Yes, my lord.
Filed an application for GA1 for judgment upon admission and interim order.
You may have, my lords, kind leave to mention item number 39 of my lord's list. I'm mentioning upon notice also. But if your lord, may I hand up the copy of my lord's last order? Your lordship,
I am appearing for the respondent number 6 and 7, your lordship.
Your lordship kindly.
Lordship,
I appear for respondent number 10, lordship.
I am appearing for respondent number 1, 2, 3.
But may I place it? If your
My
lordship.
lord, I am appearing for respondent number 1 and 2.
But if your lordship kindly sees the last paragraph at page 21, paragraph 46, let affidavit in opposition be filed within 2 weeks after puja vacation. Reply, if any, be filed within 2 weeks thereafter. List the matter on 29 November. Interim order granted is extended till 29, which is till today.
Yes.
Now, my lord, none of the defendants complied with this direction. The defendant number 6 and 7 had preferred an appeal. My lord, the kindly sees the order of the Honorable Appeal Court, my lord. 20th November. The order was not interfered with, and kindly turns to my lord page 4 and kindly sees the second paragraph. Insofar as the appellant is concerned, this direction was passed. The appellant shall file affidavit in opposition on or before 22nd November 2024. That has been done. They had filed. Reply thereto, if any, shall be filed on or about 27th of November 2024. We had served them. My lord, may I file that affidavit in reply to the affidavit in opposition of, my lord, defendant number 6 and 7.
May I file the affidavit in opposition also?
Lordship, I am on behalf of respondent number 10. We've served them a copy. We filed our opposition.
Let me make my submissions, Mr.
Okay, sir.
There are several defendants, so separate submissions for each defendants I shall make. So far as the defendant number 6 and 7 is concerned, affidavits are complete as per the appeal court's direction. Now, none of the other defendants had preferred any appeal. So, my lord, your lordship's last order and the last direction, so far as the others are concerned, is there. Now, we have received all the other affidavits, my lord, recently. My lord, one affidavit was served by the defendant numbers 1 to 5 before. My lord, we are ready with the affidavit in reply to the defendant numbers 1 to 5's affidavit in
So 1
opposition.
to 5 this you are appearing for?
6 and 7,
1,
your
2,
lordship.
3 and 1, 2, 3 and 5.
1, 2, 3 and 5.
And 5,
Four,
not 4.
And you are for the 5
6 and 7, your
6 and
lordship.
7. 6 and 7 is complete.
Complete.
For the 1, 2, 3 and 5.
1, 2, 3 and 5. Okay, 6 and 7 here.
Yes.
And you are appearing
My
for
lord,
10.
Yes.
For 10, lordship. For 10.
4.
4 I do not know.
Who is appearing for the 4? Nobody. How many defendants are there?
14.
What about the others?
Yes.
Service.
Now, my lord, no, all served. They used to appear together, but affidavit has been filed by 1, 2, 3, and 5. Now, there are 2 other affidavits which we have received, all in this week. One is by the defendant number 10. The other is by the defendant numbers 11 and 12. Both these affidavits we have received this week. Kindly gives us 2 weeks time to use the affidavits in reply to these 2 affidavits.
Lordship, I am appearing for 6 and 7. I am suffering an interim order. Lordship kindly takes up page 4, para 2 of the learned appeal court's order. If your lordship comes to the end, lordship, we do not, somewhere in the middle, in para 2, your lordship, we do not find any reason to interfere with the order at this stage. However, having regard to the nature of the ad interim order, we would request the learned single judge to decide as to whether the ad interim order should be continued on the date fixed as against the defendant number 6 upon consideration of the pleadings to be filed by the parties in the meantime. Lordship, these reactions of, lordship, if takes up the next para, the appellant shall file the affidavit in opposition on or before 22nd November 2024. Reply thereto, if any, shall be filed on or about 27th November 2024. The said direction as to pleadings is peremptory. Lordship kindly fixes. I am appearing for 6 and 7, your lordship. As regards my clients are concerned, kindly it be taken up next week, your lordship. Lordship, kindly, may I take you to page 3 of the order, your lordship? The second para. Prima facie, it seems that the plaintiff has not disclosed any document to show in writing that the defendant number 6 has assured to supply the required materials to the plaintiff through the defendant number 1. However, there is a pleading of such assurance held out by the defendant number 1 and 6 jointly and severally. In absence of any documents covering the contract period, it needs to be assessed whether the defendant number 6 could be restrained to operate the bank account to the extent of rupees 18 crores. Mere verbal assurance without anything else may not be sufficient to pass a drastic order in the nature of injunction and attachment unless it is supported by nature of dealings, transactions, and conduct. By reason of the order of injunction, the defendant number 6 is unable to operate the bank account. The plaintiff is unable to show exchange of correspondence between the plaintiff and the defendant number 6, by which the defendant number 6 can be held to be responsible for non-supply of the defendant number 1. If the defendant number 1 has received the money, it does not automatically follow that the defendant number 6 would be obliged to supply the materials to the plaintiff through the defendant number 1. Lordship, now, Lordship, I have gone up in appeal. Lordship, these directions have been passed by the Honorable Appeal Court. Lordship kindly takes up the application next week as regards to defendant number 6 and 7. Because we had filed the appeal, we have complied with the directions of the Honorable Appeal Court and filed the pleadings on time.
Your lordship will kindly also see the last page of the order, the last paragraph.
Yes.
We, however, make it clear that in deciding the interlocutory application on merits, the learned single judge shall not be influenced by any observation made in this order.
Observations on merits, your lordship will not be influenced
If
by.
we have filed the affidavit in reply, well, so far as the defendant number 6 is concerned, the pleadings are complete within the dates fixed. I am not standing in the way. But the issue is, well, the involvement of the other defendants as well in the transaction. Now, all the other defendants have flouted my lord's order, and they have not also preferred any appeal. They have served it, one 3 days back, one 5 days back. So,
how soon you file reply?
Kindly gives us 2 weeks time, we shall file, because my client is in. Your lordship's direction is 2 weeks.
Otherwise, I will take the defendant number 6.
Yes, your lordship.
I understand, but your lordship's original direction is 2 weeks.
That's correct. That's correct. But now the appellate court has modified whatever it may be. Now appellant shall file affidavit. It is to be heard.
But others have not assailed that order. Only defendant number 6 has.
That's why I'm telling you. With regard to the defendant, then I have to take the defendant number 6 application now.
No, there is no application by them.
Not application, but their contention is because their account has been stopped.
Yes, your lordship.
Without keeping apart a particular amount.
This order,
lordship,
appellate court has some.
Yes, but if they serve us so belatedly, the other defendants, and my client is in Italy, so to get the everything done, we have, your lordship has seen, we have already filed 2 affidavits. It's not that we are deliberately delaying anything. But I am saying to be on the safe side.
But correct. But
kindly gives us 10 days time, my lord.
The page number 4,
I understand.
Second paragraph.
Yes.
Learned single judge to decide as to whether the identity order should be continued on the fixed date.
Yes, your lord.
As against the defendant number 6, upon consideration of the pleading to be filed So now the pleading has been completed. With regard to the other defendants who are filing, that is different. They are not challenged. The
I
defendant number
understand.
6 challenge. The
But
court
may I
has-
make one humble submission subject to what falls from your lordship? Would your lordship kindly extend the time till Monday week? That would give us more 8 or 9 days time. On that date, the application can be taken up.
I am not hearing all of you. I will hear only the defendant number
Next
6.
month.
If lordship is hearing defendant number 6 made
So-and-so appearing for the plaintiff. Who is so-and-so appearing for the defendant 1, 2?
1, 2, 3, and 5.
1, 2, 3, and 5.
I'm appearing for defendant number 6 and 7.
Lordship.
Lordship, as
For the defendant number 6 and 7. Who is up?
I
My
am
lord,
for
may
10.
I make one submission, my lord?
7, 8. Anybody is appearing for the 7, 8? No. So-and-so appearing for the defendant number
7 is
7,
6 and 7.
6 and 7.
8 and 9.
Nobody is appearing.
8, 9, nobody.
8, nobody. So-and-so appearing for the defendant number 10. And so-and-so appearing for the defendant number 11.
11 and 12.
11 and 12. Full stop. Yes, what do you want to say?
My lord, I most respectfully submit, my lord, my application under section 45 of the Arbitration Act is fixed on 6th of December, my lord.
That is, my lord, defendant number 1, 2.
ठीक है. In terms of the order passed by the appellate court dated 20th November 2020, with regard to the pleading against the defendant number 6 has been completed.
6 and 7.
6 and 7 has been completed. Full stop. As regard defendant number 1, 3, 1, 2, 3 and 5.
Yeah.
That is also
Completed.
Defendant number 6, defendant number 6 and 7, defendant number 1, 3, 5 and 1, 2, 3 and 5, and these are the completed.
Only these two have
been completed. Defendant number 11 has filed the affidavit in opposition when? You are not filed.
Has not yet filed, person.
Not filed. Anybody
Had
has
served.
filed?
Yeah, they had served on my lord
Their affidavit.
on 25th.
Full stop. Other defendants are not filed affidavit in opposition.
Lordship, we filed and served upon them on last Friday, 22nd, Lordship.
Filed?
Yes, Lordship. It's with my clerk. He's standing
No,
right
my
in.
He's for defendant number
We served
10.
upon them. We served upon them.
Have you filed?
Yes.
It's a yes, sir. Yes, Lordship. Yes, we filed it.
Defendant number 110 has also filed an affidavit in opposition. Full stop. Counsel for the plaintiff pressed for time to file affidavit in reply to the affidavit in opposition filed by the defendant number 10. Let affidavit in reply be filed within a week from date. Full stop.
But could it only be till Monday week, my lord?
List the matter within a week from date. List the matter on the commercial matter.
Yes.
Yes, Lordship.
9th of December 2024 at the top for under the heading new motion.
My lord, GA number 2 fixed on 6th December.
But one other direction, my lord, so far as the defendant numbers 11 and 12 are concerned, they had served the affidavit in opposition.
But they are not filed. What can be done? You prepare it.
I'll prepare and serve on them.
Serve it.
And one thing, my lord, the interim order is still today. Kindly
Police
explain.
counsel for the plaintiff submit that the interim order is going to be expired today and placed for extension of the interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 13th of December 2024 or until further order, whichever is earlier. Yes. Come on,
Great.
6,
I'm
come on,
great.
9.
I'm grateful.
My lord, may I be permitted to mention, my lord?
The matter item number 35 of today's test, my lord,
Ah.
is fixed for witness action.
Ah.
So, my lord, if date and time can be fixed, I'll
Item number 35. Who is for the other side?
on the other side. I'll write down the
क्या order हुआ?
of the non-commercial list, non-commercial.
Non-commercial.
This suit, my lord. Is a testamentary suit.
Ah.
It was fixed for plaintiff's witness
Okay,
action.
you mention on the non-commercial day. I will fix it.
My lord, may I be permitted to mention, my lord, two suits, my lord, for extension of interim order. My lord, both are expiring today, my lord. They're not in the list. I had mentioned priorly, my lord. My lord, the orders-
My lord, I'm opposing one of them. It's a
Yes,
testament
my lord.
suit. It was supposed
My
to be
lord, it's expiring today, my lord. It's not in the list.
it was supposed to be listed on 4th of November. I'm opposing Mr. Mukherjee. From 4th of November, they have not taken any steps for getting
My
the
lord,
matter
this-
listed. And today at the last day.
Which one?
Mr. Shorkar, this is probably the other matter, my lord, is looking at. My lord, this is a commercial suit, my lord, which is not in the list.
Ah.
My lord, this was taken up on Tuesday last, my lord, item 9. My lord has passed an order, my lord,
You
adjourning the
directly
matter.
tell me when the order is going. Which order?
Today, my lord. Malad, this order, Malad, the interim order is expiring today. 29th November is the date.
Where is the date? Where is the which
Malad,
order?
see
By
the
which order?
last. Malad, this is the order, the last order of 4th October 2024. Malad, 4th October 2024.
This, no? So appearing for the plaintiff. Police, the plaintiff has mentioned the matter. This one, take this. Mentioned the matter and submitted that the interim order granted earlier is going to expire today and paid for extension of the interim order. And this is not in the list.
Malad is coming up in the second week of December. Malad has already adjourned it. Only Malad will.
In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended. When? What is the date? Second week of
Malad 16 December, if I am not wrong. 16 December.
Matter is interim order is extended till 20th December 2024 or until whatever is earlier. Leave the matter on 16th of December 2024. Yes, next.
Malad, another testamentary suit, Malad, where 1st October 2024 is the order.
The order where testament is.
Your Lordship, I am
Malad, it's being
opposing
handed over. It's being handed over. 1st October 2024, Malad.
On 4th of November, for 1 month, they sleep on the issue.
Malad, pleadings are complete, Malad. We've served upon them.
No, they
are suffering for the defendant number 2. Counsel for the plaintiff prays for extension of time on the ground.
Your Lordship.
Malad, I am the defendant number 2. Malad, I am the defendant in this matter. I am the petitioner in the GA. I have obtained it.
Sensation suffering for the plaintiff, sensation suffering for the defendant number 2. Counsel for the defendant number 2 prays for extension of the time on the ground that the interim order granted earlier is going to be expired today. Counsel for the plaintiff raised.
No, I am for the defendant number 1.
Counsel for the defendant number 1 and defendant number 2. Plaintiff mat karo. Sensation suffering for the plaintiff number 1, defendant number 1. And sensation suffering for the defendant number 2. Counsel for the defendant number 2 prays for extension of time to interim order on the ground that interim order granted earlier is going to be expired today. Counsel for the defendant number 1 raised objection and submitted that the plaintiff is enjoying the interim order and not taking. The defendant number 2 is enjoying the interim order and not taking any steps for proceeding with the matter. Considering the submission made by the counsel for the respective parties, the interim order granted earlier is extended till 18th of December 2024. Let the matter appear on 18th of December.
If your Lordship may appear 15th or 16th, actually Mr. Ritobroto Mitra is leading me.
15, 16 is the Friday, Saturday, Sunday. On 18 is the Friday.
Or the Wednesday before, any day, Thursday before that, 14th.
Or 12th of December.
12th, Lordship.
Extended. Let the matter appear on 12th.
12th, Lordship.